Hey guys, I got a ton of videos yesterday, so I downloaded them all, and as I'm going through them, some of them are absolute gold. So I was told that I could not do an AI video, I could not do a fake voice video, I had to do a live video. Although a hands video was suggested after Brittany, we decided that that was probably not the best thing to do. So the pups and I decided we were going to bring you some videos to get these wiped off because there are so many of them. There's probably a week's worth of content. And then while I was setting up the camera, they decided they were too tired. But Penny will say hi to get us kicked off to give you a little taste of what it's like in Florida.
Good morning, folks. My name is Kurt Hitzman, County Court Judge here in Hernando County. You folks are here for your first appearance. Purpose of the first appearance is so that you may be informed of the charges against you. I'll determine if there's probable cause for those charges. Probable cause simply means it's more likely than not that a crime has occurred. More likely than not, you're the person who committed that crime. But of course, as you stand before me this morning, I presume that you're innocent of these allegations. That presumption of innocence will stay with you through every stage of the proceedings, unless and until the state attorney's office is able to prove the charges against you beyond and to the exclusion of a reasonable doubt. We'll set your conditions of pretrial release this afternoon. That is your bail. This morning, that is your bail or your bond. In most cases, you've got a bond set already pursuant to the bond schedule here in the 5th Judicial Circuit, or the warrant which led to your arrest. I'll determine if that bond should be raised or lowered or left the same, or whether there'll be additional conditions of pretrial release placed upon you. We'll let you know when your next court date will be. If you'd like to have the services of the public defender, I'll gladly appoint the PD to represent you this morning. You do have a right to have contact with folks on the outside, family, friends, counsel. Finally, and most importantly, you're advised that you do have an absolute right to remain silent with regard to the facts which surround your arrest. I encourage you to do that. These proceedings are recorded. In addition, there is an assistant state attorney in the courtroom with me. If you say something that tends to incriminate you, they will use it against you in the prosecution down the road. I now need each and every one of you there at the jail to please raise your right hands and be sworn. You all solemnly swear, affirm, tell the truth, whole truth, nothing but the truth. Outstanding. When you hear your name called, you can step forward to the podium. Damian Beard. Morning, sir. What's your date of birth?
12/18/01.
Damian, you're here on a warrant signed by Judge Toner. He found probable cause for violation of probation. As to that charge, you're going to represent yourself. You're going to have hire private counsel. Would you like me to appoint the public defender?
Myself.
All right. Bond on that warrant is no bond. I can't change that, Damian. I'll send you back to see Judge Toner on the 15th of December, all right?
Okay.
Thank you. Jerry Bowen. Morning, Jerry. What's your date of birth?
2/27/57.
Jerry, you're here on a charge of a warrant signed by Judge Merritt. He found probable cause for a violation of probation. As to that charge, you're going to represent yourself. You're going to hire private counsel. Would you like me to appoint the public defender?
I'll represent myself right now.
All right. Bond on that warrant is no bond. We'll have you back in front of Judge Merritt on the 20th of December. They told you the 15th. The right date, I think, is the 20th, all right?
Can I ask the court for a hardship? My other half cannot take care of herself.
So Penny was slightly concerned that y'all might not know what my other half is. And here in Florida, that means the person you live with. You may or may not be married. You may or may not have dated. You may or may not have any kind of relationship at all. There could be kids. There could not be kids. There could be grandkids with no kids or grandkids with kids. There's no telling. But you live in the same house most of the time, not all the time. It doesn't have to be a house. It could be a trailer, RV, car, sleeping bag. It could be anything as long as you sleep within probably about 100 feet of each other. And that happens most of the time when you're not fighting. That would be your other half.
Okay. I can't, on a circuit court warrant, Jerry, I can't change the bond at first appearance. You have to get to Judge Merritt to get the bond changed. All right. Thank you. Grover McAllister. Morning, Grover. What's your date of birth?
9162.
Grover, I got 2 charges, retail theft and trespass. There's probable cause for those charges. As to those charges, you're going to represent yourself. You're going to hire private counsel. Would you like the public defender?
No problem. Anyway, I can on
I'll appoint the public defender, Steve.
I listened to that about 5 or 6 times, enhanced the audio, and the only thing I could hear him say was no problem. So, do you want 1, 2, or 3? No problem. Sounds good.
Beginning in 1983, grand theft, burglary, violation of probation, burglary of a conveyance, 85, resisting with violence, aggravated battery on law enforcement, burglary of a conveyance, grand theft, violation of probation resulting in a prison sentence. 1986, L&P. 88, burglary of conveyance, grand theft auto, burglary of a structure, grand theft, another VOP, more prison. 1990, escape, back to prison. 91, burglary of a structure, grand theft, burglary of conveyance, burglary of a dwelling, DSP, back to prison. 2019, felony petty.
All right, Grover, I got an address for you on Cheyenne Pass in Brooksville. Is that where you live?
No, I live in my nephew's house.
Okay,
what's the
what's the address of where you live?
I know it's top of the hill, back to it.
Okay.
Is that down that dirt road?
All right, Grover, I'll set you bond at $500 on each count. That's a total of $1,000. I'm going to have you back in court on December 14th. If you get out, you should go see the public defender. If you can't get out, they'll come see you at the jail, okay?
I got.
In case you were worried, Grover got out less than a week later, and the mail sent to his address was returned undeliverable. So apparently my sister's house is not a valid address.
Thank you, Grover. Elyard Randolph? Want to start date of birth?
8/11/83.
Elyard, I got 2 things today. I've got a warrant signed by Judge Merritt, and then we have for a violation of probation, and then a warrant signed by Judge Vergara. She found probable cause for a burglary of a conveyance with a battery. As to those charges, you're going to represent yourself. You're going to hire private counsel. Would you like the public defender?
Public defender.
I'll appoint the PD. The bond on the VOP, of course, is no bond. I'll have you back on that on the 20th of December. On the burglary, I'm going to set the bond at $15,000 with the condition that you not have any contact with Andrea Randolph. In that case, for you, it means not calling her or writing her from the jail. I'll send that one also back to the 20th of December. Public defender will come see you at the jail before you go to court, okay?
Sure.
Andrew Witzel. Morning, Andrew, date of birth?
1/12/70.
All right. So state the first charge here says possession of weapon by felon, and it was a set of brass knuckles in a car. And my recollection of that statute is that it relates to guns and ammo and electric weapons. And
I believe you're right, Your Honor.
okay. So Andrew on the.
So this is Roxy, and Roxy decided to come visit. Yes, I live with the zoo. Roxy's very grouchy, but Roxy also knows a lot about weapons. And I was a little interested when he said that brass knuckles weren't considered a concealed weapon. So I pulled up the statute just to see, because I had always thought that those were, but it has been a couple of years since I took my concealed carry class. And I would feel better if someone who actually passed the bar would weigh in on this, but it does say, let's see, what does it say here? It says, like he said, in their care or custody, a firearm, ammunition, electric weapon or device like tear gas, or to carry a concealed weapon, and concealed weapon is there individually. But then, if you look on, it does say the definition of concealed weapon means a dirk, which I'm sure has something to do with swords that Runkle would know about and be able to educate me about, because that sounds very medieval. Or metallic knuckles, which I'm pretty sure is brass knuckles. So brass knuckles are considered a concealed weapon if they are not in the ordinary sight of another person. From the way I'm reading it, but consult with a lawyer. Right, Rock? Exactly.
First charge, which is felon in possession, I'll find there's no probable cause. As to the other 4 charges, there is probable cause. So as to those charges, you want to represent yourself, or you want to hire private counsel, would you like the public defender?
Public defender, sir.
I'll appoint the PD. State.
2002, felony drugs. 2011, false info to pawn, which resulted in a VOP and a failure to appear that same year. 2016, DSP ×5 with an FTA, and 2020 FTA.
Andrew, I've got an address for you on Gopher Hills Lane in Hudson. Is that where you live?
Yes, sir.
How long you been there?
10, 15 years at least.
And are you working these days?
I'm sorry, sir.
Are you working?
I get disability from the VA.
Okay. All right, so on the first count, which is the felon in possession, that's ROR. On the meth, it's 2,000. On the hash, it's 2,000. And then on the 3 misdemeanors, 500 each. So that's going to be a total of 5,500. I'll have you back in court on the 15th of December. Very important that you contact the public defender when you get out, okay?
Yes, sir.
Very good. And then we have afternoon, Crystal, date of birth.
11/29/86.
Crystal, the charge is felony domestic battery by strangulation. There's probable cause for the charge. As to that charge, you're going to represent yourself. You're going to hire private counsel. Would you like the public defender?
Public defender, I guess.
All right, I'll appoint the PD. Steve.
Defendant has a withhold of adjudication for a 2019 possession of marijuana and paraphernalia and a driving while license suspended, a 2008 withhold for grand theft, and a 2007 withhold for possession of marijuana.
Very good. All right. And Crystal, I have an address for you at 429 Stafford Avenue in Brooksville. Is that where you live?
Yes, sir.
How long have you lived there?
Quite a while.
Okay. Are you working
5
these days?
years.
Are you working these days?
No, I go to school.
Okay. I'm going to set your bond at $2,000. Condition of the bond is that you'll have no contact with Ms. Huff while this charge is pending. No contact means no contact of any kind. You don't call, you don't write, you don't email, you don't text message, don't contact her through social media, don't go where she lives, don't go where she works, you don't have any contact of any kind.
Stay out of Fulton County.
Any way that you might imagine contacting her, I forbid you to do that. If you have contact and we find out about it, your bond can be revoked and you can be held without bond until the charges are resolved. It means no contact even if she wants the contact. So if you answer your phone and hear her voice, you should hang up. If you're out and about and see her, you should turn around and run the other way. You need to understand that she cannot drop the charges against you. That's not a decision she gets to make. She may go to the state attorney's office and ask them to drop the charges. She may tell them she's not interested in pursuing this matter, but that decision belongs solely to the assistant state attorney handling your case. So unless that person or the judge on your case or your lawyer tell you the charges are dropped, you should assume they are not dropped and you should not have contact. In addition, I have to hold you this afternoon until 4 p.m. so that if she wanted to serve you with a civil injunction for protection against domestic violence, we'd know where to find you. If you get the civil injunction, it's doubly important you not have contact, because in that case, not only would you get your bond revoked here, but you'd get new charges for violating the injunction. Were you and Ms. Huff living together, Crystal?
She was staying with me. She's homeless. She lives in her car or whatever, so she was staying with me. I honestly didn't do anything to her.
Well, I presume you're innocent, Crystal. That's what this is about. So is she like in your home or in an RV on the home? I wasn't sure when I was reading it.
Yeah, she was sleeping on a couch in my RV. Yeah.
Okay. Okay, is the RV separate from the house, or is that what the house is?
It's my house. My aunt lives in front.
Okay. All right, well, so I don't know where she's going, but be advised that, of course, I've ordered you not to have contact with you. So if she's there, you'll have to find someplace else, okay? You understand?
I do.
All right.
I think she understands just fine. She's just pissed. You let someone in off the street, you give them a place to stay, and then you end up in jail while they're sleeping on your couch still. Actually, at this point, she's probably sleeping in the bed. I'm pretty sure she's in the bed. Wonder if she washed the sheets first.
And in that case, you could go by to pick up clothes, toothbrush, whatever you need for wherever you plan to go. To do that, you've got to contact the sheriff's office first. They'd arrange to meet you there. Stand by while you got your things and got going where you're going. I'll have you back in court on December 6th. Very, very important in your case that you contact the public defender when you get out, okay?
Yes, sir.
Thank you. Amanda Mackenberg? Afternoon, Amanda, date of birth?
5/1985.
Man, I have a warrant for you out of Hillsborough County. Judge down there thinks you failed to appear on a misdemeanor charge. Looks like driving on a suspended license. That judge set your bond at $1,000. I don't have any authority to change that, Amanda. If you can post a bond, you can get out of jail here, go down to Tampa, find out when they want you in court. If you're unable to post the bond, we'll notify the folks in Hillsborough County immediately, and they'd have 5 days to come and pick you up, okay?
Yes, sir. My parents should have probably already posted.
Very good.
Thank
Thanks, Amanda.
Yeah. Thank you.
Cody Gray? Afternoon, Cody, date of birth?
04/07/1990.
Cody, the charge driving under the influence, there's probable cause for that charge. As to that charge, you're going to represent yourself. You're going to hire private counsel. Would you like me to appoint the public defender?
Public defenders.
I'll appoint the PD, state.
Defendant has an adjudication of guilt for leaving the scene of a crash with property damage in 2016, a trespass and disorderly conduct, and a withhold on another trespass. 2011, opposing law enforcement without violence, adjudication of guilt, and a withhold on a trespass after warning. 2010, resisting law enforcement without violence, adjudication of guilt, and a disorderly, and a 2008 possession of alcohol under 21, for which he got pretrial intervention.
Cody, I have an address for you on Cumberland Lane. Is that where you live?
Yes, sir.
How long you been there?
Pretty much my whole life.
You working these days?
Yes, sir.
What do you do?
I work for a general contractor.
Okay. Cody, I'll set your bond at $500. I'm going to have you back in court on December 12th. Very important that you go see the public defender when you get out, all right?
Yes, sir.
Thank you. Jeremy Simons? Afternoon, sir. What's your date of birth?
8589.
Jeremy got 3 charges. I've got an ag assault, a criminal mischief, and a battery. There's probable cause for those charges. As to those charges, you wish to represent yourself. You're going to hire private counsel. Would you like the public defender?
Well, I guess.
Appoint the PD, state.
Defendant has in 2021 adjudication of guilt for possession of paraphernalia. 2020, he has 3 adjudications of guilt for possession of controlled substance and 1 adjudication of guilt for possession of paraphernalia. 2019, petty theft. 2015, no valid license. 2010, DUI, no motor vehicle license, leaving the scene of an accident. These are all guilt adjudications. 2008, grand theft, less than $5,000, burglary of a structure, and adult permits under 16-year-old to possess a weapon.
Jeremy, any place in particular you've been staying lately? Are you living outdoors? What's going on?
I'm living outdoors, sir.
I think I thought of a name for the channel. I think I'm going to call it Crime and Crafts. We're going to listen to people's crimes while I finish my crafts. Because I can multitask like that. That one though, that one was kind of harsh. But for those of us who live in Florida, it's kind of a thing. Homelessness is a major issue in this area, and people are able to live outside year round because there's maybe a week, 2 at the most. I would say probably less than 5 days out of the year where it gets to be in the lower 20s if you're going from like mid-Florida down. And actually you get down halfway through Florida and it doesn't even get that cold. So it really isn't harsh for the majority of the time. And so if the homeless population sets up camps in very populated areas like Tampa, which they do, or St. Pete, they've been run out continuously. So they've started migrating further away from the big cities and out into the country, I guess is what you call it. And there's huge parcels of land that have lots of actual natural resources on them where they're able to survive and have space, and it's not so dirty and crowded and you're not on concrete. And they set up camps. They have tent cities. There's actually a very large camp out in the woods off the main road where the teenage runaways go. And when there is a juvenile who is missing, that's the first place the cops go to check for him. It's sad, but it's reality, unfortunately.
All right. Are you working at all?
Yes, sir.
Okay, what kind of work are you doing?
I still do lawn care, sir. Superior lawns.
Okay. I'm gonna leave your bonds, per the schedule, which is $2,000 on the ag assault, $1,000 on the misdemeanors. Order you not to go back to that Wendy's while this case is pending, or to have any, contact with Miss Emmerich. We'll have you back in court on the 6th of December. If you get out, it's very important that you contact the public defender. If you can't get out, they'll come see you before you go to court again, okay?
Sure.
Thank you.
Yes, sir.
Joseph Wilkerson. Afternoon, sir. What's your date of birth?
4/11/83, sir.
Joe, I've got 5 charges today. I've got a false imprisonment, a felony domestic battery by strangulation, witness tampering, domestic battery, and resisting without. There's probable cause for those charges. As to those charges, you're going to represent yourself. You're going to hire private counsel. Would you like the public defender?
Public defender, please,
I'll
sir.
appoint the PD. State.
Defendant has this year open in Pasco County a driving while license suspended and a DUI. He has open in Hernando County a driving while license suspended. He has in 2018 an adjudication of guilt on a petty theft and a battery. 2016 adjudication of guilt on a battery, carrying a concealed weapon, driving while license suspended. 2015 adjudication on possession of marijuana, possession of paraphernalia. 2015, carrying a concealed weapon. 2012, possession of marijuana, less than 20 grams. 2007, armed robbery, grand theft, resisting or obstructing officer without violence, retail theft. 2005, he has an disorderly intoxication. In 2004, he has a driving while license suspended or revoked.
Excuse me, can I correct one of those? It was actually a strong armed robbery, not an armed robbery.
Okay. And
Big
Joe,
difference.
I have an address for you on Blandon Street in Spring Hill. Is that where you live?
Bladen Street, yes, sir.
All right. How long have you been there?
I don't know, about 8 months now, sir.
And does Miss Nunez live there as well?
Yes, sir. I don't think she lives there anymore.
Okay. Do you have a job these days?
No, sir.
How long has it been since you worked?
Since I wrecked my truck and got my last driving on suspended license.
All right. I'm going to set your bond on the false imprisonment and the felony domestic battery at $5,000 each, on the tampering at $2,000, the 2 misdemeanors of $1,000. That's a total of $14,000. Condition of the bond is that you have no contact with Miss Nunez. Did you hear me explain no contact earlier?
Yes, sir. Yes, sir.
All right. Then the other thing, Joe, is it appears that you have an open case, 22 CT 2325. Job number 1 when you're out on bond on a charge like that is don't pick up new charges. It appears to me that you have. So pursuant to Florida Statute 903.0471, I'm going to revoke your bond in that case. We'll hold you without bond for a couple of weeks until that comes back on the 28th. My guess is we'll get that case resolved on the 28th, and then you'll be able to bond out on the other charges. The other charges are coming back on the 6th of December. When you do get out, very important that you see the public defender, okay?
Okay, thank you.
Thank you. Thanks, Joe.
Thanks, Your Honor.
Morning, Mabel. What's your date of birth?
10/8/1990.
Mabel, the charge is battery being domestic in nature. There's probable cause for the charge. As to that charge, you're going to represent yourself. You're going to hire private counsel. Would you like the public defender?
I'd like a public defender.
I'll point the PD. Hang on, Mabel. State any significant history.
2019 DUI.
Okay. And Mabel, you live on Linden Drive, is that right?
Yes, sir.
And how long have you lived there?
Since August.
Okay.
Or July or August.
All right. And James lives there too?
Yes, sir.
Okay. Are you working these days, Mabel?
I'm not. I'm
Okay.
currently employed.
All right. Do you guys have children?
None that live at the home with us.
Okay. All right, Mabel, I'm going to set your bond at $10. Condition of the bond is that if you and Jim are going to continue to have contact, it has to be peaceful contact. That means no yelling, no fighting, no obviously touching each other in a way that you don't want to be touched. Do you understand that?
Yes, sir.
Okay, it's going to be the same thing for him in a minute here too. If the police are called, both of you could find yourselves back in jail on no bond until the cases are resolved. So I mean it, no fussing and fighting, all right?
Apparently, fussin' and fightin' is a legal definition here in Florida.
Sir.
All right. I have you back in court on the 14th of December, Mabel. Make sure you check in with the PD when you get out, all right?
Okay, thank you.
Thank you. James Heinecker?
Yes,
Run James' date of birth.
2/22/1964.
James also charged of battery being domestic in nature. There's probable cause for the charge. As to that charge, you're going to represent yourself. You're going to hire private counsel. Would you like the public defender?
Public defender.
All right. And state?
2003 misdemeanor battery. 1996 violation of parole. 1989 felony false application for a driver's license.
So, Jim, same thing. I'm going to set the bond at $10. If you and Mabel are having contact, it has to be peaceful. You understand all that, right?
Yeah.
All right. Also have you back on the 14th of December. You shall also go see the PD if you get out, okay?
Okay.
Thank you.
Thank you.
Cheryl English? Want to name me what's your date of birth?
9/19/1997.
All right, Amy, I have, first of all, I have a warrant out of Pasco County, judge down there. Thinks you failed to appear on some charges. Looks like controlled substance, marijuana, and paraphernalia. That judge set your bond on the FTA at no bond. I can't change that. Then we have local charges of possession of methamphetamine and possession of drug paraphernalia. There's probable cause for those. As to those charges, you want to represent yourself. You're going to hire private counsel. Would you like the public defender?
A public defender.
I'll appoint the PD. So I'll set your bond on those at $2,000 each, Amy, for a total of 4. Those are coming back December 6th. The bond on your Pasco warrant is no bond. If you post the bond on the local charges, then Pasco will come and pick you up so you can deal with those charges in Pasco County. If you can't post the bond on the local charges, then you'll stay here till those charges get resolved, and then you'll go to Pasco.
So I thought that was an interesting explanation of inter-county transfers and extradition. Pasco County is a neighboring county to Hernando where this is taking place. So the first one, which I think was a couple guys back, they told him that he could post the bond, or maybe it was a her, post the bond here and then drive down to Hillsborough in Tampa and take care of it herself. But because this one had a no bond, she had to take care of everything here. And then Pasco has 5 days to come and pick them up. And I'm not sure where the 5 days came from, but on another stream, I heard them arguing over why he had to stay for 5 days. I think that one's coming up at some point. But so they have to sit there for 5 days and wait for Pasco to drive. I think it's about 15 minutes between the two jails to come pick them up, to take them to answer for their charges in the other county. So.
Good morning, ma'am.
Hi, how are you?
I'm doing well, thank you. May I please have your date of birth?
7/26/84.
Thank you so much. I have a battery charge for you this morning. There is probable cause. Are you going to represent yourself? hire a private attorney, or would you like the services of the Office of the Public Defender?
Public defender.
Yes, ma'am, I'll appoint the public defender to represent you.
Your Honor, she's got a shooting or throwing a deadly missile charge from 2020 adjudication, a possession of a firearm by a convicted felon from 2020 adjudication, a criminal mischief from 2020, and then a false name to Leo from '08.
Miss Flemings, I have an address for you on Veracruz Drive in Jacksonville.
Yes, ma'am.
Is that a good address for you?
Yes, ma'am.
Do you have family in this area?
No, ma'am.
Are you currently working?
I was working.
What were you doing?
I worked at Subway on Mariner
How long have you lived in Hernando County?
for about a month.
I'm going to set your bond at $1,000. A condition of that bond is that you're going to have no contact with the alleged victim, Miss Marcia Stewart. No contact means no contact of any kind. You can't call, you can't write, you can't email, you can't text message, you can't have third-party contact, you can't have contact through social media, you can't go where they live and where they work. If you have contact with the alleged victim and the court finds out about it, the court could revoke your bond and you could be held without bond until the charges are resolved. Did you understand that?
Yes, ma'am.
Your next court date is going to be January 6th at 9 a.m. in courtroom B.
Thank you.
Thank you. Thank you. Ms. Hine? Good morning, ma'am.
Good morning.
May I please have your date of birth?
January 26, 1970.
Thank you so much. I have 3 charges for you this morning: retail theft, possession of a controlled substance, and possession of drug paraphernalia. There's probable cause for all 3 charges. Are you going to represent yourself, hire a private attorney, or would you like the services of the Office of the Public Defender?
Public defender, please.
Yes, ma'am. I'll appoint the Office of the Public Defender to represent you.
Your Honor, she's got controlled substance and paraphernalia from February of this year, theft from 2021, grand theft auto from 2020, uttering a forged check from 2015, illegal use of credit cards, dealing in stolen property from 2013 and 2012, false info to Leo, another petty theft, another theft of some sort, another theft of some sort. All of those range from 2012 down to 28, and then she's got 2 grand thefts from 2009, another theft from 2008, and then 5 worthless checks from 2007, a battery from 2001, and a burglary from 2001 as well.
Ms. Hine, do you live here in Hernando County?
I do.
And how long have you lived here in Hernando County?
For 4 months, 5 months.
Do you have family in the area?
No, they're all deceased.
Are you currently working?
I have my own business.
And what do you do?
I'm a paralegal.
Did she just say she's a paralegal? With that rap sheet. I need to process that one for a minute.
In personal injury law, and I was helping several attorneys do some demand letters and funding for trial cases that were ready for trial until I email you.
I'm gonna set your bond as to count 1 at $1,000. Gonna set your bond at count 2 at $2,000. And I'm gonna set your bond at count 3 at $1,000.
Okay.
Your next court date is going to be December 29th at 1:30 p.m. in courtroom E.
Thank you.
You're welcome.
Judge, you said December 29th?
Yes, ma'am. Miss Hundley?
Who?
Miss Hundley?
Yes.
Good morning, ma'am. May I please have your date of birth?
1/10/93.
Thank you so much. I have 2 charges for you this morning. Domestic battery by strangulation, as well as 1 count of battery that's domestic in nature. There's probable cause for those counts. You're going to represent yourself, hire a private attorney, like the services of the public defender.
Public defender.
Your Honor, I wasn't given an arrest affidavit for anybody by the name of Hundley, so just bear with me one moment while I pull her history up on CSIS.
Yes, ma'am.
I've never been in trouble.
I will appoint the office of the public defender to represent you. While you're looking that up.
Not as far as she doesn't have anything in CSIS, so unless she has anything out of state, if she represents that she's never been in trouble, I would agree with that.
Miss Hundley,
Yes.
do you currently live here in Hernando County?
Yes.
Okay. I have an address for you at the Hampton Inn.
No, that's where I used to work.
That's where you used to work?
Yeah.
Okay. And how long have you lived in Hernando County?
10 years.
And do you have family in the area?
Yes.
And are you currently working?
Yes.
What do you do?
I have 3 jobs. I work at Truly, Apollo Retail, and Premium Retail.
A condition of your bond is going to be no contact with the alleged victim.
Okay.
Did you understand no contact as I described it earlier?
Yes, ma'am.
Okay. And for you, also in addition to what I said earlier, I'm going to speak about if you did share a home with the victim, if you did, if read as though you lived together, you can go by that home one time to grab your clothes, but in order to do so, you must contact the sheriff's office first, and they'll arrange a time to meet you there with the deputy so you can grab your belongings.
Okay.
I'm also going to hold you till 4 p.m. today in case the alleged victim wants to serve you with an injunction for protection against domestic violence, and that's just so where we know to find you up to 4 o'clock today. If you get that civil injunction, it is doubly important not to have contact, because in that case, not only would you get your bond revoked here, you could possibly get new charges for violating that injunction.
Okay.
It's also important to know that it means no contact even if that person wants the contact. So for example, if you pick up the phone and you hear their voice, you should hang up. If you're out and about and you see them, you should walk the other way. And it is also important to know that the victim does not have the ability to drop charges, as that function rests solely with the Office of the State Attorney.
Okay.
I'm going to set your bond as to count 1 at $1,000, and I'm going to set your bond as to count 2 at $250.
Okay.
Again, no contact with the victim. We're going to hold you till 4 p.m. Your next court date is going to be December 29th at 9 a.m. in courtroom E.
Okay.
Okay, thank you so much.
Thank you.
You're welcome. Mr. Marlot? May I please have your date of birth?
August 22nd, 1994.
Thank you so much. So I have a fugitive from justice. There you have a, looks like a warrant out of Georgia.
Yes, ma'am.
And so you have some options this morning. Let me discuss that with you. So on this, you're entitled to an extradition hearing if you'd like. And that extradition hearing would be to determine if there's a valid warrant and if you're the right person. While you're waiting for the process to happen, you would wait in the jail here in Hernando County, and that process can take up to 60 days. If we conclude at that hearing and find out that you're the right person and that Georgia does have a warrant, then they will have 15 days from that point to come and get you. You may waive that right to an extradition hearing this morning if you would like, and if you waive your right to the hearing, Georgia will be notified immediately and told that they have 15 days to come and get you. So the question I need to ask you is, would you like the extradition hearing, or would you like to put Georgia on the clock today?
May I respond to the question first?
Yes.
I was under the impression that Florida doesn't extradite on misdemeanors.
That warrant is out of Georgia, and that would be up to Georgia and what they do.
Okay. Then I'd like to go ahead and waive that right and get the clock ticking.
Okay, excellent. I do believe that the jail has a form that you can sign. Mr. Edward Lasco. Good afternoon, sir.
Good afternoon.
May I please have your date of birth?
6/18/65.
Yes, sir. I have a charge for you today of knowingly driving while license canceled, suspended, or revoked. There is probable cause for that charge. You're going to represent yourself. Hire a private attorney. Would you like the services of the public defender?
I'll hire a private attorney.
Yes, sir.
Judge, just to let you know, there is an offer from the state of time served on this.
Yes.
So, Mr. Lasco, the state attorney has indicated if you would like to resolve your charge this afternoon, that your offer is an adjudication and credit time served and be
Yes,
assessed
that's fine.
standard fine and court costs.
That's fine.
Is that something you'd like to do today?
Yes.
Okay. You understand that by entering a plea, you are waiving your right to have a trial by jury to confront the witnesses against you and the right to remain silent, and you're giving up those rights to take care of it with this plea today?
Yes.
And in this case, to the charge of knowingly driving while license canceled, suspended, or revoked, how do you wish to plea? You may plea no contest.
Yes, no contest.
I'll find that your no contest plea is freely and voluntarily made. I will adjudicate you guilty, sentence you to 2 days in the Hernando County Jail with 2 days credit for time served, assess the standard fine and court costs, as well as the cost of prosecution and cost of incarceration. And Madam Clerk, may I please have those fees, fines, and costs? Thank you so much. It's $550. Okay?
Yes.
Okay. Thank you so much.
All right, thank you.
Mr. Richards? Good afternoon, sir. May I please have your date of birth?
6/26/93.
Thank you so much. I have 2 charges for you today: possession of a controlled substance and possession of drug paraphernalia. There's probable cause for those charges. You're going to represent yourself. Hire a private attorney. Would you like the services of the Office of the Public Defender?
Public defender.
I'll appoint the public defender to represent you?
He had a battery by strangulation. He was adjudicated guilty on February 16, 2021, and he took 14 months DOC, so he just recently got out. An adjudication for a battery in 2020, a petty theft adjudication in 2017, a purchase of cocaine adjudication in 17, no other history.
Thank you. Mr. Richards, I have an address for you on Bentley Avenue.
Yes, ma'am.
Is that a good address for you?
Yes.
And how long have you lived there?
8 years.
Do you have family in the area?
I do.
Are you currently working?
Yes, I was.
What were you? Landscaping. I'm going to set your bond at count 1 at $2,000. Set your bond at count 2 at $1,000. Your court date is going to be December 29th at 1:30 p.m. in courtroom E.
Alright, so what was the total bond again? 10% or what? $3,000. Alright, thank you, ma'am.
You're welcome. Thank you. Mr. Dillard? Good afternoon, sir.
Good afternoon.
May I please have your date of birth?
040702.
Thank you so much. I have a charge for you today of conspiracy to commit aggravated battery with a firearm. There's probable cause for that charge. Are you going to represent yourself, hire a private attorney, or would you like the services of the Office of the Public Defender?
Private attorney.
Yes, sir.
Yes, Your Honor. He currently has a open case. We're asking for the new case to be tracked with 22 CF 404, 22 CF 852, 22 CF 1632 that were reopened. He was on probation, and we're asking for that to be set for 12/29. His criminal history. Is a no motor vehicle registration, withhold 2022, a withhold on a possession of paraphernalia 2022, and a withhold for a sale of a controlled substance in 2022, which is the cases that are currently open.
Are those violations?
Yeah, they're reopened.
Okay. And Mr. Dillard, I have an address for you on Twin Oaks Road in Spring Hill.
Yeah.
Is that a good address?
Yeah.
How long have you lived there?
10 years.
Do you have family in the area?
Yes, ma'am.
And whom does that family include?
Mother and father.
Are you currently working?
No.
I'm going to set your bond at $30,000. And your next court date is going to be December 29th at 1:30 p.m. in courtroom E. I do understand that his next court date in Judge Toner's is January 25th. However, I don't want to put him out almost 60 days, so I would like to keep him on December 29th at 1:30 p.m. Thank you.
Hey.
Thank you. Mr. Sasco?
Good afternoon, Your Honor.
Good afternoon, sir. May I please have your date of birth?
06/09/1980.
Thank you so much. I have several matters for you this afternoon. In the first case, there is a sale of a controlled substance, possession of a controlled substance with intent to sell, possession of a police structure or conveyance for the sale or trafficking of a controlled substance, unlawful use of a two-way communications device, and possession of paraphernalia. There is probable cause for those charges. I also have another case in which there is sale of a fraudulent controlled substance and unlawful use of a two-way communications device. There's probable cause for those charges as well. And there's also another case for the sale of a fraudulent controlled substance. There's probable cause for that charge as well. In these matters, are you going to represent yourself, hire a private attorney, or would
I just wanted to make sure you caught the fact that he got busted for selling both the real and the fake shit.
you like the services of the Office of the Public Defender in all of your matters?
I need a public defender at the moment.
Yes, sir. I'll appoint the public defender to represent you.
A trespass adjudication in 2020, a adjudication in 2020 for paraphernalia, a petty theft adjudication in 2020, an adjudication for a possession of a controlled substance in 2020, a Willis adjudication in 2018, a fraud, impersonate, false ID given to Leo adjudication in 2018, a possession of paraphernalia adjudication in 2018, a possession of controlled substances adjudication in 2018, a paraphernalia adjudication in 2018, a engage in public fraud adjudication in 2018, a Willis adjudication withheld in 2018, and no other history.
Thank you. Mr. Sasco, I have an address for you on Lowell Avenue.
At the moment, yes.
And how long have you lived there? Are you currently working?
Yes, ma'am.
And what do you do?
I work for myself. I do home remodeling and air conditioning of 15 years. Emergency verification.
Oh, no, I don't have any objection.
I'm going to keep your bonds pursuant to the schedule. As to the sale of a controlled substance, I'll set your bond at the $5,000. As to the possession of a controlled substance with intent to sell, $5,000. As to the possession of a police, I'm going to set your bond at $2,000. As to the unlawful use of the two-way communication device, I'm going to set your bond at $2,000. And as to the paraphernalia, at $1,000. As to the sale of a fraudulent controlled substance, I'm going to set your bond at the $5,000. As to the unlawful use of the two-way communication device, I'm going to set your bond at $2,000. In regards to the charge of sale of a fraudulent controlled substance, I'm going to set your bond at $5,000. It's my understanding you may have had court today.
Yes, I had court this morning, and they told me I had court on December 29th at 1:30. I believe they're going to combine all my cases into one court date. To my knowledge.
We're actually, it's, the co-defendant is on the D docket in merit, and so I've been requested to ask for January 6, 2023 for Mr. Sasco and Ms. Adams.
January 6th?
Yes, in front of Judge Merritt, I believe.
Is that 9 a.m.?
Yes.
I'm going to set your court date at January 6th at 9 a.m. in courtroom D in all of your matters.
Okay, thank you.
You're welcome.
I hope you enjoyed your little taste of how we do things down here in Florida. It's not all sunny beaches and bikinis. It's a lot of backwoods and meth and domestic violence, unfortunately, but it's interesting nonetheless. Penny says it's been fun and she'll see you again next time. Hi, Penny. Tell him bye. Can you tell him bye? Be cute. Can you be cute and stop moving? No? No? You don't know how? Hey, everyone. The first clip that I have here is a little sad, but you should recognize the attorney on it. It's one of Judge Simpson's favorites, Miss Sydney. I think she was an intern there before she got the job working. I'm not sure about being an intern. She might have actually had a position there, but she went to work for a private firm, and now she's handling some landlord-tenant matters. And this one's a little difficult. There was a fire, and it sounds like he lost pretty much everything, but how it gets handled is what made it interesting to me. So I hope you enjoy.
Y'all solemnly swear affirm, tell truth, whole truth, nothing but the truth.
Good afternoon. This is file 7768 LT of 2022. And that is King's Court versus Patrick McGrath and other occupants of 2766 South Michael site 095. And let's see, we have Miss Fontanilla on behalf of King's Court, as well as it appears the property manager, Ms. Locker. And I also see Mr. McGrath on the line. Mr. McGrath, can you hear me okay?
Yes, sir.
Okay,
Yes, sir.
so I know there's been a breakout room, and has anything been resolved, Ms. Fontanilla?
Hi, Your Honor. So we did have a discussion. There's been some recent developments in this case since the last hearing that we appeared on. If I could advise the court of that.
Sure.
So a fire broke out at Mr. McGrath's home between the last hearing and this hearing. And since then, the home has become uninhabitable.
Okay.
So
yeah, go ahead.
I was just going to say, so because of that, we would be requesting a judgment and an immediate writ due to the health and safety concerns of the home.
Okay, Mr. McGrath, what's your response to that?
Your Honor, I've been, my boss will help me with a dump trailer to clean up the area. I understand that it's my responsibility. I will go there today and do the best I can as far as cleaning. I can bring a dump trailer up there today. I work.
All right, Mr. McGrath, let me interrupt you there, because my understanding is with this fire, the residence is uninhabitable. Are you still residing there?
Oh, no, Your Honor. I'm staying with my daughter or friends. My nephew last night.
Okay, well, as far as cleaning up the property, is there still a request? I mean, I know this started out, it was adjourned to give Mr. McGrath a chance to clean up, but at this point, is there any request for relief along those lines? Ms. Fontanilla?
So I think because of the health concerns we have, it would be ideal for there to be cleanup. However, we're not willing to give him very much time to do so, which is why we would be requesting the immediate written judgment.
Cindy and sir, I just was on the phone with Brian Belcher, the fire investigator, and he said that they did send somebody out last week and they were actually going to condemn it at that time, but they held off because Mr. McGrath had said something about trying to clean it up, but he said ultimately they were going to condemn it at that time last week.
Okay, well, there was no request for money damages in the first place. This was a complaint for possession. The circumstances have changed significantly, but given the stated what Mr. McGrath has said, I think that an immediate order of possession should issue so that any health and safety concerns can be resolved. If there are additional money damages for cleanup or whatever, those could be that could be the subject of a small claims action, and Mr. McGrath maybe can be given permission to help mitigate that if he wants to try to do some of the cleanup. But I think the important thing for today is granting the order of possession so that King's Court can get that taken care of, and no one's health or safety is going to be jeopardized. So Ms. Fontanella, if you'll prepare an appropriate order of possession, and that is immediate, given that the property is being condemned. And I do want to say to Mr. McGrath, I'm sorry about the unfortunate circumstances, and I hope that you're able to find another resident soon, and good luck to you. And I appreciate, I appreciate the information, Ms. Locker, and your being here today. Is there anything else for you, Ms. Fontanella?
Your Honor, I would just like some clarification. Is it okay if I submit a judgment marked by hearing and also submit an application in order of eviction? Is that acceptable?
Yes, that is.
Okay, thank you so much, Your Honor.
What's time you got? Your Honor.
Okay. Yeah, Mr. McGrath.
Well, I have at least a couple of days to get my what's left in there that's valuable. The ashes to my wife and son are in there. Pretty much everything. As far
I assume that you don't have a problem with him making that recovery of personal items so long as they haven't been completely destroyed. Ms. Locker, is that the case?
No, I have no problem with that. It'll take me a couple days to make arrangements to have it cleaned up and pulled out of there anyways.
Okay, and you'll provide those items to Mr. McGrath. If we could just put that in the order, particularly the ashes, I think that's very important. And so I guess one concern I have is I don't know if you want Mr. McGrath doing, going into the property himself. It sounds like it's a better idea to have someone, a professional, maybe going in and recovering those items, maybe your maintenance crew or something.
If he goes over there during the day, we can go with him. Either my maintenance staff or myself can go with him.
That would be perfect. And then Mr. McGrath will know what he wants to salvage, and So, all right, I appreciate that, and
I was
if you could,
also going to say, Your Honor, and to Kim and to Mr. McGrath, if you guys need to coordinate with the fire investigator, you are also more than welcome to do that in order for Mr. McGrath to get in there and to get his personal belongings out.
The fire investigator did release the home already. They're closed, so they're done with
Okay.
it. I just talked to him. That was part of the phone call.
Okay, perfect. Then yeah, Mr. McGrath, if you just want to coordinate with Kim and King's Court, then you can get those important belongings for you, okay?
Thank you.
all right, well, once again, good luck to you, Mr. McGrath. And thank you, Ms. Fontanella, and Ms. Locker. Feel free to sign off at this time.
Thank you, Your Honor. Good luck.
As sad as it is and hard to listen to, good for the judge for actually putting it in the order to make sure that he gets the ashes back for his wife and son. Poor guy. Hopefully he'll be okay and have a better start. So this next one is from Battleground, Washington. Oh, look, you disappeared. And I went through most of the stream thinking Battleground was in Michigan, and it's actually in Washington. But I really like this judge, and I thought this one was kind of interesting. Putting the judge in an interesting situation where he sees the woman doing something that's going to be very harmful to her down the road, but yet he's not able to do anything to stop it other than just walk that very tight line of not giving legal advice, but making sure she is fully aware of all of her options. So this is Judge Andrew Wheeler, Battleground, Washington.
I will tell you, I've done DUI defense, ma'am, for 22 years. I can think of one time in 22 years I pled someone guilty at arraignment. Can you tell me why we're doing a guilty plea today?
Sure. I had an opportunity to speak with Ms. Jimenez about a week ago. I was able to file the notice of appearance, obtain the police reports, review those police reports and all aspects of the case. Received a pretrial agreement offer from the prosecutor, which based upon a review of those police reports, I believe is more than sufficient. And the best outcome that Ms. Jimenez is going to receive in the case. For that reason, we'd like to proceed forward. In addition to that, she's a single mother with 2 small boys. And ultimately, if we can proceed forward today, it avoids her having to find childcare and so forth for those additional court dates. One, we believe that it will result in the same outcome.
And you pulled all of the Draeger information on the machine she took her test on and all of that.
The PBT and the grader are in line with each other, and this is a Washington State Patrol. I get them on a regular basis. And honestly, I have not seen a Washington State Patrol maintenance calibration issue in the 3 years I've been practicing in this county.
The breath test was at State Patrol?
Yes. I have the printout of the actual breath test for the electric copy.
She did her breath test in Battleground Police.
I understand, and it's on the Washington State Patrol documentation.
Okay. Ms. Jimenez, do you know that a DUI is a non-vacatable offense? Never comes off your record. Do you understand that this plea is going to result in a license suspension, 90 days, interlock for 1 year, SR 22 insurance for 3 years? Okay. All right. Are you asking for the conversion to home monitoring, or is she doing the jail day?
She'd like to do the 1 day of jail.
Okay, and you understand that's in Stevenson, Washington, ma'am, in Skamania County, where I'm going to send you?
That's what we do the 1 day.
Oh, okay, yeah.
All right, you are Jessica Jimenez. You said you were 29. You've gone through the 12th grade. Do you read and understand the English language, ma'am?
Yes.
Have you been able to go through your attorney says, your police reports and all the related information with him?
Yes.
Been able to have all your questions sufficiently answered?
Yes.
You need any additional time? Okay. You're giving up several important rights in entering your plea today. You have the right to a speedy and public trial by an impartial jury in the county where the crimes alleged to have been committed. The right to remain silent before and during the trial, and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and the witness can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt, or you enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. Do you understand those rights? You understand you're waiving and giving up all those rights?
Yes.
Okay. The charge which you are pleading to, as we stated, is a gross misdemeanor subject to 364 days in jail and a $5,000 fine. I'm holding up what is called a pretrial agreement. You understand the court does not have to follow anyone's agreement as to sentence, but can sentence you up to the maximum authorized by law. You'll be on probation for a time frame of 2 years, during which time the court can assess cost, fees, and assessments as authorized by law. And if you're not a U.S. citizen, a plea can result in immigration or deportation issues. I do see that box J on your plea form has been checked, indicating a mandatory 90-day license suspension. Do you understand that that cannot be waived or otherwise avoided?
Yes.
Okay. You may be eligible, though, for what is called an ignition interlock license. You were able to go over the attachment A with your attorney as well, ma'am, that talks about the mandatory minimums for the charge.
Yes.
Okay. You don't have a commercial driver's license, do you?
I do.
She does, Your Honor.
You understand the suspension ramifications to your CDL? Can you tell me what they are?
Mandatory 1 year.
Mhm. What happens to get your CDL back? You have to retest fully through the commercial licensing folks.
Right.
Do you use your CDL right now?
Yes, I'm a school bus driver.
Do you understand that with SR 22 insurance, you're not going to be employable using a CDL in the 3 years after this as well? Do you understand that there are ways around the SR 22 for CDL drivers?
Yeah, we'll go through all those issues with her.
There's something after the plea we're not going to do.
No, certainly I understand. I'm going to aid her with regards to all aspects of getting reinstated at the appropriate time.
I'm not going to argue legal strategy. I just want to make sure if she's a commercial driver and this is her viable livelihood. If you discussed with her deferred prosecution and the fact that that does not have an SR 22 consequence and is going to make her employable again sooner. Have you talked to her about that?
Yes, and if the court would like to take a pause and
Yeah,
then
you
pass
need
it,
to
I'll be
take a-
happy to go
yes.
through it with her again.
You need to take a pause and go through that.
Certainly.
Ma'am, I'm just watching out for you.
Appreciate it.
Okay. I mean, a year from now, when you're able to retest and everything, you're still not employable for 3 more years after that if there's an SR 22. Whereas if there's not an SR 22, you become at least much more attractive to a potential employer if you want to drive a bus again or have your CDL reinstated. Go talk to your attorney again.
We can re-review that, certainly.
Not from a legal aspect, from a general human aspect, good for the judge for really looking out for her. I have to say, I'm not super familiar with insurance law, but I do know what an SR 22 is, because this one time, before there was auto pay, I mailed my insurance payment a day late, which got there a day late, which meant the insurance got canceled, because back in the day, they didn't really give you much of a grace period. And of course, that was the day I got into my first accident. And of course, I rear-ended a Mercedes, and there wasn't a scratch on it. There was one little scratch on the bumper. And my car was totaled completely. But I had to pay for everything out of pocket. But I also had to have an SR22, which when I went to get a new car and new insurance, practically made me uninsurable as just a normal person. So I can only imagine with the CDL what that is. And with the new restrictions on bus drivers, and not just bus drivers, but school personnel to begin with, they already go through very rigorous background checks, looking at their driving history and things like that. I used to work for the school district and did some of the reviews for the programs. And they're very critical of anything in your driving history. So a DUI is difficult, but having an SR22, they would not be insurable under the school district's policy. So there would be no way that she would be able to get a job for all those years. And if that's her primary source of income, where's she gonna go? And when you're in a situation like that, you're so emotional, you're probably not thinking down the road what's gonna happen. You just want it to be over with so that you don't have to deal with it anymore. So I personally appreciate him going out on a limb and trying to make sure that she's understanding the consequences of the choices that she's making.
All right, ready to recall Ms. Jimenez? Mr. Nicholson, how does Ms. Jimenez want to proceed?
We re-reviewed the concerns the court brought up. We wish to proceed as originally set forth.
All right. I think this is a bad move, ma'am, but I'm going to do your plea. It's your constitutional right. You have counsel. It doesn't make sense to me, but I'll do it. Box P states that you are be disqualified from driving a commercial vehicle, and that you're required to notify the Department of Licensing and your employer of this plea within 30 days after the judge signs the document. You understand that, ma'am?
Yes.
We've already gone over that. You've reviewed the DUI attachment. Entering a plea to a DUI greater than 0.08 and under 0.15. Are you entering this plea freely and voluntarily? Has anyone made any threats or promises to get you to plead guilty?
No.
Then you understand that the state would probably hold this open to give you additional time if you wanted. Was your client going to state in their own words the facts? See that off the line.
Yeah, we went ahead and checked the box for the court to review the probable cause statement.
Ms. Jimenez, have you had an alcohol evaluation yet?
No.
Court will enter a factual basis that on December 2nd, 2022, in the city of Battleground, Washington, the defendant Jessica Jimenez operated a motor vehicle after consuming alcohol. Her consumption resulted in a breath test result of greater than 0.08 and under 0.15 within 2 hours of driving. Ms. Jimenez, do you agree with that factual basis, ma'am?
Yes.
And you're again entering your plea of guilty. Ms. Jimenez, what is going to happen now is I'm going to hear from the city attorney, Ms. Carmi. I'm then going to hear from your attorney, Mr. Nicholson. And if you choose to speak, you also have the right to address the court. Go ahead, Ms. Carmi.
Yes, Your Honor. In this case, the city would ask for the pretrial agreement to be followed, which takes into account mandatory minimums based on the amended charge of a DUI less than 0.15.
Mr. Nicholson.
Yes, Your Honor, as the court is aware, this is going to have a significant impact on Ms. Menez's life, in particular with regards to her employment and being a single mother with 2 young children. She understands the options as they pertain to deferred prosecution, the ramifications as it pertains to the SR 22, and is proceeding in this manner by choice, having been fully informed. Given her lack of prior record and the enormous impact that this is having on both her life, career, and finances, we do feel like the terms of pretrial agreement are appropriate and valid. Submit.
Ms. Jimenez, do you want to address the court, ma'am? Right. Does Ms. Jimenez have a date and time that she'll be reporting to Stevenson, Washington?
The 29th of December at noon.
Is not the greatest time of the year to be driving in the Columbia River Gorge to Stevenson. If you run into inclement weather, ice, it snows, whatever else, you can call the court. Let us know, the earlier the better, and we can try to amend your jail slip. So please don't take your life in your own hands to make it up there. Follow the recommendation of the parties, 364 days in jail with 363 days suspended. For 1 day to serve. 1 day will be served in the Skamania County Jail on December 29th, 2022, no later than noon. You do need to bring picture ID with you, ma'am, when you do check in. You're also going to bring this jail form that I'm signing right now. A $5,000 fine with 4,000 suspended, a $1,000 fine to pay, a $150 filing fee, $250 alcohol violator fee, $43 conviction fee, $102.50 criminal traffic fee, for a total financial obligation of $1,545.50. We'll be giving you information, ma'am, on how to enter that through a payment plan. Mandatory conditions are: you're not to drive a motor vehicle without a valid license. You're not to drive without proof of liability insurance or other financial responsibility. You are not to drive with an alcohol concentration of greater than 0.08. You're to submit to a blood and breath test upon reasonable request of law enforcement. Once it becomes an indication on your license, you are not to drive without a functioning ignition interlock device. You're not to have any criminal violations of the law. You're to comply with the rules and requirements of the Department of Licensing regarding installation and use of a functioning interlock device.
Your Honor, would there be any portion of the fines or fees that the court could minimize or redact based upon the fact that Ms. Menez has already been suspended by her employer? And
well, you would have to let the court know before we started sentencing.
All that time to say, oh, hey, by the way, that thing you just ordered, yeah, we need something different. Like, he gave you so many opportunities to tell him what you needed and plead your case. I think the judge is getting a little irritated with him, but I kind of like this judge. Judge Wheeler.
That's why I asked you if you had anything you wanted to say. Ms. Jimenez, I asked you if you had anything you wanted to say. So what would you like to tell me about her financial situation?
She's already been suspended by her employer, and that employment will not be proceeding forward. So I would ask that the court take that into consideration, including the fines or fees that could be reduced.
Do you have any manner of income at all right now, ma'am? Okay. Are you receiving any manner of state assistance at all? Or have you applied for any? You said you have 2 children. Do you receive any manner of support from those children's fathers?
Yeah, I get 130 every 2 weeks for that.
I am gonna find that at this point, based on job loss, you would be determined to be indigent. I will redo this. $5,000 with all 5,000 suspended. The only fee that we have to charge is the emergency response fee, 200. So total financial obligation of $200. Bench probation for 60 months. Substance abuse evaluation within 60 days, has to be with a Washington certified agency. You need to comply with any recommended treatment. You need to attend and complete a victim's impact panel. You're not to have any alcohol or non-prescribed beverages. You need to provide a copy of your police report to whomever your evaluator is. We're going to be setting a review date, ma'am, to check in on that you've completed your jail day, your substance abuse evaluation, and your victim's impact panel classes. That review date is going to be on March 16th, 2023 at 1:30 p.m. That is a mandatory court appearance, ma'am. If you fail to appear at that time, a warrant for your arrest can be issued. Do you have any questions, ma'am, about your sentence in any way, shape, or form?
No, I don't.
Please make sure to stay in touch with your attorney if you have questions or concerns regarding your sentence, or if you have questions about any of the court's orders. Anything further on Ms. Jimenez's case?
No.
All right, ma'am, we'll be getting you quite a bit of paperwork over by the desk. Once you have your paperwork, you are free to go. Good luck. And Hugh here. Okay, Mr. Hugh, I recognize him.
Yep. And Mr. Hugh is an individual who I believe was seeking an attorney.
Yes, ma'am. So last.
I left this next clip in here because it's a fun little game of who's on first.
You can address the judge, sorry.
Talk to Ms. Ma'am. So last we spoke, I was waiting on the terms for a guilty plea for Ms. Carmen. So I have not seen that email yet. I was hoping to just speak to her briefly, if that's okay.
And there must be a miscommunication because our notes were that you were hiring an attorney. So we usually don't
Told us that the last
reach out if you're getting an attorney.
Right. We spoke, when I spoke to her last, I was here. It was my understanding that I was waiting on an email, the terms of my guilty plea. And
so when a person tells a prosecutor that they're hiring an attorney, that prevents the prosecutor from contacting them, because their intention is to communicate with whomever your assigned attorney is.
Okay.
So if you then continue to not represent yourself, because you've come several times and you've told us the same thing each time.
it was my understanding the last time I was here, I was to just, receive the email and then talk it over with my attorney if that's what I wanted to do.
With your attorney, yeah.
Yes, sir. I have not received.
Do you have an attorney?
No, sir. I don't have the email either.
Okay.
Okay.
Might be a little circular here, so I guess I'm just needing some official guidance whether, because if you are seeking an attorney, then ethically we don't communicate directly with you. We have to ethically communicate with your attorney. So
I was not aware.
yes, totally get it. So are you still intending to seek an attorney?
I mean, if everything is good with when we last spoke, I'm willing to proceed without an attorney.
Okay.
Well.
Just looking to see.
What was intended on his case, Ms. Carmen?
I don't have a proposal that has been sent on his case because our notes are that he's seeking counsel. So we wouldn't have sent anything to him, and we haven't.
My last court day, we spoke of electronic home confinement, and I was under the impression that I was supposed to be awaiting information on that.
Now, are you pro se on your other charge as well in Clark County? Or is that a warrant? Is that the case with the warrant? You have the same charges in Clark County is what I'm wondering.
Okay.
And I'm wondering if some of this is crossing over between the two. Are you representing yourself on all your cases? Do
I
you
haven't
have
started
any?
anything in Clark County yet. I was hoping to do it one step at a time.
Our county cases are almost 3 years old.
Yeah.
Yes, sir.
Okay. Yeah, I see that there was a warrant. Well, so here's my concerns right now. So Mr. Hugh, we've been in a holding pattern on this case. He last did a waiver of speedy trial on November 3rd. At that time, he was set over to hire an attorney December 1st. When he appeared on December 1st, we set him over to today's date. So where I'm going with this, Mr. Hugh, is we're getting to where, again, we're whittling down your speedy trial time. You're about almost 60 days in right now. You're about 45 days in. So if we're going to continue to set this over, we're going to do two things today. One, I'm going to go over your waiver of attorney. So you're going to, if you want to continue to represent yourself, we have to do that. And number two, we're going to have to figure out and whether or not you'd be willing to do a waiver of speedy trial, because if not, I need to set your case for trial today.
And I think from the city's perspective, I would just like to get in our notes a formal indication as to whether you are in fact hiring an attorney, in which case the city will wait to communicate with them. Or if today you are in fact not hiring an attorney, in which case we are allowed to communicate directly with you.
I would prefer to not hire an attorney than that way I can communicate.
All right, let's go over your waiver of right to attorney, Mr. Hugh, and then we will talk about speedy trial, and then we'll get a court date set in the future. Mr. Hugh, I'm not certainly telling you what to do, but it sounds like maybe an attorney would be helpful to you with you trying to navigate this on your own.
I didn't realize it was it's complicated up until now.
I mean, you've had the other one for 2 years now, so clearly you have some sense. This isn't your first time in the rodeo. The charges are the exact same, so. Okay, so with that said, Mr. Hugh, I'm going to read through with you your waiver of right to an attorney. And my understanding, to make sure it's on the record, because you're fairly soft-spoken, is that you are intending to represent yourself.
Under your guidance, I think I need to have an attorney.
Would you like to be screened for a court-appointed attorney? Please. Do you receive any manner of state assistance at all, Mr. Hugh?
No, sir.
Are you employed right now? Yes. Can you estimate how much you earn per month after taxes?
Roughly $3,000. Roughly 3,000.
Do you have any dependents at all?
No, sir.
Okay, you're not even close to qualifying for a court-appointed attorney. You're about 2x the court-appointed attorney level. Okay. Do you want to set your case over for you to hire an attorney?
Please.
Okay. To do so, do you want me to go through your right to speedy trial instead of setting your case for trial today?
Yes.
Okay.
Of course, we had to head to the 36th District Court because you are in the 36th District Court. I absolutely love her. She is so adorable. She's a little scary too. She beat my ass. But this is a case of two brothers who got in some trouble. I believe it was drug related, and she was giving him a hard time for using the camera. Both of them on the same camera, but it all worked out. The case wasn't super interesting, but the sentence and the lecture she gave during sentencing was.
Today is the date set for sentencing. Court has had an opportunity to review the pre-sentence reports. With respect to the reports, on behalf of the people, are there any additions, deletions, or corrections with respect to either defendant?
Judge, the people had an opportunity to review the pre-sentence report. I don't have any additions, deletions, or corrections on the people's behalf.
With respect to Mr. Purefoy, any additions, deletions, or corrections?
No, Your Honor, thank you. I've gone over the report. It's very accurate, very thorough.
With respect to Mr. Woods?
No, Judge, no additions, corrections, or deletions.
All right. With respect to sentencing, is there anything on behalf of the people?
Nothing on behalf of the people, Judge.
With respect to sentencing, is there anything on behalf of Mr. Purefoy?
Your Honor, I would ask this court, you're a veteran judge. Obviously, Mr. Purefoy is 52 years old, and he's been very honest that he's had a longstanding substance abuse problem. Jail time is necessary in this manner, in addition to the very severe and strict recommendations that are contained in the pre-sentence report. I would leave it to the court's discretion as to the terms of probation.
All right, and anything on behalf of Mr. Woods?
And likewise for Mr. Woods, Judge, as indicated in the pre-sentence investigation report, Mr. Woods' only criminal history deals with substance abuse issues and possession cases. I think conditions related to getting treatment, attending AA, and other counseling as needed would be appropriate, Judge.
All right, Mr. Purefoy, would you like to make any statement on your own behalf?
No, Your Honor.
Mr. Woods, would you like to make any statement on your own behalf?
No, Your Honor.
All right. The court, of course, I am ready to impose sentence. I will do so in the following manner. I do see one issue, one potential issue. So with respect to the plea agreement, I noticed that Mr. Purefoy's pre-sentence report has a plea agreement, and then Mr. Woods' pre-sentence report doesn't have a plea agreement, but there had to be a plea agreement because he is reduced to a misdemeanor. Do you agree with that, Ms. Ritter?
I do agree, Judge.
And then with respect to both plea agreements, so I don't know what the plea agreement is for Mr. Woods because the pre-sentence report did not state it, and I don't know if it was the same, but Mr. Woods has 2 counts of controlled substance illegal use, and then Mr. Purefoy has 1 count, and then Mr. Purefoy says 1 year probation. But with respect to Mr. Purefoy, well, with respect to both, Mr. Woods, I just noticed that you have something on your head that you are going to have to remove. Oh, okay. With respect to both defendants, it is the court's intention to transfer the case to Judge Shannon Holmes and the Sobriety Drug Treatment Court. However, Judge Holmes, who is a national leader in the drug court process, I guess, for lack of a better word at this moment, and who sits on the national board for drug court programs, she institutes what has been determined to be best practices with respect to the drug court program. And I believe her probationary period is 14 months, not 12 months. And so it is my intention to refer both of these individuals to the sobriety court. But I believe the term of probation is 14 months. It can be shortened if the individuals are progressing properly. So with that understanding, is there anyone, Mr. Sallin or Mr. O, that wants to withdraw the plea? Because I am going to send them to drug court, but I just wanted to say it's going to be 14 months and not 12 months.
I don't believe Mr. Purefoy would have any objections. If you do, Mr. Purefoy, if you have any problems with Judge Brian's decision that it's going to be 14 months rather than 12 months, please state so. Otherwise, we can proceed with the referral to drug court.
No, I don't. Not at all.
Mr. Wood,
okay.
Same question to you. The agreement was for 1 year probation, which is 12 months. The program that you're going to be referred to could potentially have 14 months of probation. Do you have any objection to that?
I didn't hear him.
No, sir.
Okay. All right. The other thing is I was informed by the case managers that at least one of your clients, and I won't necessarily had to say who, but at least one of your clients, I don't know if both of your clients, but at least one of your clients did admit to continue drug use as early as or as recent as yesterday. They have both been ordered to come down to the 36th District Court tomorrow and submit to a drug test. Now, you're not going to be penalized, I guess is the question, the statement I'm trying to say. You're not going to be penalized for the results. However, I need Judge Holmes to see what she's working with. I want to give her a baseline. Gentlemen, you're both too old, but our bodies are go through so much already. Like, without using any drugs and alcohol, abusing alcohol, without any of those things, our bodies go through stuff as we get older. Now, if you add drugs into that, you're shortening your life. You're literally just shortening your life. And I don't know, unless you just decided that you want to leave early. I'm planning on living to 125, piss a whole bunch of people off. Right? That's what I'm planning to do. Live to 125, and I'm going to still be giving my opinion even when I'm not on the bench. They're going to be like, she always said her opinion. Yeah. And I'm going to live to be 125 to do it. And when I'm taking my last breath, I'm going to be trying to tell somebody how to live a better life. You all got to get yourself together. I need you to come off these drugs. I need to see Mr. Wood's face, right? Okay. So you're older, and Mr. Purefoy, you approaching, almost 50, but Mr. Woods, you're over 50. It's time to make a change. The drug court program, I told him to leave you in the thing and to change your name. Yep, they did not follow the instructions. All right. The drug court program, it's not easy, but it is necessary, and it is a good program. And Judge Holmes has a big heart, and grace and mercy is all through that courtroom. I mean, it's just, they're going to try to work with you, give you all the resources you need to help you to live the second part of your life in a sober way. And I hope you embrace that. So, having spoken to the case managers,
We all need to live a better life. I love that. 125 and still pissing people off. She's awesome. She might need to have a little talk with this guy and let him know that a couple of beers is not the thing to do after work.
May 27, 2022, at the location of I-94 near State Street in Pittsfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
No, Your Honor. I was drinking beers.
You were drinking what?
Beers. I just got off of work.
Okay.
Had a couple of beers.
So,
and then,
okay, so you're drinking beer. I'm sorry, I used a big phrase. So you're drinking beer. How much beer did you have?
About 6 beers.
Okay. Were you stopped by the police, or was there an accident?
Stopped by the police.
All right. Why'd they stop you?
I was going too fast, and then Officer Peterson smelled the alcohol in my breath, had me step out of the car.
Okay. But they stopped you because you were going too fast.
Yes, Your Honor.
Were you ultimately arrested?
Yes.
All right. And were you taken to the police station or the hospital?
No. I was taken to the hospital.
Was there a blood draw?
Yes, Your Honor.
What were the results?
I did not get those in.
Would counsel stipulate that the results were a 0.102?
Yes.
All right. Sir, do you have any reason to dispute those blood test results?
No, Your Honor.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
This one's a little confusing, but keep an eye on Miss Ellis as things are going on.
I guess so, Ms. Stevenson. I mean, what's gonna make that any different from today?
So the situation causes Ms. Ellis to first oversleep, which is the explanation for her tardiness today, and then it's making her a little bit incoherent. We're able to communicate, but we need to communicate on a more functional level, Your Honor.
So do you want her to come back today at 1:30, or are you saying a different day?
A different 1:30 day, Your Honor, please.
All right. Then the court will adjourn the matter to, let's see, Ms. Muldrow, my January 12th date, how many reviews do I have? I have that I only had. Oh, wait. Look at me with the, look at me, don't need to ask you. Hold on. Look at me with the dockets printed out. So I don't have to ask Ms. Muldrow. Look at that. Look at that. Okay. She can come January 12th. Now we have one, two, three. Well, that's not yours. That's not yours. We have a couple of reviews, but that's also the trial with Mr. Stanton. If you all think that trial is going to go, I don't know. She can come on January the 12th.
Okay, that would be great.
All right, then I'll adjourn this matter to January 12th at 1:30.
Thank you very much, Your Honor.
All right, you're welcome. Ms. Ellis, we'll see you January 12th at 1:30. Whoops, January 12th at 1:30. Okay, anything else then, Ms. Stevenson?
Nothing on behalf of Ms. Ellis. Thank you, Your Honor.
All right, so there's someone behind Ms. Ellis. I'm assuming they're assisting her?
Yes, Your Honor.
All right, so you have the information, January 12th at 1:30. All right, we're all set, ma'am. Have a great day. Stay safe. Happy New Year. All right, thank you.
I don't know what the situation was, and I hope it was something medical. Generally, if you know you have court the next morning, you don't do anything too drastic the night before that's going to affect you the next morning. Like, you got to get up at 4 o'clock to go to the airport. You don't take NyQuil, at midnight the night before. It's common sense. I think there's we're starting to get this lack of respect for the court system. You see people on Zoom sitting there smoking and laying in bed, and nobody seems to really respect the system. And it's those people who are going to ruin it for the people who it really benefits, who don't have to take a whole day off of work to go sit in court for a 10-second hearing. But hopefully everything's okay and she got everything taken care of. So one last clip, and we're back in Judge Simpson's court, where he just wants her to shut up, I think.
Thank you.
Court calls the case, People versus Damen buyers.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Kelly Yankee appearing on behalf of Ms. Byers. Ms. Byers, if you're here, please unmute yourself and state your full name for the court.
Doing very good, Yankee. She's not checked in. She's like, oh my God. Bench warrant will issue bond 5,000. It'd be 10%. That warrant will not issue until January 6, 2023. Court calls the case, People versus Campbell.
Conrad Siller on behalf of Pittsfield Township.
Kelly Yankee, Assistant Public Defender appearing on behalf of Jakina Campbell. Jakina Campbell, please unmute yourself and state your full name for the court.
Jakina Campbell.
Thank you.
Okay. Go
I
ahead.
have not had an ability to talk with my client yet, so I was wondering if you could please, if we could please adjourn this.
If we could please adjourn it.
Can I say something though?
Oh, can I stop you? No, go ahead. What do you want to say?
I was just wondering, like this ticket is very, very, very old, I think. And I have like a lot of other things going on that I'm trying to get myself together. And
Okay,
it's
which ticket are you talking? You got two. Same day, but okay, go ahead.
okay, so I'm not even gonna hold you up. I don't even recall what this ticket is about because I had so much stuff going on in my life with other courts and other tickets and stuff. And I've been trying to get everything taken care of last year. And I'm just trying to more so ask, can this like just be dismissed? Because I have so much going on that I have to pay for in other courts and stuff. And I ain't really got time. Like
You're gonna have to make time because I'm telling you, they're not gonna dismiss it. Okay. And the other aspect to it is, I mean, I'm looking at your driver. I see what you're talking about. You got like a novel here.
Yes. And I've been like last year I went to try to pay off all my tickets. And I think if this ticket, I caught a ticket the same day. I paid off all my stuff trying to get my license and I caught a ticket the same day and it just pushed me back once again. But I'm really
so here's the thing. All right. I know these are old and it would be nice if they would just go away. Where are you with trying to get these paid off?
So
because you got a lot in here.
Right. So honestly, like where I'm at right now I'm trying to work on Washtenaw County as far as the tickets that I have there, paying them off. But right now I have like a issue going on with a Canton court from a charge that happened 7 years ago. And they just like really stressing me out because I'm on a tether that I have to pay $240 every 2 weeks for. I just got a job and I've been working for like 60 days now and all my money is literally like going to them. They like trying to violate me and send me to jail for a year for an old case if I don't pay the tether. So it's really like just been a conflict of every time I try to make a payment to y'all, they're like violating me for not paying them.
Okay. I hear you now. I see why you want to dismiss because you just need a little bit less on your plate. Right?
Yes.
Okay. So here's what I'll do. Because you got some stuff out of Warren or out of Romulus too. Have you dealt with that stuff?
Yeah. So I just recently paid them $150 to get a court date because the way they system ever since COVID, like they're not taking walk-ins. I would have to like literally turn myself into a precinct, like a jail holding place. And I got children, so it's just inconvenient to do that. So the lady told me recently that I can pay for one of the warrants, which is $150, and then that will get me in front of the judge to try to deal with all of them.
All of them. Okay, gotcha. Okay. All right.
If Miss Campbell wants to plead to double parking today, she can resolve both these cases today, and she'll be done in this court.
Okay. Yes, I'll agree to
that. You know, you got to take a moment and think about it. Might want to talk to your attorney. Might want to. I don't know. She just.
I mean, it just sounds less like a lesser offense. It sounds like a lesser.
I'm gonna. Ma'am, hold on. Just hold on. That is. If you don't take it, it'd be kind of crazy. But Ms. Yankee, any objection to your client pleading to a civil infraction of double parking on the DWLS ticket? Dismiss the other case.
Not at all.
He's done.
No objection at all, Your Honor.
All right.
See how that worked out?
What?
See how that worked out? No adjournment.
You know what? I think you've been going through your life that you just keep talking to somebody, they just give up. I think that's what it was. So you just kept talking. Conrad said, I'm done. Just give her.
You know who's my brother is? Somebody that you're really acquainted with, James Johnson.
Oh, are you serious? Now all of this, now you talking like you, now that all makes sense. All right.
Yep.
Oh my God. I don't know, you ought to be going out saying that a lot, but okay, so she's gonna enter the double parking plea on case 324. 343 is the one that will just be dismissed, which is the false info. All right.
Thank you.
Okay, young lady, do you admit responsibility to the fact that on February 28, 2020, at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you did double park a motor vehicle?
Yes.
Court will accept that admission. Count 2 and 342. Count 1 is dismissed in that case, and the other matter is dismissed. I'm not going to ask you if there's anything you want to say before I impose sentence. Fines and costs of $180, because you'll be talking, we'll still be here next year. Fines and costs of $180. When do you think you can get that paid, young lady?
I can have it paid in 2 weeks. I get paid in 2 weeks. I don't know what day that is, but in 2 weeks.
You're gonna, now you got all that other stuff you were explaining that tugged at Mr. Silliff's heartstring.
I know, I'm
Are
gonna
you
make
gonna
sure
be
I
able to
pay.
do that?
Yes.
Okay, look. See, she's just like her brother, hard-headed. You try to give him, just gonna try to do it. Yeah, then come up 2 weeks later. Oh, you know what happened, Judge, is here. You know I'm right.
You are. You're exactly right.
Oh, I know.
Maybe I
She
should
said
do
2 weeks.
30 days. Maybe I should do 30 days. Let's do 30 days.
Now she getting like her brother. Just let me do 30 days. No, see, now he that didn't work out for him. Listen. Young lady, get it paid by March 1st. All right. I'm just gonna give you a time and a break to do that. Okay. And you're welcome. And don't be like your brother. Just get it done. All right. Don't come back with excuses or trying to talk your way out of it, because I'm not listening anymore. I'm done.
Okay.
You have a great day.
You too.
Take care.
All right, everyone. Thanks for stopping by. It's been fun. It's been exciting. Not really, not quite as crazy as our Florida clips, but I have got so many more and lots to come. So if you enjoyed it, subscribe, and I will keep putting them out as long as you guys are liking them. Thanks. So this is Ziggy. And Ziggy's a little grumpy today, but he's got on his Hawaiian shirt and he's ready to go to the beach. To Florida. Because, you know, Florida's awesome. Cool stuff happens in Florida. People beat up other people with windshield wipers in Florida. That's boring? Why is it boring? Well, they're not allowed to have metallic knuckles in Florida, so they use windshield wipers. It's legal. Enjoy.
Of aggravated battery. There's probable cause for that charge. Are you going to represent yourself, hire a private attorney, or would you like the services of the Office of the Public Defender?
I'm not even sure. This is my first time. I would look into an attorney.
Okay, in the meantime, if you'd like, I can appoint an attorney, someone well-versed in criminal law. That would be from the Office of the Public Defender.
I would appreciate that. Thank you.
Yes, ma'am. I'll appoint the Public Defender's Office to represent you.
Your Honor, she has no criminal history and the victim is present in court, Mr. Silos, and he would like to request contact. Yes.
Mr. Silos, may you please like to come forward to the podium? May you please raise your right hand to be sworn? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
May you please state your name?
Alexander Silos.
And can you please tell me, what would you like to tell me today?
I would like for her to come out. She doesn't need to be in the jail. And she's not a bad person. She's a good person. It was just a bad night, and it was not with anything that was like weapons that would hurt somebody. It was they were windshield wipers. And you know, that day when she was bad, it was because we went out for date night. I took her out to a French restaurant, went out karaokeing. She just drank a little bit too much, and then all of a sudden, whatever, like, maybe she just got mad at an argument that we had in the past. She came at me, and it wasn't whatever, to the point where she needs to be in jail anymore.
Let's recap this series of events. Nice French dinner, followed by a very elegant round of karaoke. And a windshield wiper. I'm gonna think about that for a minute.
Would you,
Or any time.
and you would like to have contact with her?
Yes, we've got a daughter that's disabled, and she's 6 years old, and she needs her mother, she really needs her mother. Honestly, she was crying in my arms and stuff the whole night. It was really sad.
And, you're requesting contact with her?
Yes. I love her, I love her a lot.
And you do understand that I do have the ability today to order that no contact? And so by asking for contact, then, obviously if something arises, you can still call 911, but I could put this in place to help protect you.
Yeah, no, I didn't even call 911. Okay. And no, I don't need protection. Yeah. That night I left to a hotel room to avoid fighting and arguing.
And Miss Neal, how long have you lived at on Forest Oaks?
On and off to 2014. I left for a little while.
And are you
2014.
Are you currently working?
Probably not anymore, but yes, I was.
Okay. And what were you doing?
I worked for Baker at an outpatient rehab facility.
And there's no prior criminal history?
No, Your Honor.
No.
I'm going to set your bond at $100. I'm going to order peaceful contact.
Thank you.
Yeah.
Mr. Slattery? Good afternoon, sir. May I please have your date of birth?
6/25.
Thank you so much. I have a charge for you today of retail theft. There's probable cause for that charge. You're going to represent yourself, hire a private attorney, or would you like the services of the Office of the Public Defender? Yes, sir. I'll appoint the Office of the Public Defender to represent you.
He has 2 counts of possession of controlled substance of marijuana and a paraphernalia adjudication in 2020, a sale of a controlled substance, possession of a controlled substance, another sale of a controlled substance, use of two-way, paraphernalia adjudication in 17, a sale of a controlled substance, use of a two-way, paraphernalia adjudication in 17, sale of a controlled substance, use of two-way, paraphernalia, and a toolless adjudication in 17, a paraphernalia and possession of firearm with serial numbers altered or removed adjudication in 16, a grand theft adjudication in 17, a battery adjudication 14, paraphernalia, and 2013 adjudication, a retail theft withhold in 10, a possession of cannabis withhold 2010, and no valid DL 2010.
That was longer than my grocery list, and I like to shop for food, obviously. I don't even know what to say. Like, it's excessive. And while we could make all kinds of jokes about it, it's actually pretty disturbing the number of people in this jurisdiction specifically who have rap sheets that are pages and pages and pages long that are still reoffending, and nothing is being done to help rehabilitate them. It's just a vicious cycle where they get out and they go back to the same life they had before because there's no resources and there's nothing to help them make a better life for themselves.
Kenneth Castracino. Morning, sir. What's your date of birth?
February 7th, 1979.
I have 4 charges today. I have operating an illegal lottery, playing games of chance by lot, gambling, possession of machines, and gambling, keeping of a gambling house. There's probable cause for those charges.
I have to admit, that was a new one for me. Keeping a gambling house. Florida statute 849.01. Keeping gambling houses, etc. Whoever by herself or himself, her or his servant, clerk or agent, or in any other manner has, keeps, exercises, or maintains a gaming table or room, or gaming implements or apparatus, or house booth, tent, shelter, or other place for the purpose of gaming, gambling, or in any place of which he came first, that's interesting, may directly or indirectly have charge, control, or management, either exclusively or with others, procures, suffers, or permits any person to play for money or other valuable things at any game whatsoever, whether heretofore prohibited, not commits a misdemeanor of the second degree punishable as provided, yada, 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 yada. So, when you're sitting around the table playing poker for pennies, peanuts, Ritz crackers, those Ritz crackers are worth a misdemeanor in the second degree, right? Should ask a lawyer. Need a lawyer. Is there like 1-800-dial-a-lawyer that doesn't cost money? I need a free lawyer. Yeah, because I'm broke. But still would be cool. Maybe one day a lawyer will just magically appear, answer all the questions in the world. Until then, interpret that as you may and hope that, a cop's not showing up at your house while you're, stealing Grandma's Ritz crackers.
As to those charges, you want to represent yourself, you're going to hire private counsel, would you like the public defender?
Public defender.
I'll appoint the PD, state.
There's a reckless driving from 2010.
And can I have an address for you on Horizon Drive in Spring Hill? Is that where you live?
Yes, sir.
How long you been there?
6 years.
You working these days?
Not at the moment, no.
I'm going to set your bond at $500 on each count, so the total is $2,000. We'll have you back in court on the 12th of January. Make sure that you go see the public defender when you get out, all right?
Yes, sir.
Thank you.
I'm a very curious person and I like to research stuff. I love to research stuff. I really, really like researching. And this one kind of intrigued me, so I had to look it up to see exactly what his charges were. And so in addition to that, he had assisting in setting up, promoting, or conducting a lottery, playing games of chance by lot, and possession of coin-operated device. And I did not know that that was illegal. My mom has had a slot machine in her bedroom, or back room, game room, for years that the kids play on, and that is technically illegal. Mom, you better watch out. Who knew? Like, there's so many weird, quirky laws that you are supposed to know, and you think you know, but Like, when you're not really doing anything wrong, it's really not a big deal. But technically, when you get down to it, that you're not supposed to be in possession of it, even though you're not injuring anybody by doing so. You could. You never know.
Afternoon, sir. What's your date of birth? Good morning.
12/17/57.
All right, I've got an aggravated battery with a weapon and use of a firearm while under the influence of alcohol. There's probable cause for the charges. As to those charges, you want to represent yourself. You're going to hire private counsel. Would you like the public defender?
Public defender, please.
I'll appoint the PD. State.
Judge, he has 2 DUIs, one from 2020 and one from 2011.
Excuse me?
Okay. And that's it?
Yes, Judge, but in this case, the victim
What's
did
my,
actually get shot. When he shot through the door, it
Right.
actually did graze her.
Right.
Also, the sheriff's office are.
You know what my bond is, sir?
Sir,
Trying to get
he'll
a
address that. Stop
protection
talking.
order.
Right.
And so we would ask that he have no contact with the victim, and if he could be held till 4 PM so they can serve that on him and go
Will
out to
do.
the house and obtain the firearms.
Will do. Leonard, I got an address for you on December Lane. Is that where you live?
Yes.
How long have you lived there?
4 years, 5 years?
All right. And does Tina live there as well?
Yeah.
All right. Are you working at all these days?
No, I'm retired.
All right. On the aggravated battery, I'm going to set your bond at 10,000. On the weapons possession with alcohol at 500. Condition of your bond, Leonard, is that while this charge is pending, you're going to have no contact with Tina. No contact means no contact of any kind. You don't call, you don't write, you don't email, you don't text message. You don't have a third person contact her. Don't contact her through social media. Don't go where she lives. Don't go where she works. Any way that you might imagine having contact with her, I forbid you to do that. If you have contact, your bond can be revoked and you can be held without bond until the charges are resolved. It means no contact even if she wants to contact. So if you answer your phone and hear her voice, you should hang up. If you're out and about and see her, you should turn around and run the other way. You need to understand that she cannot drop the charges against you. That's not a decision she gets to make. She may go to the state attorney's office and ask them to drop the charges. She may tell them she's not interested in pursuing this, but that decision belongs solely to the assistant state attorney handling your case. So unless that person or the judge on your case or your lawyer tell you the charges are dropped, you should assume they are not dropped and you should not have contact. I'm going to hold you until 4 o'clock this afternoon so that either she could serve you with an injunction or the state can serve you with a risk protection order, whatever comes first. I'll have you back in court on the 12th of January. If you bond out, Leonard, as far as that address on December Lane is concerned, because Tina lives there, you'd have to find someplace else to stay. You could go by one time to collect your things, your clothes, your toothbrush, whatever you need for wherever you plan to go. But to do that, you'd have to contact the sheriff's office first, and then they would arrange a time to meet you there. I'll have you back in court on January 12th. If you bond out, you should go see the PD. If you can't bond out, they're going to come see you at jail, right?
Thank you.
Thank you. Anthony Gleason. Afternoon, sir. Date of birth?
05/269.
Jose, I have 2 charges today, felony domestic battery by strangulation and a domestic simple battery. As to those charges, there's probable cause. You want to represent yourself. You're going to hire private counsel. Would you like the public defender?
Just listening to these hearings, I feel like there's a large number of them that involve domestic violence. But the battery by strangulation has been pretty prevalent in what I've heard so far. And I looked up the domestic violence charges, and in Florida, there's actually 3 different categories for domestic violence charges. There's aggravated battery, which is a 2nd-degree felony and involves hitting someone with a deadly weapon. And there's aggravated assault, which is a 3rd-degree felony, and it involves intentionally threatening someone with a deadly weapon, especially while committing another felony. And then domestic battery by strangulation, which is a 3rd-degree felony, and it basically involves cutting off someone's air supply by covering their throat or mouth, which has the potential to cause serious injury or, even death. So while I was looking this up, a lot of the criminal defense lawyer pages came up, and I was reading through some of their pages, and several of them actually mentioned that this charge is very commonly associated with false charges, that it's very easy for someone to fake a battery by strangulation because there's usually not as serious of long-lasting bruising or damage or things like that that are easily visible to the eye. And that's become an issue that local criminal defense attorneys have been dealing with. But if you're interested, in Florida, the penalties for the misdemeanor charges of domestic battery are up to a year in jail if convicted, up to 1 year of probation, and up to $1,000 fine. And there are additional penalties that they can face that include a minimum of 5 days if someone sustains an injury, participation in a 29-week-long batterers intervention program, which is interesting, forfeiting the right to own a gun while on probation, and forfeiting the right to have a concealed weapons permit. So that's the minimum charges for being convicted of domestic battery. So keep your hands to yourself, people. If you enjoyed this video, please take a moment and like and subscribe. Help us get the channel off the ground. And also let us know in the comments what you want to see, what you like, what you don't like, so we can make it good for you. Thanks. Hey everyone, it's almost Friday, not quite yet. I wanted to throw this one up really quick. I didn't have a lot of commentary to it because you'll understand. What do you say? Warning though, there is a lot of graphic language, very graphic language, very bad words, not just the very, very bad words, but the very, very, very bad words, the words that you reserve for those very, very special people in your life. So do not watch it at work or with kids around. This is a car accident in Michigan. It appears that the young woman was driving. Perhaps it had something to do with a bachelorette party. I tried to look up the complaint or details about the accident, but I could only see the docket and that she was charged. She apparently hit the other woman who was pregnant at the time. And the other woman is still recovering from her injuries. This occurred in early September, and she's still, it was a pretty significant accident, and both of them were seriously injured. And I believe she ended up having to deliver her son early, which you can see her holding throughout the video. He was okay. She suffered some significant injuries, and she is still very, very, very angry about it. So here you go.
952 ST. And let's have appearances, please.
Jeremy Byer for the people, Your Honor.
Mike McEwen on behalf of Brianna Beldon. Please state your name.
Brianna Beldon.
All right, very good. We are here for the purposes of a no contest plea. And I just want to do a quick check here. All right, Mr. McEwen, you want to go ahead and state your understanding on the record, please?
Yes, thank you, Your Honor. Ms. Beldon is going to plead no contest to the single count information, moving violation causing serious impairment of a body function. We're prepared to proceed to sentencing. We've been given a restitution amount, I think, just in excess of $4,000. We do not have an opposition to that amount. Any additional amounts that may be claimed, we would ask be set for separate restitution hearings. There is civil litigation going on. There is what we believe is adequate insurance coverage regarding all of the repercussions from this accident, and that's all ongoing currently in the civil courts.
Okay. All right. One thing before we proceed, it occurs to me, and I would like to put this out there for the reason that we have a rather unique circumstance coming up in our court, specifically a court and school program. I'm wondering if this is a case that the parties would be interested in having sentencing at that space.
My client would not, Your Honor.
All right, that's fine. I would not be in any way trying to push that with anyone. It's just an opportunity for.
I understand. Yeah, she was horribly injured as well, and it's been extremely traumatic. And we're looking for as much closure as we can get, and she's dealing with ongoing medical repercussions, as I'm sure as the victim in this matter. It's
sure.
She's going out to the bar drinking. I'm in a wheelchair.
Wait, Ms. Samantha. First of all, ma'am, I'm going to need you to identify yourself first.
I'm Samantha Niles. I was severely injured in the car accident.
Okay, now what I'm going to need you to do, ma'am, okay, this is a court of law, okay? Now, I understand this is a very emotional time for you, all right? But I do, are you listening to me? I do need to have you hear me. Okay.
I can hear you, I'm sorry.
Okay. I need you to be able to conduct yourself in a matter of with a deal of decorum here. All right, we're in court. We need to conduct ourselves in a civil manner. We don't interrupt people, and we certainly don't interject. Okay, you only address the court when I address you. Now, I am going to be giving you an opportunity to be heard here today. I don't want you to feel like you're not going to be heard, but I can't have you disrupting the proceeding, and I can't have you interjecting emotional statements and outbursts, you know, because we're trying to keep a record here, and we also have to follow through, get some very specific things on the record, but you will be able to be, you will be given an opportunity to be heard at the sentencing portion of this, okay? You can nod your head if you understand. I mean, I don't need you, okay. Please try to compose yourself if you're able to. I know it's difficult, but we'll be with you in a moment. All right. Now, Mr. Bear, you heard what Mr. McEwen has stated. Is that your understanding?
Yeah, I would just like to clarify that restitution probably will be an ongoing issue. I know that there's the civil litigation also to work out, so I would bring that to the court's attention. But that is the understanding, a no contest plea as charged with restitution.
Restitution at this point in time stands where?
I believe the number that Mr. McEwen and I talked about last week, I think that has gone up since then, but that number was the 4,509. I believe I might have misspoke last week. Because of that, that's the number that we discussed. That's the restitution for today. Then the other restitution, Mr. McEwen had stated that he would like that hearing on.
Okay, well, that will be something we can set for hearing at any time that changes, I suppose, if we have a basis for that. But that being said, then we have an understanding then?
I believe we have an understanding of that, the $4,000 restitution number with the ability to set a hearing.
Certainly. And I think Mr. McEwen alluded to that as well. Is that right, Mr. McEwen? I mean, I don't want to speak for people, but.
It is, Your Honor.
Very good. All right. So Ms. Beldon, you heard what your attorney stated. Is that your understanding as well?
Yes.
Okay. And understanding that then, ma'am, you understand you have a right to proceed to trial. And if you did proceed to trial, the prosecutor would be obligated to prove each of the elements of the charges against you beyond a reasonable doubt. You understand that?
Yes.
You understand that if you make a plea here today, there's not going to be a trial. You're going to be, looks like a plea of no contest, but you're going to be offering into the court's review what appears to be the investigative report of the Allegan County Sheriff's Department for me to make a determination based on that. And that's how the matter will be resolved. There won't be a trial of any kind if indeed I make a finding based on that. Is that your understanding and intention?
Yes, Your Honor.
Has anyone tried to frighten you or force you or intimidate you into doing this?
No, Your Honor.
Has anyone made any promises to you?
Can you repeat that?
Has anyone made any promises to you that I am not aware of?
No, Your Honor.
Are you a citizen of the United States?
Yes.
Are you currently on probation or currently on parole for any other criminal convictions?
No, Your Honor.
It's my understanding that you're asking to make a plea to this matter by no contest. And Mr. McEwen, I think you stated that the basis of the no contest plea would be civil litigation. Is that right?
That is accurate, Your Honor.
Very good. And do I have the stipulation of yourself for me to review the Allegan County Sheriff's Office investigative report in order to formulate a basis for this plea?
Yes, sir.
Mr. Baer, do I have the consent and stipulation of the people?
Yes, Your Honor.
Ms. Beldon, do I have your stipulation and consent as well to review the Allegan County Sheriff's Office report in order to formulate a basis for the plea?
Yes, Your Honor.
Let the record reflect that I have been presented with the Allegan County Sheriff's Office investigative report. It is case number 202200017541. It is dated, well, actually it was printed, I should say, on October 7, 2022 for an incident that occurred on September 8, 2022. Let the record reflect that upon review of this investigative report, I have been able to determine that this is an incident that occurred in the county of Allegan on September 8, 2022 in Casco Township. And that the defendant in this matter, Brianna Beldon, did commit a moving violation, specifically failing to stop for a posted unobstructed stop sign, thereby causing this incident, which also resulted in the serious impairment of bodily function for Samantha Niles. Thereby, I will be making a finding of guilt on this matter. Do you wish to address sentencing, Mr. Bear?
Your Honor, I would just like to give Ms. Samantha Niles an opportunity to speak and leave sentencing to the court after she's had an opportunity to express how this situation has affected her.
Okay, now, Ms. Niles, now is an opportunity for you to address the court, and I'm going to ask you to try to do so in as composed and civil a manner as possible, all right?
I do have some PTSD from the accident, so this is extremely hard for me to be able to do. I currently only leave my house for doctor's visits. Leaving the house in general is very hard now, but I have written my victim's impact statement and I'd like to read that. I've thought every day about what I'd say to Brianna since the accident. I thought I'd scream and tell her, look at what she did to me. I thought I'd be able to tell her how worried I've been that my son would even survive. Tell her how worried I still am for his future development after all the medications I've been on. Instead, that Friday morning when I seen her and Mary Freebed transferring in and out of the car, all I could do was cry. That day she was able to get into a car. I couldn't get into a car my whole stay at Mary Freebed. That day I cried for hours after just seeing her. I couldn't believe I seen the woman who was speeding to a job interview at a hospital, no less, that caused these life-changing injuries. Even more surprising, I wasn't able to get a word out when I seen her at that time. Every time I get into a car since that day, I've been terrified, fearful another vehicle will come out of nowhere causing an accident, terrified I would be again trapped in my burning vehicle, unable to get out on my own, terrified my son was no longer with me. Most nights I dream of the accident or being burned alive. I wake up in a panic, soaked in sweat, unable to get back to sleep. On September 8th, that was the first day of 28 weeks pregnant. When I was lying on the side of the road with bones sticking out of my leg, all I could think about was my son. I was unable to find out if he was even alive until I reached the hospital. When I was transferred to the second hospital, where I'd have the surgery to repair my leg, placing a plate and a dozen pins, I had to receive steroids in case my son would have to come early. He would have been 28 weeks, and the hospital that I could get a bed at wouldn't have been able to support him. We had to come up with a plan of what to do in case my son did arrive early. Thankfully, he didn't, and thankfully, he received the steroids to help his lungs. He did, in fact, end up having to come early. He came at 37 weeks. At 28 weeks, he was measuring at the 49th percentile. 2 weeks later, he was at the 19th percentile. 3 weeks after that, he was at the 11th. When he was born at 37 weeks, he was below the 1 percentile. There's possible that the placental damage that caused him not to grow adequately was caused by the accident, considering he was the upper percentiles previously. I was in Mary free bed for a total of 2 weeks. I was unable to even brush my own hair until my first week there. That was a week after I'd been in the hospital. Before I was able to come home, my boyfriend and my dad had to build a ramp so I can get into my house. My mom was able to give me a commode as I cannot get into my bathroom. My boyfriend and my mom have been mostly providing my care. Prior to the accident, I was helping care for my 88-year-old grandmother. She had surgery the Wednesday after the car accident to remove cancerous tumors. So I've been unable to help with her care since then. My dad's been doing that all on his own, as well as helping take care of me. I was actually on my way to do my grandma's grocery shopping when I was in the accident. My 3rd trimester was stolen from me. I should be organizing baby clothes. I should be picking out nursery things. Instead, I was in the hospital. I had to have my wheelchair carried into a house to have my baby shower while Brianna is going out drinking at bachelorette parties with pictures posted on Facebook at a bar. That's unacceptable. This incident took any freedom and independence I had. It took all the joy out of my pregnancy. I do not think I'll ever be able to drive a car again. Currently, when I do ride in a car, I have to ride in the back seat, and I have panic attacks that require me to have the driver pull over for me to be able to get out of the vehicle. I'm on a daily medication now to help with my anxiety, and I have been on that since the incident. There's limited options on what I can take as I'm breastfeeding my son, so the medicine does minimal help. I was just recently in December cleared to be weight bearing on my left leg. My left leg had the open tibula, fibula, and talus fracture where the bones came out of my leg. My right ankle was fractured as well as my right wrist. I wasn't cleared to take those braces off until the beginning. The right foot I was able to take off in the end of October, and the right foot, and then my right wrist I was able to take off at the beginning of December. I've just now started physical therapy to be able to actually walk and do more than range of motion. It's been over 4 months since the accident. Yesterday, I made the most steps that I've made since September. I went 8 steps. That's big progress with the walker for me. Again, I was pregnant when this happened. So, like my son, I have struggled to be able to take care of him on my own because I can't walk. I can't transfer to my wheelchair safely while holding him. He's finally 7.5 pounds this week, so I can wear a carrier, so it makes things easier. When he was born, he was 5.5 pounds, and we've been struggling for him to keep his weight on. I feel like she should be sentenced to the harshest sentence possible. Her negligence that day would have caused me to lose my life if there hadn't been witnesses leaving the farmer's market to pull me from my vehicle. If that had been 8 o'clock at night, there wouldn't have been anyone there to help me. My car was on fire before I was even pulled from it. I was unable to get out due to the broken leg. It's a miracle my son survived. I have lifelong lasting scars, both physically and mentally, from her pure negligence. I would like to know how fast she was going, because there's no way she was going just 55. I think she deserves to go to jail. She deserves more than $500 fine. My life is in this house now. I can't go socializing because the stress that causes me to leave the house, I can't do it.
Okay. Ma'am, and I gave you an extended period of time to share your perspective and your experience. And I want you to know that I hear it, and I'm going to be addressing you very specifically in a few minutes again. But right now, I'm going to need to turn to the attorney for the defendant to ask for his perspective, and then I'm going to ask for her perspective. And then after that, I'm going to be sharing my perspective, okay? So it might be helpful for you, it might be easier for you, I would say, to mute your microphone, just to perhaps prevent yourself from of an outburst, I suppose. But I will invite you to take it off of mute if you'd like to share as I am addressing the court, okay? Does that sound fair to you? Okay, so now I'm going to move on to Mr. McEwen. Thank you, ma'am, very much for sharing your perspective. And I'm going, like I said, I am going to be addressing you very specifically in a minute. Mr. McEwen.
Your Honor, first off, we have to express remorse for the injuries that Ms. Niles has suffered. Was a tragic accident. And we understand that her comments are coming from a place of because she feels helpless, and she obviously didn't do anything to cause the pain that she has suffered. I would like to put it into context, Your Honor. My client's 22 years old. She's never even been pulled over for a traffic infraction in her life. This was a tragic accident. This happened at 10 o'clock in the morning. She's a recent college graduate. She was on her way to meet with the Human Resources Department at a healthcare facility, had offered her a position. She was going through an unfamiliar area. She was using her hands-free GPS. And these are all things that were confirmed through the investigation through law enforcement, not just things I'm representing to the court. And she missed a stop sign. And as a result, this casualty in this accident occurred. And I say accident over and over again because this is what this is. This was an accident, not an intentional act, not a malicious act. And I know it's hard for Ms. Niles to open her heart to that, and because of the pain that she's suffering. But if she could look at her own, she's driven for a lot of years. She herself has committed this exact offense and got into an accident.
Right. That's not going anywhere. Move on, Mr. McEwen.
Your Honor.
When have I ever had an accident where I injured someone? Never.
Right.
Your Honor.
Wait a minute. Ma'am, please. Hold on, ma'am. Ma'am, I'm going to ask you to please, I am going to be addressing the court, and I've already instructed Mr. McEwen not to go into the aspect of running a stop sign prior. It has no bearing on this matter whatsoever, has no relevance. Mr. McEwen, please proceed.
Thank you. She was following her GPS, her hands-free GPS. The accident occurred. The police did investigate it, and we believe that the police investigative report is accurate as it relates to her history and the circumstances that led up to this. She herself was horribly injured. She spent 2 weeks in the hospital. She went multiple surgeries. She spent a week in Mary thereafter. She's been working through physical therapy. She has ongoing pain, understands to some degree what Miss Niles was going through. This was an accident, and they were both probably hurt. As far as the comments about her drinking alcohol, frankly,
that doesn't have any bearing for me either.
All right, I just for her, my client went to a bachelorette party at a candle company, the Kalamazoo Candle Company. They made a candle. Then she went home with her mother, and the wedding party then went out for lunch and had a drink. She wasn't with them. And look at the pictures. She went home. She's still in pain. She made a candle, for goodness sakes.
I'm not going to look at the pictures. I understand what you're saying, but I don't consider that to have bearing. I don't, that I understand you're making a statement, and your concern is to convey that there is remorse and there isn't and that there is a significant impact to your client. But in regard to the bachelorette party and such, I don't find that to be probative on this matter. And please
Very
move
good.
on.
Thank you. Brianna's a safe driver. This was an accident, the one and only accident she's ever been in, the one and only interaction she's ever had with law enforcement with regard to her driving. It's a tragedy. She feels horrible. She thinks about it every single day. We believe that the unfortunate circumstance, the way the law is in the state of Michigan, civil conduct becomes criminalized by virtue of the repercussions. There's nothing we can do about that. But this was a civil infraction, Your Honor, and the only civil infraction that she's ever committed in her life. We'd ask the court to consider a sentence appropriate based on her conduct. Thank you.
Okay. Ms. Beldon, would you like to make a statement?
I just like to say that sorry. I'm really sorry that all this happened. I didn't want this to happen. I didn't ask for it. But I feel remorse on both ends.
Okay. There's a lot to unpack here. Specifically, the most that I feel that it's incumbent upon me to address and work on unpacking is the pain and anger, even outrage, I suppose I think is fair to say, that we have with the victim voicing her perspective and experience. A terrifying experience, obviously. A horrible experience that you did not deserve, that you did not, well, I'll just leave it at you did not deserve. It's one of those things that I do have to agree that Mr. McEwen's statement in regard to it being an accident is in fact the case. You indicated to me that you wanted the harshest possible sentence, and I understand that shaking of the fist and the wanting of a retribution to have some sort of consequence of weight that will rain down upon the defendant in this matter. But I want to also look to you to try to be a little more circumspect, I suppose, in regard to my concern for you, because I know that whatever I do to the defendant in this matter is not going to help you get better. It's not going to make you feel whole. It's not going to remove your anxiety. It's a terrible thing, and it is something that you have had thrust upon you, and again, without reason. And I hear that, and I hear the terror, and I understand the horrible foreboding you feel in regard to the consequence to your unborn child, and now to obviously the child that you're holding in your arms, thankfully. I urge you to follow up with what you yourself, the very first thing you said is that you have some post-traumatic stress associated with this. That is very likely true. That is probably a normal consequence to such a horrific incident, okay? And the terror that you feel, the fear that you would have lost your life or lost the life of your child or impaired the development of your child, all rational responses, all of which I want you to understand that I hear that. I also want you to understand that there's very little I can do about that. I mean, there's really, within the limits provided by the law, there's very little I can do. And I really do want and hope through counseling and your own development and your own course of recovery that you're able to get to a point where you're not focusing, and I would urge you not to focus on the actions and activities of Ms. Beldon, okay? You've got something far more precious to be concerned with and focused on. First of all, you have that child in your arms right now. You said that this incident took all the joy out of your pregnancy, and I don't think you mean that. I think you can look into your lap right now and see that there's an awful lot to be joyful about in regard to your pregnancy. I'm gonna let you address that. I get it. You wanted to plan things. You wanted to do things. You wanted to be involved with showers and things. I am not taking that away from you, ma'am. I'm not. But you do have that child there. And you do have that child there. You do have that child's future to be concerned about. And you also have your own future to be concerned about. It's really incumbent upon you to get the counseling you need for that post-traumatic stress. And that may take a long time. That may take a lot of work. You said that you just took 8 steps yesterday. That's with your physical therapy. And that's been after 4 months. That's a lot of work. That's a lot of work. And I don't want to minimize that. The mental, the post-traumatic impact as well, that's going to take more work yet. And I don't want you to poo-poo that. I don't want you to say, okay, I've dealt with that. I'm just going to let it go. I want you to get that therapy, that treatment. You deserve it, and your child deserves it. Okay? You want to be in good working order, not only for yourself, but for your child. Okay? And being in good working order does not mean tracking and following the actions of the defendant. I would suggest to you that that would be really counterproductive to your own health. All right, please don't focus on that. Please try to be focused on recovery, focused on the love that you have brought into your world there with your child. I'm really happy to hear that he's at 7 pounds, 7.9 pounds, I think you said. That's great. That's good. And is there any sort of medical consequence to him and his development? I don't know that. I know that you are determined to make sure that there isn't, and that you're going to follow up. And if there is any consequence, you're going to do the right thing to make sure that he is as good as possible, and that he gets all of the treatment and therapy that he needs and deserves. Okay. And that is it unfair that you have to do all of this work, work regarding your mental health for the post-traumatic stress, for the
I've been in mental health treatment since the accident happened.
For the physical therapy work that you're going to have to undertake, and for making sure that, and the precautions you're going to have to take upon your child. I'm going to give you the chance to speak to me again. Don't worry. Don't worry. I'm not trying to shut you up. All right. I'm not trying to muzzle you. But I want you to try to focus on that, not on Ms. Beldon. That's not healthy. Even if I could utilize an extended period of jail in this circumstance, I'm going to tell you that I wouldn't do it. Because I get that there's been a horrible consequence here, but I also get that there's not the malicious intent. Okay. That doesn't mean that horrible things didn't happen to you. Horrible things did happen to you. I'm not minimizing that. But it is no sort of solve. It is no sort of antidote to that. To thrust Ms. Beldon into a incarcerated status that would benefit no one. So I'm going to give you, I know you wanted to say a couple of things to me here while I was making this statement. And I just want you to open your heart to your own recovery and to the recovery for your child. But if you have anything else you'd like to share with me, I'm going to let you have that opportunity. Go ahead.
I've been in therapy since the accident. That's how I got put on medication, and that's how I know I have PTSD. I have been doing the work for my mental health. Her bachelorette party took place months ago.
Okay. Ma'am,
I also don't think her age or her history has anything to do with it, because someone can go off and kill somebody and not have a history there too, which is damn near what she did. She could have killed me and she could have killed my son. If those people hadn't pulled me out of the vehicle, she would be a fucking murderer.
Okay, let's first of all, I'm going to ask you to again try to compose yourself. I know it's an extraordinarily painful thing for you, and it's something that has you extraordinarily angry, and I get that. When I say I want you to follow up with the therapy for the post-traumatic stress and such, I expect that you are getting that therapy, but it's going to be, like I say, I'm trying to compare that to your physical therapy. It's a long road, ma'am. I am the presiding judge over the West Michigan Regional Veterans Treatment Court. I am no stranger to post-traumatic stress. And I can tell you that it is a great deal of work, and it's not fair that you have to go through this work, but it's the fact that you do have to. You need to do that for yourself, and you need to do that for your child. The fact that there were possibilities or something could have happened that would have resulted in your death or someone else's death, those are possible, but the world of possibilities are virtually infinite. I'm not taking away in any way, in any manner, way, shape, or form from the responsibility that Ms. Beldon has for this. All right. My concern right now, frankly, far more than with Ms. Beldon, my concern is more with you, that you're able to move yourself forward to take care of yourself and do the things that's necessary for you to do. And I can tell you with 99% certainty that it is harmful to your own interests for you to fixate and obsess over what's going to happen to the defendant in this matter, or what happens going forward with her. Your main concern, your main focus, your main passion going forward, I would hope, will be that young child in your arm right now, and yourself. Look in the mirror and tell yourself you deserve to be happy, and move towards that. In regard to this matter, I'm going to indicate that the defendant will be placed on probation for a period of 1 year. There's $360 oversight fee associated with that. During that time frame, she's to attend the highway safety program, as well as to provide 200 hours of community service at a nonprofit entity. The fines are $500. State costs are $50. Court costs are $200. The crime victim right fee is $75. And that is a total of $1,185 over the period of probation. Any questions, Mr. Byer?
Just to clarify, the court would like us to...
A restitution, I apologize. Let me put back up into the restitution. I do want to make a specific indication, though. Restitution is, at this point in time, $4,509. Subject to future hearings pertaining to sequelae of the accident. Anything else?
That was all.
No, Your Honor, thank you.
That would, let me adjust the total at this point in time, at least the temporary total. That would be $5,694. You can leave the court.
Thank you.
Ma'am, thank you. I want to take a moment also though, ma'am, to thank you for being here to provide your perspective and your heartfelt showing to us your pain, your upset, your anger, and your challenges going forward. I also want to congratulate you, however, in regard to that child in your arms. Obviously, you're committed to taking beautiful care of that child. And that focus on that's a beautiful thing. That's a joyful thing. Focus there.
I don't think her history and her age should have anything to do with that. That's ridiculous. You can...
Ma'am, I did not utilize her age or her driving history to do this. That was not taken into my consideration. I did
hundreds of thousands of dollars in medical bills.
And that's
because her pure negligence, because she was late to a damn job interview at the hospital she went to.
Okay.
Speeding to go to a job interview. It's a small fucking town. We all know you're a stupid fucking cunt. I hope you crash again.
I'm trying to. I want to try to encourage you to compose yourself. You don't want to put yourself in a situation of utilizing the profanity and such on the record. In court, I don't want to put you in jeopardy of any sort of consequence associated with that. And that's good. That's good. It's a difficult thing, and I truly, my heart aches for her. But you can leave the court, Mr. McEwen. Oh, sending Mr. McEwen an email that he has to contact the probation department. All right. I guess I should have started that at 8 o'clock instead of 8:45. Okay. Okay, we have 3 cases up for trial today. We have David Garza. And are all parties ready to proceed in the matter of David Garza?
Yes, Your Honor. Yes, Your Honor.
Okay. Then let's call the matter People State of Michigan versus David Garza, file 221982SM. Let's have appearances, please.
Jury buyer for the people, Your Honor. Kurt Richardson appearing on behalf of David Garza.
Sir, state your name for the record.
David Garza.
All right. This matter is called up today for purposes of trial. Mr. Buyer, are you ready to proceed?
Yes, Your Honor.
Mr. Richardson, are you ready to proceed?
Yes, Your Honor.
That being the case, I will excuse the matter of People State of Michigan versus Paul Hosk, and I will excuse the matter of People State of Michigan versus Gavin Tungate. We'll reset those matters for future settlement conference and trial. So. Anything for the record prior to proceeding, Mr. Buyer?
Nothing prior to proceeding, Your Honor.
Your Honor, I just have one witness that speaks Spanish, just so you're aware, Petra Garza.
Okay.
So the court's aware of the translation line.
Okay, so we'll utilize, that witness is going to be live here today.
She's here, yes.
All right, that being the case, all rise for the jury. Council approach, by the way. No, no.
Hey everyone, this video is a little bit different. I originally put this together looking at the Jessica Lunsford Act, working with John over at J. Robine Law, which if you haven't checked that out, you absolutely should. It's J. Robine, R-O-B-I-N-E Law, over on YouTube if you want some good legal education. He does a lot of looking at laws and deep dive into criminal, not just criminal, but criminal and civil cases, as well as past cases and Supreme Court cases, all kinds of stuff. You would really enjoy it if you like that kind of stuff. But the Jessica Lunsford Act was a very big controversial act at the time, and the case behind the act, of course, was the disappearance and then murder of Jessica Lunsford. And that was something that was pretty impactful to my life at the time because I lived relatively near where it happened. I knew the area pretty well. I knew some of the people loosely connected to the investigation, and I actually had a daughter that was very close in age. So it was a rough one to know what happened and what went on. But it had been a long time since I had really read about the case and gone through it. So I dug up the information and put together just a little summary of what happened with the case and what the subsequent law that was passed very, very fast following her murder put in place, the restrictions it put in place for sex offenders. And it also impacts school district personnel, people who can be on school grounds, and quite a few other things. So take a look. Jessica Lunsford was a 9-year-old girl from Homosassa, Florida, a quaint town on the south side of Citrus County on Florida's Gulf Coast. The area boasts beautiful rivers and waterways and is the winter home to the adored sea cow, known as the Florida manatee. While there are tourists coming in and out of the area to relax on the water, load up on a bag full of scallops, or participate in a dozen of other local activities, they remain on the west side of the county close to the water. Locals have generally always felt safe from the crime that plagues big cities. Neighbors look out for one another, and children still play in the streets until the lights come on. Jessica lived in Homosassa with her father and grandparents. On the evening of February 23, 2005, Ruth kissed her granddaughter goodnight, never anticipating the horror that would overtake their lives in the coming days. The next morning, Ruth heard Jessica's alarm and went to see why Jessie, as she was affectionately known, was not turning it off. Ruth found Jessie's room undisturbed. There was no sign of the innocent 9-year-old girl. There were no signs of forced entry at the home or any indication as to where Jessica could have gone. Ruth called the local sheriff. The sheriff at the time was Jeff Dawsey, a widely popular elected official who would later come under scrutiny for alleged mistakes made during the investigation. While Ruth summoned help, Mark drove around the neighborhood calling for his daughter, unable to understand how she could have simply disappeared. The sheriff's office responded immediately, bringing in bloodhounds, helicopters, and the county's mounted posse unit to help search for Jessie. In the days that followed, the FBI and the National Center for Missing and Exploited Children joined the Citrus County Sheriff's Office in the search. The media picked up on the story, and immediately the community responded as well, Hundreds of volunteers showed up to help search for Jessie, who seemed to have vanished into thin air. Local newspapers ran stories daily updating the progress of the search, and speculation about what happened to Jessie overtook the community. Former Atlanta Braves pitcher and hometown hero Mike Hampton offered $25,000 in reward to help find Jessica. More donors chipped in and brought the reward over $100,000. Mark Lunsford was frequently featured in news clips pleading for the return of his daughter. As days passed, the hopes of finding Jessie alive dwindled, but the search efforts continued and hundreds of volunteers searched daily for the little girl. Flyers were posted on every business and even mailed to residents. America's Most Wanted featured Jessica, hoping to spread awareness and find an answer. Every possible resource was used, yet there was no sign of Jessica Lunsford. There was talk of stopping the search, but the community refused to give up. There was anger at the inability of the sheriff's office to issue an Amber Alert, but with no sign of an abduction, Jessica's disappearance did not fit the criteria. Her disappearance prompted changes throughout the once safe community. Everyone was on high alert. Parents talked to their kids about Jessica's disappearance to show them that the stranger danger they had been taught years ago was real. With no solid evidence, rumors flew throughout the community of what could have possibly happened. Mark Lunsford ignored them and pressed on, pushing for help to find his daughter, holding on to the belief that she was still alive and could be found. Local companies donated door and window alarms that were distributed through the school system in the wake of Jessie's disappearance, hoping to calm fears of residents who still had no answers and worried for their own children's safety. The sheriff blamed the increase in local crime on the growing population in the area, and he insisted the community was still safe. Mark ignored the fodder and pressed on with the search. He even began organizing them himself from his parents' home. Days pressed on, 20 to be exact. Then it happened, the long-awaited break in the case. There was a suspect, and law enforcement was hot on his trail. It didn't take long before we saw the face of evil. John Evander Cooey, a sex offender who failed to register and lived in Homosassa. Detectives learned Cooey was staying with his sister just 100 yards from the Lunsford home. Cooey was questioned and fully confessed. Jessica Lunsford was dead. John Cooey had murdered her. Jessica's autopsy report revealed she died of asphyxiation from being buried alive. Her tiny wrists were tied with speaker wire. Her body was wrapped in trash bags. Cooey told investigators where to find her body on his sister's property, and that night, under the blazing floodlights, sheriff's deputies began to dig. They found her just as Cooey had said, her tiny fingers sticking out of the trash bag, holding on to her purple stuffed dolphin. Hearts collectively broke throughout the community as members came together to mourn the loss of one of their children. It was an unthinkable tragedy, and even more so for a small town that felt safe from this level of depravity. As more details emerged, the grief turned into rage. Cooey was a registered sex offender who should not have been staying at the home across the street from the Lunsfords. If proper procedures had been followed, notifications would have gone out about his presence in the area, precautions could have been taken, children could have been warned, and maybe Jessica could have been saved. There were 4 additional people arrested as part of the investigation into Cooey. Jean Allen Secord was arrested on charges of failure to pay child support. Maddie Catherine Secord was arrested after admittedly failing to inform deputies Cooey lived in the home and lying to deputies to protect him. Dorothy Marie Dixon, Cooey's sister, was charged with obstruction of justice and was accused of lying to deputies about Cooey living in the home. And Matthew Dietrich was charged with obstruction of justice by failing to turn Cooey in to authorities, even though he knew there was a warrant out for his arrest. These arrests did little to diffuse the growing rage. No amount of justice could account for the heinous kidnapping and murder, and there was outrage at those who seemingly helped to cover it up. The local paper ran a small map illustrating where Cooey was staying compared to the Lunsford's home, as well as where he was supposed to be living, over 5 miles away. These illustrations, along with a newer Google map, show how close Cooey was to the Lunsfords. Jessica was literally right across the street the entire time. So many questions surfaced, especially why wasn't Cooey staying where he was supposed to be staying, 5 miles away from where Jessica lived. Despite his confession, Cooey pled not guilty at trial, which was finally set to begin in 2007. It was moved to Miami due to the incredible amount of media attention that it had received in Citrus County. A small local newspaper, the Citrus County Chronicle, sent 5 reporters on the 5-hour trip from Citrus County to Miami to cover the story. On their website, they had daily reports, blogs, and covered every step of the trial for the public back home that was determined to see justice for Jessica. Sheriff Jeff Dawsey held a press conference near the Lunsford home, and ironically, the place where Jessica took her last breath. He called for the death penalty for Cooey. Most of the town agreed. Gawkers frequently drove by the home where Cooey once lived, needing to see for themselves where this tragedy took place. Some went out of morbid curiosity, others to understand, as if seeing the site in person would help them somehow comprehend the level of evil that was right next door. Throughout the trial, Cooey sat drawing intricate sketches, coloring and seeming disconnected to the retelling of his crimes. Mark Lunsford sat stoic, listening to details no father should ever have to hear about their child. The jury returned the verdict everyone had hoped for. Guilty on all counts. At last, some sense of justice was had for sweet Jessica. At a local bar and grill in Homosassa, where locals usually mingled and watched the game, the packed crowd huddled around televisions. The owner of the establishment grabbed a microphone and the crowd went silent. As he announced the guilty verdict, they erupted in cheers. The impact this senseless murder had on an entire community was astounding. Mark Lunsford didn't celebrate for long, though. He knew this was only step one. Justice would not be served until John Cooey was slated to suffer the same fate as Jessica. Hopefully, an old Sparky, Florida's electric chair. Mark needed to see justice for his daughter. It was all he had left to give her. As the penalty phase concluded, John Cooey sat emotionless as the verdict was read.
Madam Clerk, you may publish the recommendation.
In the Circuit Court of the 11th Judicial Circuit of the State of Florida, in and for Miami-Dade County, change of venue from the 5th Circuit, Citrus County. State of Florida versus Johnny Vander Cooey, case number 2005, CF 298. A majority of the jury, by a vote of 10-2, advise and recommend to the court that it impose the death penalty upon Johnny Vander Cooey for the murder of Jessica Marie Lunsford.
Death. The sentence all had hoped for. The justice Jessica Lunsford deserved. Following the trial, Mark took to the courthouse steps to greet the throng of reporters that were covering the case. Several jurors who usually were escorted out the back door of the courthouse and remained anonymous went to the steps. Some were crying. Others embraced Mark. Mark Lunsford's words to his daughter's killer: "Skip all the appeals and take your punishment. Be done with it." Cooey didn't listen to Mark's advice. He filed an appeal shortly after the trial. That appeal was never heard, though, as in 2009, John Cooey died of natural causes. The court's dismissal of the appeal due to Cooey's death closed the case, but was it really justice? The house where Cooey lived and committed his heinous crimes stood for some time, then mysteriously burned to the ground one evening. A relief for Jessica's grandparents, who still lived across the street and had to look at the monstrosity daily. During the years between Cooey's arrest and the trial, Mark Lunsford did not sit idly by and wait for justice. He used his newly found name recognition to get his voice heard and advocate for a bill that would tighten the penalties on sex offenders. Then Governor Jeb Bush, son of the former President George H.W. Bush and brother of former President George W. Bush, signed it into law with Mark by his side. The bill was prepared quickly after the details of Jessica's death at the hands of a sex offender became public. Lawmakers were rightfully outraged and had the ability to do something about it. Once a law, it became known as the Jessica Lunsford Act. It tightened the supervision and the penalties for sexual offenders and predators. One of the other requirements is background screening on all personnel who are permitted access onto school grounds when students are present and those who have contact with students. This provision came as a result of allegations that John Cooey worked on the grounds of one of the neighboring schools, potentially the one that Jessica attended. This law gave Florida one of the toughest child sex laws in the nation. Following its enactment, all but 8 other states enacted similar legislation. While Jessica's name has become synonymous with the law and its impacts, to her community, her name is a reminder that evil does exist in this world, and no matter how hard we try, sometimes it's impossible to prevent it, and it can be living right next door. It's a little chilly out today, and Siggy's refusing to change out of his jammies into his, day clothes. So he has dinosaur jammies because other things that we don't understand in the world is this woman.
8, council appearance.
Attorney Mark Caldwell, P71729.
Okay, Ms. Norris, can you hear me? Yes, I can. Thank you, Your Honor. Okay, today's the date and time set for the sentencing. I do have a pre-sentence report and recommendation. Mr. Caldwell, did you get a copy of that?
Yes, I did, Your Honor. We have no additions or corrections to that report.
Okay, you can make allocution.
Just briefly, Your Honor, she's 36 years old. She has no prior criminal history. This is an isolated incident. She is in Grand Valley State University, getting her doctorate in nursing, and she just got a job last week where she's working at Bronson Health as a registered nurse. In my conversations with her, I know that she has taken this very serious. She's been very emotional at times and is ashamed of her behavior. We would just ask that you follow the recommendation. And I do believe she can pay in full whatever fines and costs are levied.
Yes, I can, Your Honor. Did your client want to make a statement?
Yes, she does.
This has just devastated me. I'm ashamed of what I've done. I just want to reiterate to the court, to everybody, that I will never do this again. It's just devastated me. It's my husband and I are seeking counseling because of it. It will never happen again. I'm just very, very upset by this. And I want to reiterate to the court, to everyone, that this was a once in a lifetime situation. It will never happen again. My life is devoted to helping people, and to do this is very upsetting. So I hope to be granted that opportunity. Thank you, ma'am. Thank you. Did you undergo a substance abuse assessment?
Yes, we have an assessment.
Trying to locate it in the file. Oh, shoot. Sorry, my job was just calling. That was who was calling. My bad.
Okay. I was trying to, Journeys Inc., that's not the same place as Life Journeys, correct?
Correct.
I don't
It's,
believe it. I don't think so. But
it is not. I can speak to it. It is
thank you, Mark.
not. It is not. It is a Grand Rapids location that all the courts in Kent County use for their assessment.
When I called for an assessment, that's.
You don't need to think.
Oh, okay. Sorry.
I'm gonna be very frank. I'm not even positive your client's not under the influence now. I have concerns about her state, her stability. You told her that you'll handle a situation. She can't even be quiet to let you do that. I'm just watching her demeanor during this interaction. And I do have some reservations. And that's why I'm concerned even about this assessment. We have here a situation where the defendant understood and knew she had been drinking and knew that she felt under the influence when she made the decision to get behind the wheel of the vehicle, came back with a 0.17 blood alcohol level. And that in any other circumstances would have been charged as, or could have been charged as a super drunk. My concern is that there is or may be an issue that's not being addressed here.
Okay, well, her demeanor is out of nervousness, not any intoxication of any sort. I have no doubt that she is.
Okay. Well, because of my concerns and my reservations, I think that the court is going to require some oversight. I'm not going to adopt the recommendation. I do think that the indication that you would get behind the wheel of a car with such a high blood alcohol content and knowing that you have been, or you feel that you're under the influence and still making that decision is cause for concern for this court. But also she did, the overall impression based on this evaluation was that she was moderate to low risk, but that's not no risk. And so I want to evaluate that and have an opportunity to have some observation. So I'm going to put her in a short period of probation. And so I am going to place her on a term of 90 days probation. While on probation, she will submit to random preliminary breath test and or urinalysis.
Your Honor, is that going to influence my new job?
No, it won't.
Potentially?
You can speak to me
no,
about
no,
this.
that's okay. That's all I wanted to know. That's all I wanted to know. That's good. Okay. Thank you.
While on probation, you will be required to submit to random preliminary breath test and or urinalysis testing. You're responsible for the process.
Is there a way I can do that in Battle Creek? Or do I have to do that in Kent County? Or anywhere else?
What you're gonna do is you're gonna let me go through your sentencing requirements.
No, that's okay.
I'm gonna give you an opportunity when I'm done to ask me questions, okay?
I'm sorry. Sorry, Your Honor.
Okay.
I still want to lose my job. That's all.
All right, Stephanie, please.
Well. Did you do it? Are you okay, Ms. Norris? Can I proceed? I can't hear you.
Sorry. Of course you can. I'm sorry. I just don't want to lose this job. That's all.
Okay. We don't want you to lose your job either. And I don't think that a period of probation is a situation that cause you to lose your job. Okay?
I agree. All right. Thank you.
No problem. So, and it's a short period of time, it's 3 months, 90 days probation. There's a $30 per month oversight fee that you're responsible for.
Of course.
While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase
Of
or
course
possess a
not.
fire.
Never. Never.
Okay.
Stephanie, can you just not make any comments?
No, I'm going to order her to appear in person for sentencing. I'm terminating the sentencing at this time.
Okay.
Give me a date.
Do we have a court date for that?
January 23rd. Does that work for you?
Yes, it does, ma'am.
No, I'm talking to the attorney.
Oh, I'm sorry. I'm sorry.
Yeah, is that in the morning then?
At 8:30.
All right, thank you.
Thank you. We'll see you then.
Bye. Oh my God.
There's a few things that you shouldn't do in life, like wear black when you live in a house full of pets that shed nonstop. Also, show up drunk to your DUI hearing. It's probably not advisable, but good for the judge for recognizing it and that poor lawyer. I love the comment afterwards when he thought it was disconnected. I mean, what can you do? I mean, it's not like he's standing next to him and he can, finger shush him like the guy in Florida the other day. But really, what do you do? I mean, how many different ways can you tell someone to hush? I mean, these people will never learn.
Your Honor, Mr. Coleman would like to continue his plea of not guilty. Respectfully ask that we schedule this on track for a jury trial. Just want the people to be advised that I did not see that we've received any discovery at this time from the people. We only have the investigator's report.
Attorney Tish, is there a discovery that needs to be provided at this point? You have that available, rather?
You just need one moment to check to verify that it's been uploaded and send. Let's see here.
We have the complaint as well.
Seems I'm having difficulty locating it in my systems, and I can continue seeking the full discovery, whether it's from officers or within my own office, and send shortly after today's hearing, or send when available. I anticipate it to be shortly after today's hearing.
Okay, so let's do this then. The court is going to set this matter for trial. The trial date will be April 11th. And we'll have a final pretrial conference on this matter prior to that date on Friday, March 31st. The time will be at 9:45 a.m. As it relates to discovery, the court does want discovery to be provided to defense counsel.
Your Honor, can I ask a question?
It's not right now, sorry. By Monday, February 6th. And certainly there's, as information is discovered, there is an ongoing obligation of that to be provided to defense counsel as well. Anything further, Attorney Tudge, on that?
No, Your Honor, and the people will do so, or will continue ongoing discovery.
All right, the final pretrial conference on the 31st, Ms. Alexander, the court does want you there as well, okay, ma'am?
Can I ask my question now, Your Honor?
Mr. Coleman,
That
no,
is my birthday.
no. 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 There's a process. I haven't forgotten that you have something that you want to say. And when we get there, you have an opportunity to do it.
Continue on. Go ahead.
Sir, I don't need your instruction or help about what I'm doing. You just need to be quiet. It's funny, I know. It's funny. It's hilarious. It's a gas. It's inappropriate, sir. Just be quiet. That's it.
Told me that already.
Mr. Coleman, thank you.
This is what we're gonna do here then. So Mr. Coleman has a problem with understanding the process, understanding how to.
I don't have a problem with the process.
For a court proceeding. And so we want to have Mr. Coleman in person. We'll set a new date. That'll be a little earlier to give Mr. Coleman a proper understanding of what's happening. It's just, you start the year off with goofiness, I guess. It's how things work. So that discovery date, let's make that the new final pretrial date. And that'll be an in-person proceeding for Mr. Coleman.
When was that date? I didn't catch that.
Mr. Coleman, I think that you think this is cute. I will say
You didn't catch it either. Mr. Coleman, please stop.
I will say that it's not cute. The issue is that there are individuals that are appropriate individuals to speak at a certain point in this process. Those people are certainly the judge, certainly defense counsel, and certainly the prosecutor. There are, and this is why this is important. You know, and I understand that folks have their own perspective on how they think the court process should work, and everybody should be able to talk when and if they want to. But the silliness of it all is the reason why Mr. Coleman should be quiet is because he has the right to remain silent. That's the most important thing. And so me advising him to be quiet isn't because I want to rule this courtroom with an iron fist. It's just so that he does not say anything that can come back to bite him. But he's at time and he's still talking. It is amazing. It's amazing that someone cannot just sit quietly while someone else is talking. It's hilarious. Wow. I don't think this has ever happened with someone just you have to say something. It's crazy. So again, the date that the court is setting for an in-person proceeding is the 6th of February. I think that's what I said for discovery. And so we'll see where we are at that date time. That time will be 9:45. And so maybe by then the people will have certainly provided discovery and or reviewed their information to see if there's an offer to be provided, and we'll just take everything up then. Ms. Alexander, you are excused from Zooming in at that date and time. However, you're free to do so if you so choose, or you are free to observe the proceeding via the court's live YouTube stream. Okay, ma'am?
Okay.
Anything further from the people?
No, Your Honor, nothing further from the people.
Now, Attorney Roberts, I note that despite saying whatever he wanted to say, regardless, there was a question that Mr. Coleman had. And so I don't know if you want to speak with him about whatever that question is.
I think he was indicating that the final pretrial was his birthday in hopes of trying to get a different date. Has that been resolved, Mr. Coleman? Are we all set?
All set.
Okay.
Because I'll be out of town on that date.
I'd like to have a breakout room with Mr. Coleman, please.
Hold on. I have a court order here in front of me. I have a court order that says Mr. Coleman is not to leave the state of Michigan without permission of this court.
Okay. With that being said, I'm going to ask permission.
Mr. Coleman, you do not have this court's permission to do anything but follow what you've been ordered to do at this point. I'll leave it at that. So I laugh because people have everything that they want to do. Mr. Coleman on today has not comported himself to in any way, shape, or form to make the court grant him special permission to do anything. And I don't even remember the first date I gave or when his birthday is, and it's kind of irrelevant to what we're doing on today. But that being said, I would suggest that an individual that was in Mr. Coleman's situation not make any future plans up until this matter is resolved. And so the court's going to continue bond at this point, and we will see what's what on the 6th of February. Again, that will be in person for Mr. Coleman here at 36th District Court, 421 Madison, Detroit, Michigan, 48226 in courtroom 338. Let me do this room thing here.
Do you think he learned his lesson? Because I don't think he learned his lesson. I mean, if that judge was screaming at me like that, I would have learned my lesson. But I really don't think he learned his lesson. What can you do? Until next time.
Your Honor, Attorney Mark Caldwell, P71729.
How are you today? Oh, today's the date and the time that we reset the sentencing. I had to reset the sentencing because I had a concern about you. You know why I had a concern about you?
Because of my interruptions to the court, my behavior that day.
Right, and I recognize people would be nervous in court, but you were so unable to control yourself, it caused me to believe that there was a possibility that you could be under the influence. Because you were behind a device, I couldn't tell.
Of course.
So I had to make it come first. So you've already made your allocution, your attorney has made allocution. Did you want to say anything else for the court at this time, counsel?
You've already heard my allocution before. No, Your Honor. We would just ask that you follow the recommendation.
Okay. The recommendation from the probation department also reviewed your prior criminal history, which was limited. But nonetheless, the recommendation at this time was that you scored moderate to low risk, and you needed minimal probation services. That you admitted that you felt intoxicated at the time, but you expressed remorse. You're still currently employed at Johnson Hospital?
Yes, Your Honor.
In Kalamazoo?
It's Battle Creek.
Did she complete the drug and alcohol class?
She is not, Your Honor. The class that she completed was a 3-hour victim impact panel, which she completed yesterday. I have proof of it on my phone. I can show you that. I don't have it. Oh, you got it. Hey, approach, Your Honor. Oh.
Thank you. I indicated before on the record that I did not feel comfortable with the recommendation. I disagreed. And that's because when I look at her prior criminal history, I look at this incident and I take into account the concerns I had for her behavior. I believe it was important that I have some oversight to ensure that there wasn't an issue that was being missed by this probation officer during the evaluation, even the assessment from the substance abuse assessment, believe that she would benefit from some programming that was a little bit more substantive than this victim impact panel. Nonetheless, with that being stated, I am going to deviate with this, what I indicated last time from the recommendation of probation of the report. I am going to seek to search 3 months of probation. Okay. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or any other dangerous weapon. You're not to use, purchase, or possess alcohol or drugs that you don't have a valid prescription for, okay? Yes, ma'am. You're not to be at any bars or any nightclubs while you're on probation either. Do you understand that? Yes, sir. I'm not going to order any further programming at this time because you did complete the victim impact panel here, it looks like.
Good morning and welcome. Actually, by the time I finally get this up, it'll probably be afternoon or evening or tomorrow morning or who the hell knows. But I just wanted to say thank you all for all the love. I really appreciate it. I never thought this would take off like this. It was supposed to be a fun little side project and it's kind of blown up. Biggin and Mike, Law Talk with Mike, have been absolutely amazing, as has John over at J. Robine Law. I'm putting links to their channel in the description. I'm sure you've already been there, and that's where you came from. But just in case, make sure you check all 3 of them out. Absolutely amazing channels, amazing commentary, and lots of interesting stuff going on. I can't tell you how appreciative I am for the love I'm getting from all 3 of them, and it's pretty awesome. Do you know what's not awesome? When you open up your YouTube feed and the first thing you see is a video about putting butter in your coffee. I know I'm from the South and all, but we put butter in a lot of things, but usually the things we put butter in have to go either on top of the stove or in the stove. You know, we put things in the stove. It's not an oven, it's a stove. It's always a stove. It's not an oven. Stove. Goes in a stove. We put a lot of butter in things, like sticks. We count by sticks. There's no like partial sticks. It's just a stick. Maybe sometimes a half a stick if you're making just like for one person, but usually it's a whole stick. It's how many sticks do you need? Usually it's more than one. We like butter. Butter in the coffee, which how YouTube's algorithm relates that to me is beyond me because I haven't drank coffee in like 15, 16 years. Who knows? Don't do that though. Butter will clog your arteries and kill you, apparently. So the other video on the other YouTube account says, because, you know, that's all about health and stuff. That one wants to tell me how to live better. Speaking of living, here is a gentleman who is very concerned about the time he has left to live. And Magistrate Alicia Fink is having none of it.
Hello, could you state your name, please?
Hello, my name is Richmond Starbuck.
Okay. I have your address on Winewood in Ann Arbor. Is that a good address for you to get mail?
Yes, that's correct.
And is it okay with you if the court uses your phone number and your email to have contact with you?
Yes.
Thank you. This is State of Michigan versus Richmond Starbuck. 23F55009. I have received a petition requesting a court-appointed lawyer.
I will sign that. You may proceed when you are ready, Ms. Yankee.
Thank you, Your Honor. Assistant Public Defender Kelly Yankee appearing on behalf of Mr. Starbuck today. We're going to waive formal reading and stand mute to the charge.
Yeah, 1 second.
Your Honor. Oh. Okay.
Yes, go ahead.
Oh, I apologize. Your Honor, this was a bank robbery. He does not have a long criminal history. No weapon was used or implied in this case. I gave a 50,000 surety bond. I think there should be some type of surety component, but I'll leave it up to your discretion. I am concerned about his mental health, Your Honor. He indicates to the officers that he doesn't have long to live, and he's gonna, hurt himself too.
Okay, thank you. Go ahead, Ms. Yankee.
Thank you, Your Honor. We're going to ask either for a personal bond or a low cash bond, please. He informed me he's not on probation or parole. We didn't see any other open cases nor holds. We went over possible bond conditions that the court may place on him, and he was fine with that. We went over the no contact or the no go to, and he's completely fine with that. He informed me he does not have a medical marijuana card. He does not own any firearms, and he does not need to travel outside the state of Michigan anytime soon.
Okay, thank you. So
And Your Honor,
I think that, yeah, go ahead.
I apologize for interrupting. I was just hoping to impress upon the court just some beg of mercy in the bond issue. My time left to live is in a matter of days and weeks, and I do have people I have to say goodbye to, and I do not.
What is the matter with you?
I have cancer. I have small cell lung cancer.
Who's given you that time limit?
I've been told that it spread to my lymph nodes, and I've refused treatment. So, based on what I've seen with my father and what my
Okay, but this is a time. Okay, so I myself have had cancer in my lymph nodes. All right, so I'm here 14 years later. So did you decide that you were going to die within a few days?
I was told within a matter of weeks if I did not receive
Told by who?
my doctor.
When were you told that?
By an oncologist. I was told that several weeks ago.
Okay. So what is your diagnosis?
Stage 3 small cell lung cancer.
Stage 3 what?
Small cell lung cancer.
That you need to say that a little slower. It's hard to hear.
Small cell lung cancer.
Small cell lung cancer. Okay. Go ahead. What else did you want to say?
Simply that I do not have money right now, and if I'm placed on bond, I will not be able to pay it. And I leave it to your judgment, but I would just ask for the court's mercy, and that's all I had to say.
Okay. Well, I am sympathetic to your diagnosis. I truly understand what you're going through and how that feels. Without it, I would be remiss to have your statement of your life expectancy be how I decide what your bond should be. I hear what you're saying, and it's not good enough for me that you are indicating that you have a short time to live. Things change all the time. I don't have any information in my file indicating what your doctors have actually told you. That's all stuff that might become more relevant at your next proceeding. But for today, Your word alone on that is not enough for me to do anything specific with that information. Having said that, the only reason that this is the type of charge that it is, and I'm guessing this at least partially informed the prosecutor bond recommendation, is that it's a bank that's being robbed. The person that I saw right before you stole approximately the same amount of property with a value of what you allegedly took from the bank with a recommendation for a personal bond. Banks have a lot of power in our criminal justice system. That's why stealing from a bank is a life offense and stealing from your neighbor is not. So I am going to give you a personal bond. No weapon was used. It's not other than the fact that a bank was the victim, it's not what we traditionally see as a bank robbery. While you're on bond, you're not to go to any Chase Bank anywhere in Washtenaw County. I'm just going to say don't go to any financial institution.
We did discuss that if he does have to go to a bank for some reason, someone else can go for him.
Yeah.
That shouldn't be a
No.
problem, actually. I think. And also, I am sorry, but I have not been, I'm sorry, please.
I just didn't hear you say it again.
Oh, I was saying that won't be a problem because I use an online bank that doesn't have branches. And also, I actually do not know what a personal bond is if either you or my attorney could.
Personal bond means you're going to be released under your own personal supervision.
Okay.
So there's no financial component to that.
Thank you.
Okay. No purchase or possession of firearms, weapons, or ammunition. Do not leave the state of Michigan without permission of the court. Do not, I may have already said this, do not purchase or possess firearms, weapons, or ammunition. No criminal behavior while you're on bond. Any questions about the bond recommendations? I mean, the bond conditions are not recommendations.
No, Your Honor, and I will certainly follow all those conditions.
Okay, your court date will be January 26th, 9 a.m. over Zoom. So something will be sent to your email with the exact time that you should appear and also the link to use to appear by Zoom on that day.
Okay.
Anything else?
Nothing for me, Your Honor.
Nothing more, Your Honor. Thank you.
All right, you're all set. Thank you.
Thank you.
Was trying really hard to figure that one out. He may very well be right and, not have much time if he did refuse treatment and does have small cell lung cancer. Generally, when you get close to the end, there's a lot of coughing going on. I've seen that. The thing that I'm struggling with is, why are you robbing a bank? What are you going to use the money for? Because if you don't have a lot of time left and you're trying to get a bunch of money, you really don't have anything to spend it on because you don't have much time left. Don't you want to spend that time with, people or doing things? Or I guess things can cost money. How much money? Risk, reward, that whole balance doesn't seem to jive with the situation that he has in life. Especially the thought of possibly spending your last days in jail versus not having money that you're not going to have the time to spend and doing something that you really enjoy. Yeah, I'm not getting that one. Okay, well, here is a
divorce case for you. Fun times.
Calling case 2010-435-DM Leslie Henderson versus Corey Henderson. Today is Tuesday, January 17th, 2023 at 9:05 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff and Mr. Bartel on behalf of defendant. This matter is before the court on the defendant's motion for parenting time and other relief. Mr. Bartel.
Thank you, Your Honor. There's two motions out there. I guess I'm going to address them both, one by the plaintiff and one by us. We had filed this motion regarding parenting time and other relief in this particular matter. What's going on, Your Honor, is that there was original order entered in September 29th, 2010, and there's two minor daughters. And at that time, they were approximately 3 years old and 1 year old at the time. My client was defaulted. He received no overnights. However, right after the order was entered with my client not receiving any overnights, he started receiving every other weekend. So at least 52 overnights with Audrey. Shortly after that, judgment of divorce was entered. And about a year later, he started receiving that same parenting time with Marissa. It appears in the answer that plaintiff admits for a period of time that the parties exercise that parenting time arrangement, but it appears that they can't agree on the extended period of time. I would note for this court, there was an order entered after a hearing with referee Nuts, and it was signed by this court on February 6, 2020, in which that was a child support review that did put my client at 52 overnights. And as this court is aware, is that those hearings, even if the order for parenting time shows something different, but if the parties are exercising something different, that will be reflective in the actual uniform child support order, which was the case here. However, what happened is we had the pandemic back in 2020 start, and it was about 6 weeks after that occurred. Plaintiff indicated, well, the doctors are saying we should not be doing this anymore. It's a matter of life or death. And she started withholding the kids from my client. And that went on for about 4+ months. And then at some point she said, well, you can start having the kids back, but you can just have them every other weekend, just during the day. And that makes no sense given COVID, but she said we can expand it out when COVID clears up better. Clearly that never happened. And ever since then, since that period of time, the two minor children have significantly altered their attitude towards my client. And we delineated a bunch of examples in the motion. It has become clear that the minor children are given information by plaintiff that the minor children would never otherwise know, such as things that happened during defendant's childhood or when he was under the age of 18. And plaintiff is involving the minor children, showing them text messages to suggest that my client is being nasty towards her, when there's a lot of text messages where she is very controlling and nasty towards my client. She's making claims that my client rear-ended her, going 100 miles per hour with Audrey in the car when she was a baby. I don't understand the answer from plaintiff in this matter. Supposedly they deny that she stated it, but supposedly Audrey overheard it when plaintiff was having a conversation with her former lawyer. I don't even know what that means from the standpoint of, obviously that allegation was out there. Your Honor, it is deteriorated to the point plaintiff doesn't even indicate where the kids were going to school. She was indicating to my client that they were being homeschooled. and then they some type of Zoom, and then come to find out they're going to a new school in person, and we actually have a text message from plaintiff to my client's former ex's son saying, do not say anything to Corey because he does not know. And he responded, 13-year-olds don't tell me what to do. You know, I mean, this is the type of stuff that's going on. This is clear parental alienation. She does not want my client to be with the minor children. The attitude is significant. Just recently, my client did have some time with the minor children, and there were witnesses to this. They had a great time. They went shopping. They had a fun time all day. My client drops the daughters off, and all of a sudden the next day they come out with this huge attitude, throw the bags of stuff they purchased into his truck and say, here you go, we don't want this, just leave us alone. It's totally night and day after they went back with plaintiff. So, Your Honor, in this particular matter, we're asking for the parenting time that my client received earlier, the 52 overnights and holidays. We're asking for counseling in this matter. It's pretty clear. I think both individual and some type of conjoint counseling to get to the bottom of this with Dr. Haugen, I think, is appropriate, because this is clearly night and day as to what has happened in the past. And with regards to child support, Your Honor, I'm going to address I don't know if you want me to address their motion. I can just do it all at once if you want me to.
Go ahead.
Okay. All I would say with regards to that is that there's not a lot of information that is specific, other than there was a car accident and now she is out of her PIP benefits, and therefore we need to redo child support. Just for this court's information, she caused the accident. She was sued. She was the one who was negligent. And if she cannot work because of her own negligence, then I think you can impute wages on her. Right now, we have no medical records, no verification of her injuries, doctor evaluations. And further, there's no indication that she can't at least do sedentary work with regards to her injuries. There are a lot of jobs, as this court has indicated many times over in the last year or two, there's a lot of jobs out there, including sedentary jobs, that she does not have to lift items or whatever. So I think it would be appropriate for imputation of wages at a minimum for her with regards to this matter, Your Honor. Thank you.
Okay, thank you. Ms. Podolsky?
Thank you, Your Honor. This motion for parenting time was filed after our motion regarding child support was filed. The allegations that this schedule has been occurring since COVID are false. This schedule began long before COVID, after things deteriorated significantly in the defendant's home. Minor children were forced to lay in beds that were urine soaked. A tree went through the roof, causing a gaping hole in the ceiling. It was completely inappropriate for minor children to be living in that home, as defendant was refusing to fix that until very recently. Further, he stores multiple guns unsecured in the home. At one parenting time, the guns were stacked in front of the minor child's bedroom, and she was told if she wanted to go in there, she needed to move those firearms. That is not a safe environment for these children. They've been exercising daytime visits with their father for several years. He oftentimes skips visits, misses visits, is routinely late to picking them up, including 30 minutes late on a regular basis. He will get them in his car and return them just a short time later because he doesn't want to deal with their attitudes. Since the filing of this motion at the end of 2022, the children ran away from the defendant's home. My client received a call from a third party unknown to her who said, "I have your children. You need to come get them." The police were called because of this. The children do not feel safe in the home of the defendant. They do not feel that they are experiencing an environment that is safe for them, in that the defendant is constantly using a racist attitude. He makes disparaging remarks regarding protected classes. He routinely speaks negatively about the children's mother. He does this in text message to the plaintiff, but also to the children. There's an allegation that it is plaintiff who is talking to the children about defendant, but that is not the case. It is defendant in his home who continues to speak negatively about my client. He calls her a whore, a slut, and a bitch in front of them on a regular basis. This does not make them want to be in his home. As we stated in our response, the children are in counseling at this time. My client herself is in counseling. Counseling between these parties is not appropriate due to the significant domestic violence history with defendant against the plaintiff. The defendant has raised the issue of Dr. Haugen. We do support the need for psychological and substance abuse evaluations with Dr. Haugen. These psychologicals should be for all parties and with the parties following the recommendations. Based on the concerns we have in defendant's home and with the children having run away just in the last few weeks, we do believe that parenting time should be suspended at this time, pending those psychological evaluations. And we're also asking for a friend of the court investigation. There's a significant history in this case with minimal parenting time in defendant's home and some significant allegations as to what's happening there. And we believe a friend of the court investigation in this case would be appropriate. Lastly, these parties have been communicating via text message. We are asking that this court institute our family wizard so that none of the messages, communications can be deleted in the future, and they've got that standard communication app working between the two of them. As it relates to child support, it is necessary for child support to be recalculated. It has not been done in some time. As we stated in our motion, my client has lost that benefit. She does continue to have medical needs as a result of the accident, including continued surgeries. Since that accident, her income has been based upon what benefit she has received because of her inability to work. We're asking this court to continue to base child support on that inability to work, and the proper medical documentation would be provided at a hearing. So we're asking the court to set a hearing as it relates to child support, deny their motion entirely as it relates to parenting time, and set this matter for a friend of the court investigation and psychological evaluations.
Thank you. Mr. Bartel, anything else?
Just briefly, Your Honor, I'm not going to go down the laundry list of things that they just slung at my client. My client denies those. By way of example, they said just recently he patched the roof of his house. He sold that house years ago, by the way. So I don't know how he just recently patched it. This is the type of stuff that they have. They make up their own information and they throw it out there. It's inaccurate. And this has got to stop. And that's why Dr. Haugen or some other person is very important. Someone aside from plaintiff's handpicked person. And, you know, it's important that some independent person come in, Your Honor. I just had a parent, an alienation case in Jackson County where the mother, or the father, I should say, selected a specific counselor. And that counselor was one-sided and got booted by the judge. That's why it's important that we have some type of independent counselor come in here, evaluate. The whole point here is we're trying to have some type of reunification, number one. Number two, we are also trying to get to the bottom of this. We can't just have a one-sided narrative from plaintiff where she puts all this stuff into the kids' heads and just says, well, you know, it's really only defendant. So that's why we really need that. I think parenting time is appropriate. If all this stuff was going on this entire period of time, Your Honor, and now they say it should be suspended, that makes zero sense. Parenting time as it was with 52 overnights should continue, Your Honor. And I think a hearing with regards to her surgeries, et cetera, should be set.
Okay. Well, what the court's going to do is the court is not going to suspend parenting time. The court will continue the current parenting time order in this particular matter. Again, there's a lot of allegations. The court will order an evidentiary hearing with the referee as to parenting time and child support. In this matter, the court will order that the parties would communicate, and so they know they're only to communicate through our family wizard, so that the court does have access to, again, whatever that communication is. The court would order psychological evaluations by Dr. Haugen, and Dr. Haugen can make a recommendation as to a counselor after that evaluation. The court will not order a front of the court investigation in this matter. The court has ordered an evidentiary hearing. The parties can, again, present all of their evidence and present that to the referee at that time, and we should be able to get to the bottom of it. That will be the order of the court. I'll ask Ms. Podolsky that you would prepare that order and submit it under 7-day notice.
Your Honor, for clarification, are the psych evals for both the parties and the children?
Do we think we need it for the children or just the parties in this case?
I requested them for the children as well, so.
Mr. Bartel?
Yeah, and then whatever recommendation that Dr. Haugen indicates.
Okay. Okay, the parties are in agreement that the children would have an evaluation, so court doesn't oppose that. We'll have the children included in the evaluation as well.
And
If I
those-
could, oh, I'm sorry, go ahead.
I was just saying, those evaluations are to be submitted to council and the court?
Yes.
Thank you.
And I was going to suggest, Your Honor, before and I forgot, that perhaps in this case, mediation might be appropriate only because they never participated in mediation even from the very get-go. And I guess I would suggest that if the court would be willing.
Ms. Podolsky, what's your thought on mediation?
I don't know that mediation would be fruitful in this matter based upon the significant history in this case.
Okay. Well, based upon what at least has been alleged, I don't know that mediation would be productive. So the court's not going to order it. If you want to agree to it, that's fine. Otherwise, we'll just proceed and have the matter proceed with hearings if we need to have those. So.
Sorry, one last, should the evaluations be done prior to the evidentiary hearing?
Yes, yes.
Okay. Thank you.
What happens is, what we'll do is have, just put in there that the evidentiary hearing before the referee will be, again, will proceed once we have concluded the evaluations, so that the referees don't just set a date that you can't get to, because I know Dr. Haugen's very busy.
Okay, thank you.
Okay, thank you.
All right,
Court will end this matter at 9:23 a.m. You're free to go. Have a good day.
I'm not generally one to lecture because, had enough problems in my own life. Not one to, really tell you how to live yours. But one thing I can tell you is if you have issues with another adult, deal with the other adult. Don't mess with kids. Don't mess with kids. Don't mess with cats. Don't mess with dogs. Don't mess with kids. Definitely don't F with cats. There's a whole movie about it. You should watch it. It's really good. But seriously, kids are impressionable. You have the potential to F those kids up for the rest of their lives. Like, don't be a petty asshole. Like, deal with an adult. Don't mess with kids. Don't put them in the middle of your drama. Deal with the adult. Leave the kids out of it. They're not a pawn. They're not a toy. They're not something you can use against another person. Neither are animals. If you're trying to fight over a dog or something, that's not cool either. But especially kids. Like, you're seriously scarring them for the rest of their lives. Don't do it. Don't do it. Don't do it. Please. Pretty please. You have no idea what you're doing to those kids. You probably don't care, but just deal with the person. It's not fair to the kids. Nobody really cares what's fair to you because you got yourself into this. And while we're talking about what you get yourself into, like when you're drunk at the bar, and it's a couple minutes before lights come on and you're thinking about sneaking out the back door with, that person, you really need to stop and analyze the amount of crazy you're about to take home because, one little slip up and You could be stuck with that person for the rest of your life. And you don't know how much crazy is wrapped up in that cute little package at the club. It could be a whole hell of a lot of crazy. And you can't get rid of it once you got a kid involved. You're stuck for a solid 18 years at least. And possibly longer, you know? Just don't do it. Wait till the lights come on. Wait till, you got a little coffee in you. Then recheck the crazy meter.
Ms. Dodgegill? All right, y'all take yourselves off mute, raise your right hands. Y'all swear affirm testimony about to give is the truth, whole truth, nothing but the truth. Mr. Montgomery?
Yes.
All right, and Ms. Dodgegill, you take yourself off mute?
Yes, I want to apologize. I wasn't aware that I could turn my camera off earlier.
That's okay.
So I'm sorry about that.
And I just see people primping it. Well, see people doing a lot worse, trust me. But anyway, so tell me what's happened. Start from the most recent event and work backwards for me, okay? So
Okay, well, the most recent event was in 2020. There was a family violence arrest and a simple battery arrest for Mr. Montgomery in Henry County, and theft by taking my car and left me at a gas station. And at that time, there was a protection, like a no
bond condition,
violent protection order.
Was that a bond condition?
No, that was actually a condition of the case, I guess the
criminal case?
Yeah, that was a condition of the case after the probation. Oh, the probation. That was a condition of the probation.
Okay, condition of probation. Okay, so 2020, but I mean, something else happened before. What's happened, December 2022? Do that way and work back.
Okay, well, the protection order expired. I'm not sure exactly. I don't have the details of it. I have the assistant DA's information.
No, I'm not gonna call them. So you had it in place and it's expired. So you're wanting to get it again. So what happened that makes you want to get another one since that one expired?
Okay, what happened is Mr. Montgomery will not stop contact with my daughter. She's 16 years old, and he's started contact with my daughter. I'm sending her cash apps, texting her like every other day. And I asked him to stop about a year ago, and he hasn't, and
so is it your daughter together?
No.
Okay.
And I've tried to reach out to Mr. Montgomery directly and say, hey, I appreciate your assistance, but I would rather it go through me because that's my child, kind of thing. And he blatantly very rude to me, curses me. There's no kind of way for us to have a conversation without being cursed and on all that. And he's already threatened almost killed me in 2020.
Okay.
So I'm doing that incident. He almost ran over me in my car.
He ran over you in the car. Okay.
Yeah, he almost did. Luckily, he did not because he actually almost killed me on that day. So I know his and he was a simple battery, theft by taking, and family violence.
Is his probation over with?
I'm not sure.
So, in one of his conditions, he's not supposed to contact you or your daughter?
No, that's what I would like, the protection, because I'm not sure. I'm not sure if my daughter, I'm not sure if she, I'm afraid of him, so I don't want him anywhere near me.
Okay, that's what I want you to focus on. So articulate why right now you are afraid of him.
Yes.
Go ahead. I want to hear why what he's doing now that makes you afraid of him.
Due to his nature, due to the actual incident that happened in 2020, and due to the series of events that have transpired, I just would feel.
What's happened since then that makes you afraid of him? Did he violate that what's happened that makes you want another protective order? Has he been in touch with you, articulate why you were, I mean, I get what happened and that makes you scared.
Well, for the protection of myself and my daughter, I mean, I've asked him to specifically stay away by phone or by email, by anything. I don't even have his phone number.
So,
and
if you don't have his phone number, all right, let's see. How is what he's doing right now? How about this? Making you interfere for your safety?
Because of contact with my daughter, she's 16 years old and she's a minor, that's not her father, I don't understand the intention behind it. And I would just rather feel safe to protect my daughter at this point from any contact.
So was the violence before, did it involve your daughter or?
No, she wasn't with me when he almost ran me over. No, luckily she wasn't.
Mr. Montgomery, so why are you sending her daughter money? I mean,
She's 16 years old, Your Honor. We've been together for 15 of those 16 years. She's been my stepdaughter. She makes all A's in 11th grade. When she got into high school, I told her I'd give her $50 for every A. I'm very proud of her. She makes good grades. As far as I know, she's respectful to her mother. I don't see why she shouldn't get what she asked for. I'm not rich. I don't volunteer the money. But she asked me for money like a child would ask her dad. $30 for the movie, $25 go to Lennox. I haven't, to be honest with you, I haven't seen Miss Stagia or her daughter in over a year and a half. This has been the biggest day of my life, wasting my day in almost 2 years. I'm not in a relationship with her. I don't communicate with her. Last email she sent me on December 20th was to send her the money to buy Milan's Christmas gifts. And I'm looking at the dates. She asked for money on December 20th. This is Miss Stagia asking for money. She asked for money on December 20th. She filed this protection order on December 8th.
No, it was more like November. It wasn't December 20th.
This is the biggest waste of the court's time. I don't deal with her. I don't have any dealings with her. I don't know if she lives, works, or anything.
So, Mr. Montgomery, let me ask you a question, and it doesn't matter. Are you still on probation?
No.
Okay. So you completed your probation, didn't get violated or anything like that?
I moved out the house when the incident she's talking about, she was so in fear for her life. When I woke up that morning, she was on my couch saying good morning, and she was sorry. She wrote a letter to get the charges dropped. I don't want any dealings with her. You asking for her asking for a protection order against me, Judge, to be honest with you, you might as well ask, because I'm not gonna bother her no more than I'm gonna bother you. I don't deal with her. Period. Like I don't at all. I'm almost in here for a stranger. I don't talk to this young lady. I don't bother her. I don't call her daughter and ask her, do she need money? She asked me, she texts me as a child would do her father. And I have the CashApp transactions, and I can show you the emails where Miss Stagia has been trying to contact me. I haven't even responded to one of her emails in over 2 years.
So when she's contacted you, what has she said other than, has she said, stop contacting my daughter? What has she said?
I can show you. I saved them all. For this just reason. I'm not sure if you can see this, Your Honor.
Let's see. Back up a little bit. All right, hold on. This is one more thing.
Yeah, she asking for a PlayStation and a.
Is that from your stepdaughter?
No, that's from the young lady on the TV screen.
And it looks like it was sent in November.
No, that's December.
I know that I can read it. If you hold it still, I can read it. It says
December 20th.
I can read it to the judge. It says one more thing. Let me read it. Not sure. One more thing. Not sure if you want to help out with Christmas for Milan. She needs a TV for her room, and she wants the PS5. Quite pricey. So hold on. You moved. Oh,
I'm sorry. I'm trying to be still, but that don't sound like somebody in fear for their life.
No, it's got the glare. You just can't read it from the glare.
Yeah, but the one more thing is the first message I sent before that was saying, look, I appreciate you sending Milan money. However, I would appreciate it if you went through me first. If you do, please respect my wishes. And I said one more thing. That was the second thing, but that was what I said. And that was, and then like the next couple of days, he sent her. I mean, he deliberately. It's right at this point. I just want we're done. We're not together anymore.
I have a question. Do you ask for Christmas money for somebody you're in fear for your life from? Come on, man, you a joke, bro. Please leave me alone.
I mean,
how is that? How is that?
Just leave me alone, man. Let me live my life. I don't want no more harassment.
So, Ms. Dodger, what do you? So he was with you and your daughter 15 years of your daughter's life. So
no,
well, that's what he said.
No.
When I met them, she was 1. She's 16 now. You do the math.
Okay, yeah, I'm a lawyer, not good at math, but
no. I was with Mr. Montgomery. My daughter was 2. From her being 2 until her being about 8.
Your Honor, with all due respect, I can make this short and brief. I don't bother her, and no, I
it's not
want to
lie.
bother her. I'd like to at least have a half a day at work, because this has been the biggest waste of my time. I didn't know if I didn't attend.
So, Ms. Dodger, what is it that you want from him? Because I mean,
I just want to be left alone.
Okay, this is my concern. My daughter and our safety. There's no reason why Mr. Montgomery should contact my daughter or me. And I mean, I was wanting to accommodate like kind of my daughter's wishes, kind of just trying to, just trying to make sense. But I don't want him to contact my daughter. She's 16 years old. I have no clue his intentions by contacting her. I don't want to see him anymore. I don't want her to see him anymore.
So what would you think his intentions are? That's what
I have no clue.
Well, I mean, but you emailed saying this is what she needs. You appreciate your help.
But my email before that said, listen, because initially I thought that it was like trying to make things right with me or trying to do something to make sure. But every time I would say thank you or something, he would be so angry and rude. So I mean, I don't really see it's like some ill intention.
Your Honor, she using this court and hogging up the court, wasting the court time. I guess he's trying to further harass me and uproot my life. But I haven't. If it weren't for this court, she wouldn't have never even laid eyes on me in going on 3 years.
So, Ms. Thursdale, you don't want him
contact me. I would like it's like a year. I would like a permanent.
No, that's not the way it all happens. But here's the thing.
Because honestly, my daughter and I, one more thing.
Him saying this is what she wants for Christmas, and you appreciate his help. So had he always told her, "Hey, when you make an A, I'm going to give you money"?
Okay, it's like I have PTSD from dealing with him through my therapist. I mean, during that time when I was telling you the time we were together from when I was 2, when she was 2 until 8, that was 6 years. I abruptly left Mr. Montgomery for something better because he abused me a lot. And so when I started dating him again, it was the same thing. And so that's just it.
Your Honor,
I don't want him. I mean, I don't even text my daughter.
She can talk to y'all. I'm not interested.
Hold on. So, Ms. Dodger, you didn't answer my question.
Right.
Did he give her money before when she's made good grades?
Yes. That's not his place.
Huh?
I mean, that was before when we were dating. We're not dating anymore.
But I mean, so when did he stop giving her money?
Always.
I don't know. But
her whole life.
My point is that I don't feel comfortable with any connection with Mr. Montgomery at all. Oh, and I want my daughter to be protected.
So, well, hold on, but your daughter's reaching out to him. So have you had a talk with your daughter not to contact him?
Thank you.
Yeah, I've had a talk with my daughter, but that's my daughter. I mean, it's my job to protect her.
Well, exactly. But if but she's also 16, and I don't know how it was when you grown up, but when my mama said don't, she meant don't.
Well, I mean, it's not, I did say that, but I want her to also, this is a second layer of protection for her. So she is 16, and I don't know the intentions of Mr. Montgomery. I would just rather feel that this to protect my daughter myself.
So you want to protect your daughter from him sending her $50 for every A?
From any contact, period.
But how has the contact with her been harmful is what I'm trying to say.
It's the potential that I want to protect from. I don't know locations being shared. I mean, I'm just being a mother to protect.
Okay, no, all right, I understand that, but here's the thing.
Mr. Montgomery's like 45 years old. I don't see why. I mean, that was when we were dating. that's not my problem. Technically, it's not his daughter. I don't feel comfortable. I don't feel like I'm not doing my daughter a service to protect her to the fullest, because I don't know Mr. Montgomery's intention.
So here's the thing. So I can't put a TPO in place because you think maybe something might be happening in the future. It's not like Tom Cruise.
I mean, for the
you know, where it was like in the future, what happened? What was that Tom Cruise movie? Anyway.
Okay, for the blatant violence that has been done to me, family violence been convicted of.
Right, and I understand that he's been on probation and he hasn't contacted you. He was, you know, your daughter was obviously reaching out to him and she's done that. So Mr. Montgomery, I guess, block the daughter's number or tell her, and I guess when she's, you know, 18 and moved out or wherever, she can contact you if she wants. But Ms. Tonja, you also can't call him and say she wants help with Christmas. So
but did you see the message before that? We used to have to show the message to you before that message that I said one more thing. He's showing you half of the message.
Okay, but did you not tell him don't send it to her, send the money to me?
Please, yes, it's laid out in the message before. That was an addition to the first message. I said, do not contact her anymore. If you want to help her out, contact it through me. I'm her mom.
Okay, so I want you to listen. So now you just said you don't mind if he contacts you to give you any money.
I don't want him contacting my daughter. I feel like I know his intentions.
How do you know
protect my daughter? I know he's being convicted of with me and what he's done with me based on the past. So to protect my daughter, I mean, I don't feel like that's appropriate.
Maybe that movie was a minority. So this isn't that kind of system. He did what he did, and I say he did what he did because he was convicted or he pled. Either way, he served time, he served probation, and this isn't the first appearance hearing, so that's the, you know, he did it. He paid for what he did or whatever. But I don't see how anything has happened to your daughter, and I can't go on what you think he may do. Mr. Montgomery, all I can say is her daughter just stopped sending her money.
Because I was actually told from Henry County to come for the additional protection after the probation was over. I was advised to go through the county he lives in for the protection since it expired. So
that's why you gotta tell me what he's done to make you and sending your daughter money for A. Hold on, what he's done since then? Sending your daughter money because she got an A, and then you saying, "Oh, this is what she wants for Christmas. Thank you for helping me out." That's not a threat. It's kind of a little contradictory.
Did you see the message before?
You just told me what it said. That send you the money and not her.
No, it was very more detailed than that. I said, please don't contact me or my daughter anymore. I'm my daughter's voice.
Okay, hold on. But then you responded and said, this is what she wants for Christmas.
If he was,
here's what I'm going to do, Mr. Starjo, because you didn't that thrust over because he's done that. Mr. Montgomery, stop contacting him. Stop contacting her daughter also.
But could you put a note on this case? Because I swear to God, this young lady is like internally, like she'll go to the end of the earth just to ruin my life. I'm in court.
I'm just telling you, don't send her money. Don't send the daughter money.
I changed my number. What more can I do?
All right, there you go. She doesn't have his number.
Don't want it.
All right.
Don't want it.
There we go. If both of y'all will put your emails in the chat, we'll send you the denial order, and y'all stay healthy and safe and have a good new year. Mr. Montgomery, just don't change your number. Don't block her, whatever you got to do. Don't accept emails, anything like that. Okay.
I mean, she's smiling because she get what she. This is all.
Mr. Montgomery. Mr. Montgomery.
It's up the judge to tell you that. Like,
Mr. Montgomery.
Yes.
It's not in place. I'm just telling you to leave her alone.
Okay.
Okay. You block her daughter's number, block her number, block her email. Move on with your life. Okay.
I'll continue. I will continue. Thank you.
Thank you.
Both of y'all put your emails in the chat. Once you do, you can both leave the meeting.
Unfortunately, you can't have it both ways. You know, either you don't want her to have the money or you do want her to have the money. But, you know, if you don't want him to give her the money, you can't call him and say, hey, you want to give me some money for her? That's not how it works. Just cut it off. No contact. Move on with your life. Just move on. It'll be all right. Lots of crazy today. Speaking of crazy, my animals have been quite crazy today. They're colluding together to help each other destroy things. Rambo knocked the fish food off the top of the fish tank, very high up. I'm not really sure how he got there. And then Penny chewed the lid off of it. So I had to go, do a bunch of Googles to make sure fish food wasn't going to make her sick. And she immediately puked it up all over the floor, of course, not outside or anything. So we've been having a fun morning. I hope you have too. So if you liked this, please take a moment, hit like and subscribe. Please subscribe. We're almost to 1,000 subscribers, which is absolutely amazing. As soon as we hit 1,000, I will do a fun little live. My first live. I'm sure to screw that up. So if you want to watch me screw up a live, hit like and subscribe. Tell a friend. Make them hit subscribe. We're almost there. Thank you all for everything. Thank you for the love. I appreciate it, and I will see you soon. For those of you who haven't met her, this is Penny. This morning, Penny thought it would be a good idea to go find a mud puddle and dig in it. So Penny had to learn a hard lesson. So we had a long talk about things you shouldn't do. Things we shouldn't do. We should not dig in mud puddles, right, Pen? No digging. No, because then Mom has to wash you, and you don't like washy-washy. Washy-washy is not fun. I know. No washy-washy. So Penny wanted to put together some videos for you to show you some things that you should not do. And here you go. This is number 1.
Sure. Let's Mason Brown. And who's here representing Mr. Brown?
Good morning, Your Honor. My name is Tracy Newbin.
Good morning. All right. And there's Mr. Brown. All right. This is case 17095, arraignment, 1 count of stalking.
Yes, Your Honor. And this is a first appearance. So conditions have not yet been set.
Okay. All right. Then Mr. Brown, do you understand the charge against you is stalking?
Yes.
All right. And have you discussed your legal rights with your attorney?
Yes.
All right. Would you like to ask me any questions about your rights?
No.
Okay. All right. Ms. Newbins.
Good morning. So we understand the charges that are set forth against him, waive formal reading, and wanted to enter a plea of not guilty.
All right. Plea of not guilty will be entered then. And is there any stipulation to probable cause for setting release conditions?
No.
Okay. Let's see if there's I don't know if there was a declaration. I don't see one. No. Okay. All right. Was the state going to be, or the city of Tumwater going to be asking for release conditions?
Yes, Your Honor.
Okay. Do you swear the testimony you give in these matters this morning will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. Go ahead.
The state is seeking to establish 1 count of stalking. The facts to establish this charge are from Tumwater Police Officer Thompson from a report dated November 20th, 2022. He responded to a report by Alexandra Wilson of a possible stalking incident by her ex-boyfriend, Mason Brown. Mr. Brown and Ms. Wilson dated for several years and are now separated. They have an infant child in common and a parenting plan in place that allows Mr. Brown to have the child every other weekend. They have a shared diaper bag that they trade off when they exchange the child. That day, Ms. Wilson reported that she exchanged their baby and the diaper bag as usual and returned to her new apartment. A few hours later, her roommate got home and his iPhone notified him that there was an Apple AirTag nearby. He connected to the AirTag and activated the audible chime on the tag.
So for those of you who don't know what an AirTag is, it's a little keychain size object that will link to your phone and will send signals whenever a phone is in range telling you its location. The same way you can locate someone on a phone or, low jack their car. It's pretty much the same thing, just modern day technology. And when I pulled up the website, before I even got on the website, the description on Google says AirTag is designed to discourage unwanted tracking. So, at least she found it, and apparently it's doing its job because she was able to get rid of it and take him to court, I guess.
Ms. Wilson and her roommate followed the chimes of the diaper bag. Ms. Wilson was not able to extract the tracker from any of the pockets and had to cut the lining of the bag to remove the tracker. She told Officer Thompson that she had safety concerns and did not want to be in contact with Mr. Brown. Officer Thompson later spoke to Mr. Brown, who admitted that he put the tracker in the bag so he could know his daughter's approximate location when he does not have custody of her. Utilizing the serial number of the tag, Officer Thompson located a sales receipt and security footage of Mr. Brown purchasing the AirTag from Walmart on November 20th, 2022. Your Honor, the state believes that that establishes one count of misdemeanor stalking domestic violence.
Let's see here, you've alleged 9A46110. All right, anything from you, Ms. Newbins?
No, Your Honor.
Okay. All right, based on the declaration, I'll find probable cause for the crime of stalking. All right, what release conditions is this city looking for?
Thank you, Your Honor. The city has no objection to continued release on PR with standard release conditions, including no new criminal law violations and no firearms or dangerous weapons. We're also asking for no contact order for Ms. Wilson, as well as for the shared child. And I know that a no contact order with the child is not necessarily standard, but I do believe that in this case, the child was present and is it's insignificant risk of harm based upon the defendant's actions of that place the victim in fear based on his surveillance of her.
All right, Ms. Newbins, your position on release conditions?
Your Honor, we have no objections to the standard conditions. However, as far as the NCO goes, Ms. Wilson has already filed for a stalking no contact order and it was dismissed by the judge. We, at the very least, want to make sure that since they co-parent, that they're able to have contact regarding just the exchange of their child. So we ask that the no contact order not be in place.
Okay, yeah, I'm looking here at the, there was a protection order petition, which it looks like it was filed and then expired, if I'm reading it right. And then there's also a parenting plan. All right. All right, Mr. Brown, let me confirm your contact information. Pearl Street in Centralia?
Yep.
Okay. All right,
Apartment
I'm
16.
gonna release you on your own recognizance with conditions. Those conditions will be, don't violate the law, don't possess firearms or dangerous weapons, and comply with the conditions of the no contact order. I'm gonna issue that no contact order with regard to Ms. Wilson only. And I don't have the advantage of knowing what the exact provisions of this parenting plan are.
I could tell you what the parenting plan basically is. I can outline.
That's okay. You don't have to do that. All right. Did you submit a proposed no contact order?
Your Honor, I did prepare one. I just hadn't put any exceptions in it yet, so I hadn't moved it, but I will move it right now.
All right. All right. My inclination here in issuing this no contact order is to prohibit contact with the exception of electronic contact, which would be text and email regarding the child. So that'd be no contact with Ms. Wilson with the exception of text and email regarding matters to do with the child. Other than that, no contact.
Okay.
All right. We will set a pretrial hearing for you. You'll get that notice in the mail. And we'll see you here then.
So lesson number 1 is we don't track things that don't want to be tracked. Kind of like we don't sniff butts that don't want to be sniffed. We just don't do those things because that's not nice. We respect other people's privacy. It's very important, right, Penn? Right?
We pass out.
22-40778, is that you? All kind of names there on your chest. Yeah. That's one way to do it.
It's very important when you're going to court to wear your finest attire. Make sure all the important areas are covered. And no hoodies, even if they do have cute little frog eyes on them. Keep the hats off the head. We need to still, even if we're on Zoom, look appropriate. Because if we screw this up, they will take it away. We want to have nice things. Please don't take the nice things away from us.
First, we'll go straight to the state. This for the state.
It'll be me, Your Honor.
All right, please proceed.
Your Honor, officers arrived in reference to a domestic dispute. They spoke with a defendant who stated that the victim and her have been living together for 9 months and got into an argument. She told officers that she made the victim leave the residence, and after she left, she smashed multiple plates belonging to him and wrote that she was I am a whiny ass, bitch, and pasta sauce on the walls. The state will be requesting a $3,000 surety bond, 1 anger management class, no contact with the victim, Anthony Quantrochi, that's QUANTTROCCHI, and to stay away from the incident location, 3125 Addison Lane in Johns Creek.
All right, I'm gonna sound for, is it Quantrochi? Is Mr. Quantrochi present on this Zoom conference and wants to make a statement? All right, I don't see or hear Mr. Quantrochi. Who represents this defendant?
Petey Kim.
All right, good afternoon, good to see you, Ms. Kim. Ms. Kim, your
Good
recommendation.
Yes, Miss Beasley is actually a victim of this whole incident. She was attacked and battered by Mr. Anthony. She was the one who called for the police because he struck her and he used his arm to choke her neck, and she was knocked down to the floor. And all the rest of them happened after all that. But the police didn't catch the first part. I was wondering if we can get a signature on bond. Miss Beasley is qualified for public defender services since she has a seasonal job that she travels once in a while. Last job she had was August 2022, and ever since then she has not had any income. She has a bachelor's degree, and she has been living with his Mr. Anthony Quantroch for last 9 months. She's from Houston, Texas. He is the sole person that who has been contact here in Georgia, and my client is afraid of him now. She does not want to go back there. She does not want to continue the relationship. So she's the one who want to have no further contact and stay away from that location, except that she just has to go back there one time with a law enforcement officer to retrieve her personal belongings and her dog. So we would like to request for a signature on bond. Thanks.
All right, at this time, defendant will receive a $5,000 signature bond through the jail. She is to have no further contact with the alleged victim, last name Quantrochi. She's to stay away from the address on Addison Lane. She can return one time with a member of law enforcement to get any items, and she's to have alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor.
No.
All right.
So please, Miss Beasley, I'll be happy to call you to explain anything and everything. You've got the best deal, so I think you should stay silent.
All right. Best of luck to you. Who do we have next?
Another important lesson is don't play with your food, or mom will take it away, and then you won't have any food. Then you'll have to eat dry food. Oh, the horror. The horror. Don't play with food.
CR 000-323A. You're charged with simple battery and theft by taking with the offense date of January the 16th. Do you understand your rights?
Yes.
All right, Mr. Howard.
Second arrest, last was back in September for disorderly conduct out of Riverdale. So that appears to be open.
Thank you. Mr. Taylor?
Your Honor, on January 16th, 2023, the defendant entered multiple restaurants in the area of 933 Peachtree Street and caused a disturbance. He went into Five Guys where he was ordered to leave and grabbed the arm of a worker there. Once he left there, he went to a nearby Vietnamese restaurant, Sewing Garden, and was acting drunk and belligerent. He was asked to leave there, but refused and got into a fight with two security guards on the premises who removed him. After that, he went into a Taco Mac where he went in the kitchen and grabbed a 9-inch knife and was ordered to return the knife, but left the business with it. The state would be asking for a $7,000 surety bond to stay away from all three locations, 933 Peachtree Street, which is the Taco Mac, 848 Peachtree Street, which is the Sewing Garden, which is spelled SOIGNE. Garden is common spelling. 860 Peachtree Street Northeast, which is the Five Guys, and to have no contact with Jordan Jones, who's the victim that he grabbed, and to have one anger management class.
All right. Ms. McLeod?
Yes, Your Honor. My client is 22 years old. He is a native of Atlanta. He is gainfully employed. He tells me that he works for Allied as a security officer and has been doing so for some time. He denies the allegations as stated in the warrant and in the prosecutor's statement of the case. He said what happened was that he was actually at a club sitting and having a drink, and when the alleged victim approached him and offered to buy him a drink, and he kept trying to ply him with drinks, and he didn't want to have any more drinks. And that started an argument because he just thought it was odd that this guy just wouldn't go away when he wanted him to go away. So an altercation started, and the security guards jumped on him. And the reason why he tried to go into these other restaurants, he was trying to get away and he was trying to find something to defend himself with. So that was when he went into the restaurant, because there were these three men after him and he grabbed the knife. I would ask the court, given the fact that he does not have any significant criminal history and these are not personal people, he was just out, and as he said, he was jumped by these people, that the court would consider giving him a signature bond so he can get out of jail and get back to work. Nothing further, Your Honor.
All right, at this time, the defendant's going to receive $1,000 surety bond, $500 for each count. He's to stay away from each of the locations on Peachtree Road and have no contact with Mr. Jones. Moreover, he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further, Your Honor.
No.
All right. Best of luck to you, sir. What do we have next?
Your Honor, that concludes my business before the court today. May I be excused?
Yes.
In addition to not playing with your food, you probably shouldn't isolate yourself from all the good restaurants around your house. You need a place to eat.
Last name Arthur, first name Alivia. Anyone in our virtual courtroom with either that first or last name, if you are with us, state your full name, please.
Olivia Arthur.
And today is in fact the date and time set for arraignment on the bench warrant. The bench warrant indicates that this individual chose not to come to court on December 22 of 22 in front of Judge Hoffman. Counsel, would you identify yourself and why did your client choose not to come to court? She's just appearing this afternoon by way of audio only.
It was just the same thing that it is now, which is just a Zoom meeting. And I simply was told that it was on the 22nd, and I remember hearing the 23rd. So it was just a matter of the dates. And then as far as me trying to reschedule it, just little petty stuff like phone being dead, oversleeping, because I'm a full-time mother who's also working third shift. So all the times that you guys want me to be in the meetings is when I'm supposed to be sleeping. So it takes a lot of work to be able to, wake up to that alarm when you're just not going to sleep. So it's just honestly, just some small, just forgetful type stuff. It was never intentional or me running. And then I don't live in Saginaw. So that's the reason why I have to do everything over Zoom. I just caught the case there.
And counselor, her excuse of her oversleeping, we're going to make sure this warrant, counselor, we're going to recall this warrant. Counselor, what is her current address? Because we're going to get her because she thinks that she's giving me all these excuses why she's not coming to court. We're going to eventually get her. She's just
How many times do I have to tell you? I was never told to come to court. I only had arrangement meetings over the phone.
Ma'am, you're just appearing by way of phone. This is an actual court hearing. Just because you're appearing by way of phone, it is a court hearing. And counselor, what we'll do, we'll recall the bench.
Okay, but you're making up stuff because even when okay, but you're not giving me a chance to talk, and everything you're saying is not true because there's recorded phone calls. So even when I did set up another meeting, I literally called during the meeting at 1:37, and the meeting was over at like 2, and I was sitting in that meeting for an hour. And the person who set up my meeting failed to tell me that it was already going when I called to double check to see what it was. So that was miscommunication on the court's end, miscommunication that was wrong on the court's end, and I already have that in my notes. So I'm not going to be blamed. You're not going to attack me because I've only missed one arrangement, and the other one, the court failed to tell me the correct time when I called back for it. I live in Flint, so that's the whole point of the arrangement.
Court takes a matter of people versus last name, Lately, first name, Niles. Anyone in our virtual courtroom with that first or last name, would you state your name? Anyone with that name?
Niles Lately.
And that's ticket number 2015940. And today is in fact the date and time set for your arraignment on this bench warrant. The bench warrant indicates that you failed to appear on August 29th of 18 for a show cause hearing, and you failed to pay $420. Counsel, would you identify yourself for the record, please?
Yes, Your Honor. Damian Fisher here for Mr. Lately for the purposes of this arraignment. Given what you just said, there was a show cause for ability to pay. That puts him in a payment situation here with recalling the warrant. Is that correct, sir?
Why didn't he appear for his show cause hearing on August 29th of 18?
Indeed. Mr. Lately, this is the time to tell the court.
Well, as the reason why I didn't show is because I didn't have a ride for him to do, and I didn't want to risk getting more in trouble by driving myself there.
That stated, Your Honor, I do see that there is an updated address that Mr. Lately has, and I see that the bench warrant has a Parkside court address in Saginaw. He's got an updated address out of Ypsilanti. That may be another.
Okay, what is this gentleman's current address? And sir, quit moving. Would you stop moving? You're in a court of law. Stop moving. You're in a court of law. Counsel, what is this gentleman's current address?
Your Honor, I have 1572 Village Lane, apartment 101 in Ypsilanti. 48198 is the address he gave me.
And counsel, what we're going to do, we're going to recall the bench warrant. Bench warrant will be dismissed. We're going to refer this back to Judge Jones for an ability to pay hearing. He'll get another notice in the mail. If he doesn't show up, then we'll do another warrant and we'll eventually get him. That'll conclude this case.
Yes, and to answer your question, Your Honor.
Address?
Thank
like
you.
you're trying to. I'm not understanding what you mean by taking me in. Like, I'm not understanding what's going on. I have a simple case of a misdemeanor of somebody bullying me and her trying to lie and say that I was being aggressive towards her. She's not even showing up herself.
And ma'am, your lawyer will be in touch with you. Counselor, what is her current address?
Thank you, Your Honor. I have 4186 Corunna Road in Flint, 48532.
And that's the current address we have. We will, as indicated, bench warrant will be dismissed. We'll refer this back to Judge Hoffman. And counsel, make sure you have contact with this individual because my file indicates that we entered bench warrants for her. A warrant was entered on January 9th of 23, November 11th of 20, January 11th, January 9th of 23, October 10th of 22, December 27th of 22, January 5 of 23. So make sure you have contact with her at that address, and that'll take care of this matter.
This, my friends, is why we can't have those nice things. I swear. Would she talk to the judge like that if she was standing in front of him in court? I mean, maybe she would, but probably 95% or so of the time, people would not talk to a judge like that, standing face to face to them. When someone has a keyboard, a screen, a phone, something in between them and the other person, it's so much easier to let that attitude fly. And I think that's what's happening here, and it's going to get her in trouble. I am really surprised at the restraint that that judge showed. He could have, yeah. That was out of line on so many different levels. The lack of respect is unbelievable. I mean, how many other people should we respect more than judges? They're determining your fate in so many different ways. If you should be nice to anyone, you probably should be nice to them. So she did all that, and then 10 minutes later, she interrupts.
When am I going to be able to talk? Because the judge said some false information about my case and my court date.
Ma'am, Mr. Fisher will be in touch with you. Does he have your phone number so he can call you, ma'am?
Hey, I'm not seeing who's on that. Is that Motorola Moto G 5G? Your Honor,
what is your name again, ma'am? She must have hung up.
Always listen to Judge Dad. Judge Dad knows what he's talking about.
Good morning, Your Honor. Gabriel Lacey on behalf of Ms. Moline.
Your name?
Chelsea Moline.
Whose name is on this file?
It was originally, but we tried to give Mr. Crawford some relief. Because it's so busy today. Well, Judge, she didn't show up, so it's a warrant.
Yeah, I know, she's got big issues. She's got big issues.
Your Honor.
There's a bond violation. She was supposed to be here January 4th. This is Ms. Tessino. Ms. Tessino testified to a bond violation. She was placed on sobriety court status. She failed to appear for testing on December 22, 27, December 30, December 31, and January 2 of 23. I found by a preponderance of the evidence that she violated the bond conditions. I set for a bond violation hearing. I could have easily just forfeited the bond and issued a warrant pending a hearing. We set it for January 4. You didn't show up then. Then I issued a warrant. She just walked in today?
Yes, Your Honor.
How old is she?
I'm 28.
When are you going to start to grow up and act like it? Seriously.
I understand that.
Well, I hope you do, because I don't appreciate this. I tried to give you a break. I tried to get you some help, and you just blew it off. And now you start thinking you're larger than life and you don't have to show up in court. And I just don't appreciate that. We're not a restaurant here. We're not a ballpark. This isn't play golf if you feel like it today. So I guess the first order of business is I have to find out what she's going to do with the bond violation. Is she going to plead guilty to these or not? Or does she want to have a hearing as to whether or not she failed the test December 22, 27, 30, 31, and January 2?
Your Honor, we're not asking for a hearing. We are pleading guilty with explanation.
Call in, Ms. Tessino. If you do that, if you plead guilty here, your bond could be forfeited, released, revoked, high cash bond set. Do you understand that?
Yes.
Did you sign, read, and understand this advice of rights?
Yes, I
If you
did.
plead guilty, you'll be giving up all those rights. And there will be no hearing of any kind. You understand that? You
Yes,
understand
Your
that?
Honor.
I'm sorry?
Yes, Your Honor.
To the charge that you failed to test on December 22nd, how do you plead?
Guilty.
You failed the test on that day.
Yes, I did.
Is to the second aspect that you failed the test December 27th, how do you plead?
Guilty.
To the charge you failed the test on December 30, how do you plead?
Guilty.
To the charge you failed the test on December 31, how do you plead?
Guilty, Your Honor.
To the charge you failed the test January 2nd, how do you plead?
Guilty.
Did you fail to test on all of those days?
Yes, sir.
Anybody force you to plead guilty?
No.
All right, I'll accept your plea. And she understands I can revoke the release, forfeit the bond, and set a high bond, right?
That is correct.
So I want to know, Ms. Tessino, your name?
Emily Tessino?
Why?
Your Honor.
If I'm flagging a larceny charge and saying this person needs sobriety court, that's a bit like, I don't know how to explain it. Let me just try to put it. It's a little like looking out when I'm sleeping and seeing a polar bear. That's how, when I start sending people for larceny charges, there's a big red flag here and you've blown it off. Now, I don't suggest sobriety court unless I think somebody needs it. And if I think they need it and they don't make an effort, guess what happens? Take a wild guess. What do you think happens?
Probably some deeper punishment than that.
Which would include,
Probably jail time.
which would not be fun.
No.
Why'd she blow it up? Why I want to know why she blew it off. She just decided I'm larger than life, I'm not coming.
That's not quite the case, Your Honor.
Don't tell me. She was in the hospital.
No, Your
She
Honor.
was running a marathon in Tahiti.
So it's not, Your Honor.
Tell me, I need to know. Why wasn't she here? What was so important?
So she did contact Ms. Tessino before she stopped testing that finances was an issue. She is unemployed. She's been unable to get a job since she's dealing with a stolen identity issue. So until she's able to get her identification straightened out, she can't get employment. She's working on that. So she does not have a job. She is residing with her grandmother who's here today.
Hang on, let's stop. Why did her identity get stolen?
It's not stolen identity. I think that was a miscommunication. My birth certificate and my social security card don't match. So when I went to go renew
How
my
long have you known that?
for at least about a year and a half, 2 years.
And you've been taking a year and a half, 2 years to get that ironed out? Young lady, you proceed at this.
Having a hard time with the social security and the birth certificate not matching. How does that happen? I really, if you have any idea, please let me know in the comments because I can't figure it out. I've been racking my brain trying to figure out what situation you get in where that happens. That's kind of a big deal. You kind of need to get that fixed because usually those things go hand in hand and you have to get one fixed without the other. I guess if you got married or divorced and you changed one and not the other, but I thought they got changed at the same time. I can't remember. That was so long ago.
And you're gonna be living on the streets. You gotta move. You gotta move.
I do understand that.
No, you don't. I mean, here I am looking at a case. What's the drug of choice again?
Alcohol.
Something else too, right? Was it just
Alcohol,
alcohol?
marijuana, yeah.
You live with your grandma,
Yes, sir.
and you live in Trent,
Yes,
and who pays the rent?
she
Who
does.
pays for the food?
She
Who
does.
pays for the utilities?
She completely takes care of me.
You guys have a car?
She does.
And who pays for the insurance?
She does.
The gas?
That would be her.
She have a car payment?
Mhm.
Who pays that?
Not me.
Well, shame on you. I hope your grandma lives another 42 years.
She would definitely deserve it.
But at some point, and this is the way we all want it, I think any of us that are parents here would never want to see a child or a grandchild predeceases. It's not the natural progression. It's not the way the world works. So just God forbid, she looks like she's in wonderful health. Let's say something happened to her. What are you gonna do?
These are conversations that we've been having recently.
Why? But you don't. Recently, you should have been having them with yourself a long time ago. You screwed around on getting something that can help you gain employment. I don't know why we think we have free lunches. I never went to school and had somebody come up to me and say, here's a free lunch. Never had somebody do that. Never did that. I don't remember it ever happening. I don't know why we think we don't have to work. I don't know. I don't get it. I don't understand it. Can't relate to it. You want to work 35 years someplace and then retire? God bless you. I'm all for it. We'll give you a ticker tape parade downtown Trent. But this stuff about not working, having your grandma support you, sitting around drinking. How far is Leisure Lane from here?
Not very far at all, right down the road.
Yeah, right here, then.
Mhm.
400 yards, 600 yards, right? It won't, right? I mean, I could walk there backward right now.
Yeah, probably.
I could jog there even at my old age. You don't bother coming over here and taking care of your obligations? You're going to force me to do something I don't want to do.
Your Honor, if you would allow me to.
Well, I want to hear it because this is not good. I don't want to hear this nonsense that they come in and tell you guys to tell me about how they're, I can't get this straightened out. I know if I asked her 7 questions, I would know that she hasn't done as much as most people would have done in a day to try to straighten that situation out. So, I mean, the stories I hear every single day is fantasy land. Go ahead. I won't interrupt you again. I apologize. My
That's
mistake.
okay, Your Honor. Well, she did realize that, once she stopped testing, that is something that she needed to come in and tell the court. She does acknowledge that she should have called Ms. Tessino when she stopped testing and let her know, hey, I can't afford it. That's why I haven't been testing. She also could have walked over and came into the court. She knew she had a sentencing date today, and so she was just under the assumption that I can take care of it when I go for sentencing. Of course, that was wrong, and I have let her know that anytime she's having a problem with anything that the court has asked her to do, she needs to come in and first try to contact Ms. Tessino and also try to get in front of Your Honor to see if something can be worked out so that she can stay in compliance. I think it was just really ignorance on her part as far as not coming in sooner. She knew she had this court date, so that's why she came in today.
Did she graduate high school?
Yes.
You sent her a notice of the bond violation. What compelled her to say to herself, I'm not going down there. I'm not walking 400 yards. I'm not going to have my grandma drive me. I'm not taking a bicycle. I can't rent a helicopter, and an airplane's too big to drive such a short distance. I'm serious. I don't know why you're rationalizing your conduct here. The world does not owe us a living. Your grandma sure doesn't. Not illegal, mind you. It's not illegal to leech off your mom and grandma and people like that. But it's not right. Did you graduate high school?
Yes.
Why aren't you working? There's all kinds of jobs out there. Why aren't you working? I mean, what do you do during the day? Here's what I always like to think about. Like we had off the other day. Very solemn day in our country's history, as far as I'm concerned. And I thought to myself, what am I going to do today? That's what I thought to myself. What am I going to do? I don't like soap operas. I'm not sitting home and watching nonsensical TV. I don't do gaming. What am I going to do? And you know what? I couldn't think of anything. It's too cold to golf. I don't snow ski. There's no snow around here right now anyway. What do you do? I want you to tell me what you do on a given day.
Mostly I spend my time in my room or in bed.
Doing what? Why are you doing that? Have you ever talked to a therapist?
I have dealt with mental health issues. Yeah, I've been institutionalized a few times for.
So maybe we need to get you some help along those lines. Here's what I'm going to do for you. I'm not going to do anything. I'm really not. I'm not gonna set a high cash bond, make you sit in jail. I'm not gonna do that. Why would I do that? What's the point? What is the point? Here's what I want you to understand. If I'm sounding too harsh, I don't know what to tell you. I don't know any other way than to tell people how I feel. We all have problems. Every single human being has issues to deal with. It might be drugs, it might be alcohol, it might be mental illness, it might be a whole host of things. We might have family members that are troubled, we might have friends that are troubled, we might not have enough money, we might not have job skills. There's all kinds of things that go into this crazy thing we call life. But you gotta try. And the big thing is you got to try to improve yourself and make yourself better. So here's what I'm doing right now. You're not just sitting in your room though, you're drinking, right?
I was up until I completed a rehabilitation program back in October, I believe.
Okay, well, that's good.
But I would just like to also acknowledge that I don't disagree with I don't feel great about the last 2 years of my life at all. I was a very efficient worker. I was living by myself in a relationship. Like I graduated high school, went to college a little bit, and yeah, I don't feel great about the way I've lived the last 2 years.
So then what do we do? We try to take positive steps to rectify it, right? That's what I want you to try to do. I can't have you get into sobriety court if you're not working, and I don't want your grandmother paying for your testing. And we can't pay with our testing yet with our grant because you're not in the program. You would just be in the bond phase.
Okay.
I don't know what to do right now. I'm not going to sentence you. I'm not going to revoke your bond. I'm not going to send you to jail. I'd like to put this off.
I would reconsider her sobriety.
Well, the problem is how she's gonna pay for her testing. If she's that, I don't know how I can expect the grandma to pay. How's she gonna pay for testing 3 times a week at the tune of $16? That's $48.
Traditional probation, it's $26 per test.
You mean on probation or sobriety?
On probation, I'm saying it's $26 sobriety.
No, I know.
I'm just saying money regardless.
The point is she would be testing a lot more. I just think you need to think about this and reevaluate and try to take some positive steps here. That's what I feel like.
I would love to have some more positive things to say the next time I see you instead.
Well, you can, but you're not gonna run the Pentagon tomorrow, and you're not gonna be running Ford Motor Company tomorrow. You gotta take steps. The first step is let's get you a job. I don't care where it is, as long as it's legal. And the second is let's stay off the alcohol. The third is let's do something productive. Even if you found a job today and they told you we're starting on Monday, laying in your bed all day is not productive. We can't feel good about ourselves. You should feel good about the fact that your grandmother thinks enough of yourself where she's trying to help you out here. Right, Grandma? She doesn't have a lot of money. She doesn't have a lot of money. She ought not to be having to spend it on a grandchild.
No, absolutely not. Especially we have a 4-year-old in the family too. He should be getting all the attention that she focuses on me lately.
Is this your child?
No, it's my younger brother.
I see.
I wish you would have said when our next court date was so I could write it down. We really need to follow up on this one. This is one of those ones where I really want to believe that she's sincere and she's going to follow through and she's going to do what she needs to do to get on the right track and make Judge Dad proud, because boy, he wants her to do good and I want her to do good. And I bet some of you want her to do good. Not all of you, because some of you guys are, negative and you're like, fail, fail. It's okay. Allowed to have our own opinions. 50-50 on whether I think she will or not, but it would be nice, to see Judge Dad happy that his lecture and his encouragement paid off. That would be really nice. He deserves that. He puts a lot of effort into those lectures. He needs a little reward for that effort. I am going to try and keep an eye out for it and follow up. If any of you happen to see it and I miss it, please let me know.
All right, so where do I go from here, Ms. Tessino? What I'm going to do is I'm putting this sentencing off. I want you to go get a job today. Can we help her figure out a place to go for treatment where we can get her funded to some extent when she's not on probation? And
her set up to go and a lift to go, and she didn't go.
Why not? Why not? Did you hear what she just said?
Yeah.
Why
Well,
not?
I just honestly, the way, like I said, the assumption that I made was that if I wasn't going to continue the sobriety court,
Let's
then I
quit
wasn't.
talking about what we're gonna do. Let's do something.
Okay, I like that idea.
Well, I know, but if I wasn't gonna go into sobriety court, why start doing this and wasting my time? You've got all kinds of time. I'm putting the sentencing off for 1 month. I'm gonna expect to see some positive steps here. Whether it's mental health treatment, a job, trying to get back into testing so you're staying clean and sober, getting out of your bed.
Okay.
You graduate. You can tell you're a smart lady. I mean, and I gotta tell you, none of us are that smart, but you sound like an intelligent lady to me.
I appreciate that. I do. I was raised very well, so.
Well,
I
you know what?
conditioned
Sometimes we fall off the horse and we got to get back on. Maybe this is your time. Maybe you're going to view this as a positive. I'm going to adjourn this 1 month.
February 15th at 8:30.
February 15th at 8:30. And I'm just going to write down here. Job, mental health treatment, consider sobriety court. You got to get that straightened out. I don't know what's all entailed in your issues with the social security number, but let's get it straightened out the next day.
Okay,
Can't
yeah.
Come on.
Absolutely. Thank you, Your
Good
Honor. I
luck.
appreciate that.
Go down and get your notice. I don't know what else to
Thank
do
you.
right now. I'm not gonna revoke the release. I'm not gonna forfeit the bond. I've taken the plea, I'm accepting the plea to the bond violations. I find by preponderance of the evidence that there was a bond violation. Was there something you wanted to say?
Yeah, I'm sorry, I just want to make sure we're on the same page. So she is no longer on sobriety court bond conditions?
I mean, I'm not gonna order somebody to do it that tells me they don't have any money.
Do you
They
want-
should, I think it's silly. I think she should figure out a way. What I'm hoping is she's gonna get into mental health treatment. She's gonna get a job real quick. And then we can try to enter her into sobriety court again. That's what I'm, but I'm not gonna have her do it and have her just tell me next time I couldn't go, Judge. I told you I had no money. None of us would have any money.
Would the court like for her to reach out to Ms. Tessino if and when she gets a job?
Yeah, I absolutely
Okay.
would. I absolutely would. Okay?
Thank you, Your Honor. I appreciate that.
Good luck. William James Jones, 22B, 142261, 22B, 142230. Yeah.
So these were a couple life lessons from Penny, who is very, very, very sorry for the trouble she caused with the dirt pile in the backyard. And she swears she will never do it again if I just let her take a nap. Hey everyone, happy Friday. We finally made it. Fun times, and thank you all so much for taking the time to watch this. I cannot believe how much love I'm getting. I appreciate you all more than I can say, but on to the stuff you care about. And Judge Stevens is having none of it today.
Are you a bully?
No, not at all, sir.
Yeah, well, that's not the way this reads.
I understand.
It's always the bully who says they're never the problem. Second time you've been arrested for an assault, isn't it? Isn't it?
Sir?
Second time you've been arrested for an assault, isn't it?
Correct. Second time I've been charged with it. I have not been found guilty of.
No, I've never been arrested.
No, I have been arrested before.
Say that again?
I have been arrested before.
Twice, man. Twice. You look at me like
I don't know.
somebody from another planet. Twice, correct?
I've been accused of, yes, sir.
Yeah.
For sure, for sure.
Yeah, well, you're looking at up to 20 years in prison on this. So you need to get a lawyer. Are you getting one?
Yes, sir.
Who is it you've talked to?
I have made some calls. I'm trying to figure out if I'm gonna be able to afford one and have to get it for it.
Why would the taxpayers have to pay for your mess?
Well, I cannot afford one.
Why not? Why aren't you, like everybody else working?
I was working. It was November, December.
Why aren't you working right now?
I was waiting to see what was gonna happen with this.
You're waiting to see what happens for this.
No, I have 2 jobs lined up for me
Then
right
go
now.
hire somebody. I'm gonna give you 4 weeks. Do you understand?
Yeah, I'll get, most definitely, I'll have a job lined up.
Get a resetting. Give that person your resetting when you hire the lawyer.
Okay.
Eric Smith.
Thank you.
This next clip is a little slow. There's a lot of details. Takes a little while. You got to have a little patience, but I promise you it is worth it in the end, because how often is poop the cause of your problems? I mean, for some of us, it's the cause of our problems a lot. If you have poop issues, then, it's a big deal in your life, but generally you don't bring that into court. So how often do you sit and tell a judge it was because of the poop?
You ready?
Yes, sir.
We are on the record this afternoon for the 28th Circuit Court from Missaukee County, calling the case of the people of the state of Michigan versus Wesley Roy Takama. This is file 22-3371 FH. Appearances, please.
David on behalf of the people.
May it please court, Robert Champion appearing on behalf of Mr. Takama, who is seated to my left, Your Honor.
We're here today for a contested hearing on an alleged probation violation. The allegations that are listed in the bench warrant are that the defendant allegedly failed to enroll in a drug testing program as ordered. And when he was released from treatment on or about December 30th, 2022, defendant also failed to appear allegedly for drug testing as ordered on or about January 3rd, 2023. Are we proceeding with the hearing? January 3rd, 2023.
My understanding is that
He actually appeared but refused to provide a sample.
he wasn't able. We will have a hearing on it.
All right, Mr. Denhout, you prepared?
Yes, sir.
The court recognizes joining us today via Zoom from the Wexford Missaukee Community Corrections Program, Miss Dean Stark. Ms. Stark, are you able to see and hear the court?
Yes.
Is this your witness, sir?
It is, sir.
Ms. Stark, please raise your right hand. You swear or affirm the information testimony you're about to provide will be the truth, whole truth, and nothing but the truth.
Yes.
You may lower your hand. Your witness, sir.
Please state your name for the record.
Miss Dean Stark.
And what is your position?
I am the manager of community corrections for Wexford and Missaukee counties.
Thank you. And are you familiar with a matter involving a Wesley Takama?
Yes.
And are you responsible, or is your office responsible for supervision of Mr. Takama?
Yes.
And what are some of the requirements with respect to bond, whether restrictions or requirements?
Mr. Takama was ordered to do random testing as a condition of bond. He went to Sunrise Center Treatment Center, and he was advised that upon release, he was immediately to sign back up with community corrections for random testing. He called on January 3rd and said he was released from treatment back on December 30th of 2022. I asked him why he did not call. He stated our number was disconnected.
And were you having any issues to your knowledge with respect to your phone or electronic equipment there?
No, in fact, I believe we had 11 people show up that day that actually called the number to check to see if their number was, and they all came in.
And what did you do at that time on the 3rd in response to what he was telling you?
We ordered him in immediately to sign back up and be drug tested. And he also advised that he was on his way.
And approximately what time of the day on the 3rd, what was that conversation?
I spoke with Wesley at 9:46 a.m. and advised him he needed to sign back up. He didn't show back up until our office until 4:10 p.m.
And then what happened at that time?
We told him he had to go be drug tested, and he knew that because I had talked to him early about that. He tried 3 times. He said he couldn't go. I stayed until 4:50, asked him for the 4th time if he could go, and he told me he would not be able to go and that he could come another day and test.
And then what happened? Did he leave, or did you release him? What happened at that time?
At 4:50, he told me he could not go, and then I told him I would be forwarding a violation to the court.
Thank you. All right, I don't believe I have any further questions this time.
Mr. Champion.
Thank you. Did Mr. Takama request on the 3rd, did he request a mouth swab?
I am not sure if he requested, but he did not request one for myself. No.
Was a mouth swab available?
Mouth swab is available in our office, but he was advised he was going to be doing a urine sample.
Did he have court that day on the 3rd? Do you know?
I do not know.
As far as the phone call on the 30th, what hours is your office opened on December 30th?
We are open from 6:30 to 8 on weekends and holidays. I believe that was a holiday.
And Mr. Takama, do you know what time he was released from his treatment program?
No. He did state that he had tried to call, excuse me.
He had tried to call, and he was the number that he got off the internet. Is that correct?
I didn't hear you.
Isn't it correct that Mr. Takuma said he tried to call from a number that he retrieved off the internet?
I'm not sure. He just said our number was disconnected.
Are you aware that there's more than one number on the internet for your office and one of those is in fact disconnected?
No, I am not.
Thank you. I have no other questions.
Mr. Denham? No additional questions. All right, thank you. Any other witnesses, Mr. Denham? No. Mr. Champion?
I'd call Mr. Takuma, Your Honor.
Mr. Taka, you may remain where you're seated. Please raise your right hand. Do you swear or affirm the information testimony you're about to provide with the truth, the whole truth, and nothing but the truth? I do, Your Honor. You may lower your hand. Go ahead, sir.
Mr. Takuma, when were you released from your treatment program back in December of last year?
It was around 10 o'clock in the morning.
And that was on the 30th?
It was on Friday, before the commuters, I don't know, probably the 30th, yes.
So it was around 10 a.m., is that correct?
Yep.
What did you do after that?
My parents picked me up, we went out for lunch, and as soon as we got back in the car, I looked up community corrections number on the internet and tried to call them a few different times. And went to a disconnected number.
And what other numbers did you try, if at all, to reach community corrections?
I just tried a few off the internet, and then I tried to get a hold of my lawyer, and I called my lawyer on Tuesday previous to that and told her I was gonna be getting out on Friday if there's anything I needed to do. I'm just trying not to disobey anything.
And you tried getting a hold of, this was on a Friday, is that correct?
Yes.
And this would have been on the holiday, is that correct?
Yeah, holiday weekend.
Did you call the court numbers?
I called the court numbers, yes.
And were there any answers?
No. And the only way I got a hold of community corrections on Tuesday morning is I called my old probation officer, Christy Hardinger, and she put me over to him. I couldn't get through to anybody off the internet number.
Did you have court on the 3rd?
On Tuesday, yep.
And where did you have court?
It was not in this courtroom, but it was in this courthouse, and you were my lawyer that day.
And that was down the hallway.
That was down the hallway, yep.
And that was on the 3rd, is that correct?
Yes.
What time was that court?
My court was supposed to be 10:30, but I waited around until like 11:30, 11:45 before I mentioned it to you that I was supposed to be seen.
And then you were seen by the court, is that correct?
I mean, I didn't have to go up in front of the court, but yeah,
were you able to test on the 3rd?
I went there, and like she said, I went there at the end of the day because she said show up before they close. And I tried to produce a urine sample, which I couldn't because my stomach was turning from eating the rehab food. I requested to be able to sit down to go pee or a mouth swab, which neither was provided. I'm not trying to hide anything. I'm 69 days clean today.
Thank you. I have another question.
Mr. Denham.
So quick summary, because it was confusing and I had to watch it 3 or 4 times to get it. He was supposed to call in on the 30th, which I'm assuming is December 30th, and did not call in because he didn't have the correct number. He didn't have the correct number because it was written on a paper that went to his house, but he wasn't at his house. He was in rehab and another person was in his house and maybe lost the number. So he looked it up online and couldn't find it. And all the numbers he had were disconnected because it's very difficult to find the number to call in. So he did not call in when he was supposed to. Now, the next thing is on the 3rd, he was supposed to show up for his urine test, for his drug test. And when he showed up, he was not able to urinate. And that's pretty much the crux of the issue, was the failure to urinate, caused a bit of an issue.
Thank you, you've heard the testimony from Ms. Stark. Did you have a conversation on the 3rd on or approximately 9:46 a.m.?
With her? Yeah, on the phone. I called her and told her that I had court, but I was trying to check in with her first. And I called my old probation officer's office to get through to her.
And did you say at that time that you were on your way?
No, I said I had court at 10:30. I'm not gonna miss court. She said, go to court and see what they say. And as soon as I got out of court, I called back to her office.
Why is it that it took you until 4:10 that day to arrive? First of all, did you arrive approximately 4:10? Is that correct?
Yes, she said just show before they close at 4:30. I went right back to work. I already missed 2 hours of work and I'm trying to catch up on bills.
Okay, so you went to work in between times?
Yes, sir.
And is it true that she asked you 3 or 4 times to provide a sample?
Yes, and I was trying, but like I said, without sitting down, it wasn't gonna happen.
You were released from the 30th, is that correct, from the treatment center?
Friday, I think, yeah, the 30th.
You had said that you had some difficulty contacting. Had you called community corrections prior to that?
No, but I talked to my lawyer on Tuesday previous to me getting out.
So it's your testimony today that nobody provided you with a number to community corrections?
Not other than the internet, no. I mean, when I checked in December 5th, I got a piece of paper, but with somebody living at my house while I was at rehab, I don't know where that piece of paper went, which was probably the right number. I don't know, but.
I have no further questions.
All right, Mr. Champion, anything further?
You didn't have any of the paperwork with you at your treatment, and that was in Traverse City, is that correct?
No, it was in Alpena.
Alpena. Who picked you up?
My mom and dad.
I have another question.
Thank you. Anything further? Thank you. Any other witnesses? Set in the back.
If I could have just a moment.
Yes, you may.
Can I call my client's father to stare?
Sure, you may come approach. You may have a seat here at the witness stand. Before you take a seat, I'll swear you in. Come on up. All right, please raise your right hand. Sir, do you swear affirm the information testimony about the truthful, truth, nothing but truth? I do. Have a seat, sir. Your witness, Mr. Champion.
Sir, could you please state your first and last name and spell it for the record?
David Tacoma, Davidtacoma.
David, how are you related to Wesley?
I'm his father.
Direct your attention back to December 30th of 2022, last year. Did you have contact with your son?
Yes, we did.
Where'd you have that and when?
We went to Alpena to pick him up from the treatment.
What time was that, if you recall?
I believe it was 10:30, the release time.
What did you do after that?
He had told one individual he'd get him a pack of cigarettes. We picked that up and brought it back to the facility. Then we went to Burger King and had a bite to eat, and then we drove home.
During that period of time, was your son ever on the phone?
It was definitely on the phone.
How, you say definitely, how do you know that?
Because we were in the car with him, and the first 2 numbers he called went to disconnect.
How do you know that?
That's what he said, and there was no speaking on his end, just listening, and then disconnect.
Did he make any other phone calls that you're aware of?
I believe he called the probate court, and I believe he called James, who sometimes employs him and is a friend. And he tried the office for your office, whatever the title of your office is.
Okay. Defender's office?
Defender's office, yes.
No answer was that. That was a Friday, a holiday, and all the
Yes, it
offices were closed. Is that correct?
And it would have been after lunch, probably by the time he was making the phone calls.
Thank you. I have no other questions.
Mr. Denon?
Were you in the car when these calls were occurring? or-
Yes.
And you heard those yourself? It wasn't something that was relayed back?
While we were driving. The first little ways after Alpena, there was not enough service. So we probably were 30 minutes out of Alpena before he had enough service to get to the internet and make class.
I have no further questions.
Thank you. Mr. Champion?
Nothing further.
Thank you. Sir, you may return to your seat. Anything further, Mr. Champion?
No, Your Honor.
Argument, Mr. Denon. Thank you, Your Honor. Your Honor, based on the testimony, I think it is clear that the defendant did not report when he was released. I know there's been some testimony that he lost the number, but it is believed that the number was given to him. There was a few days that went by. I think importantly, though, on the 3rd, the agent, Ms. Stark, told him to immediately test. It took some time. He said he went to work in the interim, but it did take a significant period of time from, I believe, the 9:46 until 4:10 when he arrived. He was asked to test 3 or 4 times. He indicated that he was not able to do so. So I believe that there is a violation here in terms of not immediately reporting and then not testing immediately when requested. I also think that it does need to be looked at in context. This is not the first issue that we've had with respect to bond. I know it was in the lower court, but there was a mistest, there was a violation, he was remanded previously. So this is not the first time. I know that today we're looking at this incident, but I do believe that there has been a violation. How we handle it, obviously, is for the court to decide, but I would respectfully request that the court find that there has been a violation.
Mr. Champion.
Your Honor, we've heard the testimony. My client did attempt to contact community service when he was released. Excuse me, community service when he was released. I would note that Friday was a holiday situation, and our office was closed and the courts were closed at that point in time. On the 3rd, which was a Tuesday, was my client's original court date. He did show up. I wasn't aware that he was going to be here until he made note to me in the hallway that he had showed up for this particular case, and I advised him to leave at that particular point in time once I realized what had occurred. Did attempt to test on the 3rd, but was unable to. I don't believe there was a purposeful violation there. He's attempted to abide by.
I don't understand why. What does sitting down have to do with it? I'll buy the first one. I'm not gonna find him violating for the missed phone call, but I don't understand how he could, yeah. I don't understand how you could.
Like, because my stomach's so turned from all the food that he had at rehab, that if I didn't take a poop, I wouldn't be able to pee, because if I peed, I would have pooped. If that makes sense. Like, I requested that or a mouth swab. I don't understand why they have mouth swabs if they won't use them.
Well, I don't understand why people are told to pee and don't pee. So the court finds the defendant not in violation of his bond for the phone call. I understand that it was a holiday, and the court. Hold on, Ms. Stark, did Mr. Takama describe to you the impact that he would have to defecate before he could pee?
I was not on the first 3 times he tested, but we also always let an offender sit down if they need to, or use the other bathroom in security if they need to before.
Okay. Now, when you have mouth swabs, do you, what's the difference between using a mouth swab and using a urine?
A mouth swab typically picks up use within about 10 to 12 hours. So we will go back and forth whether we use a urine or a mouth swab at that time. He was advised he was going to take a urine test. He also didn't show up Saturday, Sunday, or Monday when our office was open for testing. He had that sheet with our number on it and our hours on it.
You mean that Saturday, Sunday, or Monday over New Year's Eve weekend?
Correct. So he would have been home to get his sheet that had our correct number and the times. He could have just shown up.
I understand there's some debate about whether he had the form. I'm not going to fine him for violating the bond for the phone call over the weekend. I do find that, and here's one problem, here's one challenge. There's a reason why the court does not allow, through the community corrections office, somebody to dictate what kind of test they're going to take, because the testing detects it differently. I'm quite confident that if the defense knows that often people who might fail a mouth swab might ask for a urine test because of its different results. I find the defendant in violation of his bond by not testing when told to test. It's pretty easy. He was able to stand there for a half hour, 40 minutes, but he didn't provide a sample. And then he tried to dictate what kind of sample he was going to provide. So I find him in violation of his bond there. Now, the next question, and really the most important question today, is what does the court do with the defendant in the meantime? Is there any further argument, Mr. Denhoughton? I think you kind of encapsulated it.
Well, essentially, Your Honor, it was the people's position previously. He was remanded, he tested positive in the lower court. He missed at least one test in the lower court. I know the court was inclined to give the defendant, excuse me, a second chance at arraignment, reinstated the bond, allowed him to be out and bound again. But the people would respectfully request that, given this history, because I do think that this violation has to be taken in context, we would respectfully request that he be held at this time.
How often is he testing right now? Is it just randoms?
It's random, correct, Your Honor.
Okay, thank you, Mr. Denhoff, Mr. Champion.
Yeah, so the court's aware that he did give a urine test on the 9th. It was negative.
Okay. I appreciate that.
He is working. Like I said, he successfully completed the treatment program.
Where's he working?
At the lumber
Lake
company.
City Lumberyard.
Is that, I know it sounds stupid. Is that here in Lake
It's
City?
about a block away. If I'd known I had a warrant, I would have came in, but
It's all right. I understand. All right, thank you.
And he was here on the 3rd in the court.
I recall.
So I would ask the court to reinstate his bond. He'll do whatever the courts believes appropriate. My client is clean. I'm very proud of that fact. He has strong support from his family also.
All right, thank you. The court is going to release the defendant back on his bond, but will add the term of condition that he will test randomly at least twice a week. All right. That's okay. I'm just gonna do it twice a week because it costs you money to test. And I don't want you to not pay for the tests. So we're gonna have you randomly test twice a week. So quite honestly, it's a bit of a gamble. You better not miss any tests. And if they tell you to pee, pee. Run your hand underneath some water. It's really simple. My wife is a doctor and tells me all the time what she tells her patients, put your hand underneath some warm water while you'll all of a sudden have to pee, guarantee it. All right, thank you very much. We are adjourned.
Thank you, Your Honor.
Might need to call a doctor to explain this one to me because I need a little more information to completely understand the functionings of the male body. I mean, really, I don't because I really don't care, but I understand for women, you know, when you're sitting down, there's pressure, everything's going down with gravity. But for a man, you're standing up and, you know, aren't those muscles kind of separated when one goes one way, one goes another? It's not like they're all intertwined up in there like in a woman's body. I need a man to let me know like how this works. Is this a normal thing or is this just, you know, a bullshit excuse from the rehab food, you know, tearing up his stomach and that's all he could do. Just totally ruined it all and it was worth going back to court over. We should start keeping a list of the excuses that we hear. Bet there'd be some good ones. So I have one last clip for you, for those of you that like the longer videos, for those of you who don't and are headed out right now. Thanks for sticking around this long. This one is from Judge Conlon's courtroom and the beautiful Jessica Blanche. Still can't get over how tall she is. She is so freaking tall. They need like a taller microphone for her just to like bend in half to reach the microphone. Holy crap. She's awesome. I thought this one was a little interesting because it's kind of a debate over a restraining order that has to do with neighbors and Judge Conlon trying to figure out what to do and how to handle this guy to keep him away from his neighbor but still allow him in his house. So enjoy.
Any comment on the recommended conditions, Ms. Blanche?
No, Your Honor, they're in line with their sentencing agreement. So I ask you to follow the sentence.
Okay. And then, Mr. Rodriguez, do you have any comment on the proposed conditions as well as any elocution on behalf of your client?
Your Honor, simply, we obviously, we want to get this behind us, so I'm going to be very brief here. There's a condition number 9 that requires Mr. Loughran to stay 500 feet away from the residence of the victim. They are next door neighbors, and we've been under a no contact order for 1.5 years without any issues. I like that condition to reflect the impossibility that, you know, they're neighbors and they live there. They have a related civil suit that looks like it's going to resolve, and I think we're going to try to get this behind us, but that's the only thing on that. The other issue is we're not sure how the attorney fees charged is appropriate in this case, and that's the only thing we'd ask the court to consider. I also do want to say that that through this issue had nothing to do with alcohol or drugs. We understand that these are standard conditions. I do want to note to the court that Mr. Lofgren does get tested twice a year by his doctors related to his chronic back issues, and we'd be happy to provide any drug testing report that comes out on a biannual basis.
Okay. Mr. Lofgren, anything you want to say before I impose sentence?
Thank you for asking those.
Okay. Let me tell you what my concern is, and this is kind of dating back to my prior iteration as judge when I was the PPO judge, and what always causes my concern to rise are neighbor disputes. I mean, all personal protection order matters are serious, but people tend to dismiss those of like personal relationships like neighbor disputes is not a big deal. And I always felt that they were amongst the most dangerous situations. So I'm not your civil judge. I'm not involved in that matter, but I always have concern about people living in proximity to one another with this kind of tension. So that said, I'm going to put on the record kind of the reason I adjourned the sentencing is that the request was essentially that, and the photographs were pictures purportedly of your wife, don't know if that's who it is, kind of on the neighbor's property doing stuff. And a request basically that if she showed up on the property, that I should hold you accountable for that. I know your lawyer has talked to you about that. I mean, I can't really hold you accountable for the actions of a third party, but I am going to say that, Condition 9 talks about that 500 feet. It talks about not having any communication with Sherry Lee Allen. And what my handwritten notes on this are, sir, I don't know what the nature of your civil dispute is, but you should really caution your wife to just also stay away from the neighbors, because the last thing you need is someone calling probation saying, this guy and his wife, this guy's wife is doing this. He's telling his wife to do this. I don't know what that ends up being for you, but you've got kind of a deal here sewn up, deferred sentence and all that. And any of this type of stuff that could be like pushing the envelope is a difficult situation, because so I am giving you my advice. You've got a good lawyer. I'm giving you my advice that any communication between you and your wife and any of, I don't know if Sherry Lee Allen has a family or not, but any communication probably needs to cease and desist for the foreseeable future, because I'm telling you, I don't want to be in a situation where you're back here on an alleged violation and we're back to potentially trying a case because of that. So I just want you to be warned that when I looked at those photos and looked at that email, those were my concerns, and I'm just sharing them with you. Okay?
Your Honor, I want to say this in front of my client. We hear your advice, and there's a lot of responses to those emails that we can sit here.
Right.
Time. We don't want to do that.
But a lot of those responses wouldn't involve your client going to jail. So that's where I am uniquely giving you advice, sir, that I don't care what your responses are. I really don't. But in my world, if I find you violated your probation, you're going to go to jail for a period of time. And I'm just trying to be transparent that I don't want that to happen. So I can't technically hold you accountable for what's alleged that your wife is doing. Mr. Rodriguez knows that. But the fact of the matter is, if there's enough allegations that somehow you're acting, she's acting at your direction or something like that, probation could violate you for that. And I don't want this to be a big surprise, because I'm telling you the civil suit, the potential neighbor dispute, that's risky business. So if you're hearing anything I'm saying, I'm telling you to stay away from your neighbors and have your wife stay away from your neighbors too. And if there's legitimate dispute in the civil suit, you can work it out in there. But the worry that I have is that you're back here and then we're dealing with that. So that's my worry for you. Okay. As to the added count 2 disorderly person, there are no sentencing guideline recommendations. It is the sentence of the court that you serve 1 year probation subject to the following special conditions. Number 1, you must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site unless the field agent has first given you written permission from your employment or for your employment at a specific location. Numbers 2 and 3, you must comply with the requirements of alcohol and drug testing directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. You must present proper identification at the time of testing. Number 4, you must pay the cost of your substance abuse testing. Number 5, you must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. I will note for the record, I'm not changing the condition, but I'm aware, and the prosecutor is aware of your medical marijuana prescription, that I'm not challenging that or, whatever, but just make sure that that's current in anything going forward. Number 6, you must use prescription drugs only as prescribed for you by your licensed physician. Number 7, you must take medication as prescribed by a licensed physician. Number 8, you must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. Number 9, you must not have verbal, written, electronic, or physical contact with Sherry Lee Allen, either directly or through another person. And I'm just going to say you must not be within 500 feet of their residence, school, or place of employment. I don't know where your residence is in relation and how many feet. Right. I'm not going to exempt that. So tell me, Mr. Rodriguez, how I can put a condition in here that makes sense.
Well, he's been on a no contact order for a year and a half. It didn't have anything about 500, but we just don't want a technical violation. We're going to stay away from.
I think if we just say no trespassing on their residential property and then 500 feet for the
Everything
schooling
else.
and everything else, I think that would work, Judge.
All right. So then you must not be on Sherry Lee Allen's residential property within those boundaries, and you must not be within 500 feet of her school or place of employment. Okay. This is where I would note kind of my caution about your wife and what's been alleged, but I've already explained that to you. Number 10, you must pay $50 state costs as ordered by the court. Number 11, you must pay a crime victim assessment in the amount of $75 as ordered by the court. Number 12, pursuant to MCL 791.225A, as amended by Public Act 164 of 2019, you must pay a supervision fee of $30 per month for each month of regular supervision or $60 per month for each month of electronic monitoring supervision. You'll not be required to pay a supervision fee to Michigan when you're being supervised in another state under the provisions of the Interstate Probation and Parole Compact pursuant to MCL 798.103. Number 13, you must pay court costs of $1,611 as ordered by the court. I'm striking number 14, Mr. Rodriguez, you're correct. He does not need to pay attorney fees. Number 15, you must not use.
Court-appointed attorney prior to Mr. Rodriguez, so that may be why.
It was Mr. Montoy.
I'm sorry.
No, it was Mr. Montoy before that.
That's right. Sorry.
That's okay. Number 15, you must not use any object as a weapon. You must not own, use, or have under your control or area of control a weapon of any type or any imitation of a weapon. You must not be in the company of anyone you know to possess these items. You must not own or possess a weapon of any type or any imitation thereof, any ammunition or any firearm components. I'm actually going to add a number 16 that doesn't affect you in any way, but what I'm saying is that you're to serve 90 days in the Washington County Jail with credit for 2 days. That's suspended upon your successful completion of probation, which means that if there is a violation finding after a hearing, you're going to serve that, but I'm just going to clarify that on the record today. I'm going to also modify, just because of my earlier comments to you, this is not going to affect you either necessarily, but number 8 says arrest or police contact, loss of employment, or change of residence to the field agent. I'm also going to include in that a grant of a personal protection order. It doesn't mean you violated, it just means that I want probation to know that if that's the case. So I'm going to modify that condition.
There is one.
Correct. Correct. I mean, all I'm saying is that just like police contact or anything else, he has to notify the probation agent of that. I'm not making any findings of whether it's granted or not or whatever, but if he has a PPO granted against him, he's got to notify probation so that they're aware of that. Okay. All right, sir. Well, this is a deferred sentence, so actually, I don't think you get half. I don't think you can serve half and be released. So I think we are going to.
Your Honor, just to foreshadow though, we intend to comply with all this and move.
Right.
early termination at some point.
I'm not sure if you're eligible for early termination because it's a deferred sentence.
Technically, it's the prosecutor's deferral. I mean, he can talk to me after 6 months and we can.
Okay.
I told him I have no problem. He's doing well. Everything's okay.
Okay. All right, so it's possible, sir, that you could be released from probation after you've served half of the probation term and complete the required programming. That may or may not require a hearing. You or your attorney or the probation department can raise that with the court. You will be provided an appellate rights form. If you don't like what happened today, Mr. Rodriguez can hand you that form. It's on the podium right there. If you wanted a court-appointed attorney, you have to make that request within 42 days in writing. Any questions, Mr. Lofgren? All right.
I have a clarification, just because this is so important. The condition on the 500, it's no trespassing onto their property.
Correct.
And the reason this is an issue is there's an easement of a shared driveway. And so the shared driveway is not technically on their property, but
So literally, I guess you have to explain this to me. So I'm not the civil judge, thank goodness. So in this case, you're saying that the access to their residence is accessible by a shared driveway, correct?
Yes, and that is the only access.
And that sounds in the civil case, like whether it's an easement or who has access or rights to it. So I am saying that he may not trespass upon the property of the victim, Ms. Allen, I think her name is. Obviously, I am not going to say he may not access his driveway. So for the purposes of my being here, as long as he is simply using the driveway, but I'm only operating on my 6 years doing PPOs for this court, is that it wasn't unusual for a neighbor to walk across to the edge of the driveway, start screaming at the neighbors. I'm not putting that on you, sir, but I saw it a lot. And so that would be a violation to me. But using the driveway to get to his house, not a violation. Agent Miller and I are literally on the same page here. She's going to know that. So I don't want to do anything that violates your probation without you knowing you're violating. So that's not my intent. Okay.
All right. I think it's clear. Thank you.
Hold on. So Agent Miller, is he going to report today or is he going to report to his field agent? It's about 4 o'clock. Make that appointment. All right, that concludes the hearing. Thank you.
Thank you.
Number 1 on the supplemental, People versus Mario Roland Taylor, 21248 FH.
Justin Lamb, preparing on behalf of people.
Portia Feaster, Assistant Public Defender on behalf of Mr. Roland Taylor. Please state your name for the record, sir.
Mario Roland Taylor.
Mr. Taylor, can you hear us? Mr. Roland Taylor, can you hear us?
Yes, I can.
All right. I know you've had a chance to speak with Mr. Feaster or someone from his office today, but do you understand why you're incarcerated right now?
I haven't spoken to anybody today.
What's that?
I haven't spoken to anybody today.
Did you speak with someone from the public defender's office?
I haven't spoken to nobody today.
How about yesterday?
None.
Would you mind reading his violation, Your Honor?
I don't mind. All right, sir, you were arrested because of a warrant that was signed by the court on March 13th or March 17th of 2022. It's alleged in that warrant that contrary to condition number 1, that you not violate a criminal law, according to Huron Township Police case report, the defendant, you are alleged to have been carrying a concealed weapon and driving without a license on or about March 15th, 2022, after the police conducted a traffic stop. Charges are currently being requested and submitted to the prosecutor's office for review. Count 2, contrary to condition number 32, you must not own, use, or have under your control or area of control a weapon of any type or any imitation of a weapon. According to Huron Township Police case report, same one, the defendant is alleged to have been in possession of a firearm on or about March 15th, 2022, after police conducted a traffic stop. CCW, carrying concealed weapon charges, are currently being requested and submitted to the prosecutor's office for review. I don't know whatever happened to that or those charges, but I'm just telling you, those are the two alleged violations of your probation. You need to know from me that if you were found guilty of those violations after a hearing, you could be sentenced to the maximum of the underlying charge, which is 5 years incarceration. So that's what's on the table. I'm not saying you would be or you will be, and you haven't had a hearing and you can plead to whatever. I mean, there are a lot of options between now and going forward, but those are the maximum penalties. Do you understand all of that?
Yes, sir.
All right. And since you haven't had a chance to talk to the PD's intern, do you want me to appoint the public defender to represent you in this matter?
As retained counsel, Judge, and Attorney Milk.
Do you have Mr. Molkoff still, or do you need an attorney right now?
I don't have Mr. Milkoff at the moment.
I think that was in the former case. All right, so I will appoint the Washington County Public Defender to represent you in this matter until further order of the court.
Thank you, Judge.
So I guess what I'm going to do for today, because we're sitting here, is that I'm going to enter a not guilty plea. I'm going to say that you stand mute to the charge. You're not going to plead guilty today, and that will set the matter before Judge O'Brien, which is tomorrow. So this is her case. So, so Judge O'Brien has a VOP hearing scheduled tomorrow, which is January 12th at 1:30 p.m.
Your Honor,
Okay.
I missed one day of work last night. I haven't had a chance to call in, and I'm in the process of getting hired in this week to my job. I work 11 at night to 7 in the morning, and I can't afford to lose my job. Is there a way that I can get a PR today so I can make it to work or something?
Your Honor, I think what Mr. Roland Taylor is asking is that Your Honor to consider allowing him to have a bond to go to work tonight, or I guess it'll be tomorrow morning, but he would have to be in court tomorrow afternoon at 1:30 in front of Judge O'Brien. And so if the court does release him, he needs to understand that he does have to be back tomorrow at 1:30. So I don't know if he would have a chance to work or not.
That's not a problem with me making it work. I'll show up to court. I never miss court dates. I never had a problem making it to court.
I appreciate that. And if this were 2 weeks from now, I would be certainly willing to consider it. But since the hearing is tomorrow, I'm going to order your remand until Judge O'Brien can take a look at it. It's her case, so you can make that same argument tomorrow. Thank you.
Thank you, Judge.
Just a quick question. Is it because I'm being held because I haven't talked to the court-appointed attorney? Is that why I'm being held?
No, I arraigned you. That's why I read the arraignment. I read the charges to you because you hadn't gone over those with your lawyer yet. So you're being held because Judge O'Brien's hearing is tomorrow. This was just an arraignment. And so all I do is arraign you and tell you what you're being charged with. And I would consider a bond request or your request to be released. And as I just said, if Judge O'Brien couldn't see you for 2 weeks, I would probably release you on bond. But since she can see you tomorrow at 1:30, I'm going to order your remand until then. It's her case, so you won't see me again. Okay?
Okay.
All right.
Thank you, Judge.
Numbers 19 and 20, People versus Ibrahim, 21103 FH, 21104 FH.
Just the Blanche Karen, have people.
And that is all I got for you today, but thank you again for everything. I appreciate you, and I will see you again soon. While I'm working on some other stuff, I also have this one that's been sitting there for a while that I kind of wasn't sure what to do with it, but I find it kind of interesting. It's some baby daddy drama, child support, paying for daycare issue, and the agreement that the court upholds is the interesting part of it. I'll follow up with you when you're done watching it.
This matter is before the court on the plaintiff's motion to show cause relating to the payment of health insurance and child care payments in this matter. Ms. Ford, you can proceed.
So about 3.5 years ago, there was a custody order signed by you stating that Evan had to have health insurance on Halen, as well as he stated in the agreement that he was responsible for all childcare related payments. He has not been making his payments for childcare, nor does he have health insurance on her. She has been kicked out of her childcare program twice. And then I've had to pick up the bill, and he said he is not paying because he does not need it, so he's not paying for it. He now pays half and makes me pay half. And then during the summer, he told me I had to find my own way.
Okay. Anything else?
Nope, that's about it, I think.
Okay. You did state in your motion you had that there was a childcare bill to Learning Zone of $120.50. You never stated the amount owing to the Sonoma.
I did
Smiles.
attach
What?
I attached the receipts of all the payments I've had to make so far for Sonoma Smiles.
Okay, well, sometimes those attachments don't make them to me. They end up in the clerk's office, but I don't get them. So I don't know how much you're claiming to Sonoma as far as the amount that's owed to you.
It's right around $1,300 right now.
Total with both of those, or just to Sonoma?
Just to Sonoma is $1,300. The one with Learning Zone, I did not pay. It's still under him, waiting for him to pay it.
Okay, so you haven't paid then. Okay, sir, why have you not paid these expenses?
Well, with the Learning Zone one, honestly, I just kind of forgot about that one because she only worked there for a very short amount of time, and the bill was not in my name, it was in her name. So after she left working there, it just kind of fell through the cracks. As far as the Harper Creek Sonoma Smiles goes, it started a while back during the summer where she was not taking her into Smiles because she was working at home at another different job. I didn't need the daycare. I know it says that I was the one that was supposed to be paying for the daycare. We've adjusted our court order before because we both have agreed on things as far as like switching time when we get the child and whatnot to make everything work accordingly for both of us. So I have documentation that I got from the school because she told me she needed the child care, which that's fine. But she was not taking her in at all during the child care times for multiple days. She would just drop her off. She wasn't utilizing the Smile. So I said, well, if you're not going to utilize it, I don't need it. Well, I'm going to probably have to go back to court and get this changed because I'm paying the child support. I'm paying for the daycare stuff. I just can't really afford to do all of it. And I have in-text form that I printed off multiple things, and I could submit this. I don't know how you guys want to do it, but where she agreed to pay for half, and I agreed to pay for half to help her out because she needed the daycare. I didn't need the daycare. So I was trying to avoid going back to court to switch the custody order because we came up with an agreement together, which we have done in the past on different things.
Okay, but let me explain how this works, sir. Is what happens if you vary from the orders are in stone, okay? The court will enforce those orders. If you come up with an alternate agreement, you're going to have to put that in a form of an order that the court will sign, or you have to put it on the record. Like if we're here today and you had an agreement, we could put it on the record. You could basically express your agreement and affirmation to the agreement, and then that would be binding. But it either has to be in a written order form or it has to be put on the record, okay?
Okay.
So that's
with her, I'm sorry.
That's where you're at. And if in fact you don't do that, then you don't have an agreement. There's no order in place. and the court can only enforce its orders. I can't enforce agreements that you have or discussions that you have or anything of that nature. Again, I can only enforce, if you have something, let's say you were to have an agreement and you put it in a written form, say, we agree A, B, and C, and you both sign it, you date it, court can enforce that agreement, but I can't do it if you talk on the phone, then she sends you a text, then whatever else might happen. Okay, there's a process whereby those orders have to be, again, addressed, or otherwise the court won't enforce it.
So the text form where we were talking about paying for half and her agreeing to pay for half because she needed the childcare that wouldn't.
Well,
It
I
doesn't
don't
mean anything?
know if she agreed to that. You're saying she agreed to it. I don't
Well,
know if she may have said.
I've got it all printed off. I printed everything off because I keep everything. So I didn't know if we were supposed to submit it or I brought it with me. So.
Okay. Ma'am, he's got some text apparently in writing whereby you agreed to divide that cost. Is that accurate?
So I did agree only because he said he was not paying for it. He said, I'll pay half and that's it, or I'm not paying anything. So at that point, I have no choice but to have the little bit of help that he's supposed to do because I had to have childcare. There were days she didn't go.
Okay, you do have choice. You could have come in like you did today and filed a motion and the court could have enforced it. But you can't say, oh, I agreed to this and I put something in place and now I don't agree to that, or I don't like that agreement, or whatever it might be. If you agreed to it, you agreed to it, and you have it in the text in writing, so it would be binding upon you.
He got her kicked out, so I couldn't afford to pay the full price. So that's why I had to. It was either get some help or get no help. And so I've been struggling to pay on my half because it's not in my budget of my bills. But that was the only choice I had at the time because he was saying he was not paying. Yes, I could have brought it to court and that was the plan. But unfortunately, he already got her kicked out and I have no care, no options for care. I don't have family in the area. I don't have anybody who can help me with her.
Okay.
Sir?
And sir, how about the insurance coverage? Do you have that yet?
I do not. I did not see that in my custody order. My work does not offer insurance. It's a privately owned company. It's not a big corporate company. There was talk of adding insurance recently. So I'm kind of seeing what's going to go on there. So I can do like a family package with my son as well. As far as her saying that Halen got kicked out of Sonoma Smiles, I did talk to the principal and the I can't remember her name. Anyway, and I got a letter from them right here from Sonoma Smiles saying she has never been released or kicked out from childcare at Sonoma Smiles. There's been a couple of late payments back in the day.
Okay, I don't care about that. I don't care about that. I care about whether it's being paid. I don't care if she was kicked out or anything of that nature. So, well, what happens in this particular matter, the order does provide that you are to acquire a health insurance coverage. And typically, I don't have it up in front of me, typically it'll say you have to do it if it's provided to you as a benefit of employment or as a low cost option. And you're saying it's not provided to you at all. Is that correct?
I do not get insurance at work now. And I knew she was on Medicaid through her mother, which I don't know exactly how Medicaid works, but I do know when the whole COVID thing happened, I went to get my daughter tested because she had a lot of the symptoms. And I had issues with using the Medicaid because I don't have any of the information. I'm not like a person on there that can utilize it. I never got that information from her.
There's ways you can do that. You just have to acquire that information from plaintiff. As it relates to the child care expenses, pursuant to that order of July 19, 2019, there was a consent order. It did provide that the defendant would pay those expenses. So the court will order that you are obligated to pay the $120.50 to the learning zone to take care of that.
Okay.
The parties since that time have come into an agreement whereby they would split the childcare cost to the other entity. The plaintiff has stated her expense is approximately $1,300. There's been no dispute or opposition to that, so the court will order Mr. Hoppy that you do owe the sum of $650 to the plaintiff. The court will order that you would pay that to her within 45 days of today's date. And you're failing to do so, the court would implement a process whereby she would be able to, and say, if you haven't paid it within that 45 days, the court will grant to the plaintiff a writ of garnishment, attachment, and/or execution so that she can collect that particular money. So the court will order as well, Mr. Hoppy, that you would get something from your employer stating that there is no health care insurance available to you through work, and that you would provide that, that you would get something from the employer within 10 days of today's date, and provide that to the plaintiff within 7 days of your receipt of whatever it is you get from the employer saying that it is not available.
So within
Okay.
10 days, get information from my work to Caitlin saying I don't have option for insurance.
Correct.
Okay.
And that will be the order of the court today. Ms. Ford, you're going to have to put all of that in a order, okay? So what the court's ruled, you have to put that in an order, submit it to the court under 7-day notice of entry, and that will become the order of the court, which will be binding and enforceable after this time. And at this point, what, ma'am?
I have a question. So going forward now, is he to pay all of the childcare related expenses then?
No, because you have an agreement. If you want to change that agreement, you have to file a motion setting forth the basis for the court to modify that agreement. And then the court will look at it at that particular time. But at this point, pursuant to your agreement, you're dividing that cost.
Okay.
Okay? And you can include that in the order as well, so that we have everything's wrapped up and everything's taken care of, so we don't come in the future and have competing orders or anything of that nature.
Okay.
Okay. Okay. Thank you both. The court will end this matter at 10:47 a.m. You're free to go. Have a good day.
You too. Thank you.
Okay. That was interesting. So she texted him and said, okay, whatever, to get him to pay half of it, which I completely understand. Sometimes it's difficult and you got to just, cut your losses, take what you can get until you can get the court thing going. I guess I understand that. But I guess she probably should have not accepted anything and gone straight to court. I think the question is how long would it take to get a court date, because you do need childcare in the meantime. But it was interesting that they enforced that casual text message conversation as a contract, that not necessarily a contract, but as a agreement. And now it is part of their parenting plan agreement in their support order. So she's going to have to go back to court again and get it modified to get it back where it was originally, because she did that temporary agreement. So be very careful what you agree to in text messages, because it could be used against you in court. I've heard someone say before that they write every text message like it would be used against them in court. And it's not bad advice, because if you think about it, they technically could be preserved forever. And those are your words and can always be used against you. And down the road, it could be used out of context. I have one more for you real quick. It is a dad and a daughter, some form of domestic violence several years ago, and it caught up with him right before the holidays.
This is case 22-0171. People of the State of Michigan versus Michael Reed. Appearances for the record.
Bob Marshall, on behalf of the people, Your Honor.
May it please the court, Your Honor, and Happy New Year. Deborah Martinez on behalf of Michael Reed, who is present on Zoom.
Okay. And what am I honored to have the presence of the attorneys for today?
Your Honor, I reached out last week looking to file a motion to amend bond for Mr. Reed as it relates to contact with the complaining witness in this case. I would like the court to consider an amendment to his bond to allow peaceful contact with his daughter, Tiffany Reed, who is an adult. I filed a written motion, which I don't know if the court was provided, but I did send it earlier this week and today with the attachment. Mr. Reed has no prior criminal history. This incident occurred a year ago tomorrow. And Mr. Reed was not aware he had a warrant out for his arrest until right before Christmas when he contacted our office, kind of as a fluke because he applied for a job and his criminal history shockingly triggered which is why he wasn't eligible for that job. He immediately contacted our office. We brought him in, got arraigned. Magistrate Paul was filling in for Magistrate Godsey. And as is expected in these kind of cases, a no contact order was put into place. However, in the year since this incident has occurred, he and his daughter, Tiffany, who's a student at Central Michigan University, have made amends. Mr. Reed immediately put himself in counseling and therapy, very distressed at himself for the incident that occurred with his daughter. Has been in therapy for the past year, has also attended a 10-week anger management program. And is my understanding that his daughter Tiffany does want contact with him, that they have been together. They've celebrated Thanksgiving together. They talk on Zoom, they talk on the phone. She visits her home, and they would like that time. Okay, I'm done. Sorry.
No, I just, if he has a no contact order with her, he's not supposed to have any contact, and having contact is a bond violation. So I don't know that you want to actually say that he had contact with her, even if it was in a family setting, that could be a bond violation.
No, he was not on bond at that time, Your Honor.
Okay.
He was only arraigned right before Christmas. He has not had contact with her. They made alternate arrangements for Christmas, sadly, so that he did honor the bond, so that he was not with his daughter over Christmas. But he has not engaged in any conduct with her since that time, which is why we're here requesting that change.
Okay. Mr. Marshall?
Your Honor, I spoke with the victim this morning for probably a half hour. She was very adamant that she wanted this lifted, basically kind of the same story that Miss Martinez had stated. I had asked if she wanted to be present today to make a statement for the hearing, and unfortunately, due to it being last minute, she could not get off work. So I let her know that I would inform the court of her thoughts on removing that.
Okay. So what do you have in mind for this peaceable contact, Ms. Martinez?
So what I would have in mind is no assaultive or threatening conduct, no physical contact, rather, no firearms in the home, which is already a condition of bond, and there are none in the home. Communication allowable via Zoom and for family gatherings. And if the court felt more comfortable with Tiffany's mom and his wife present for that, we would be amenable to that as well.
So I think that probably, because I don't actually have her here with me, kind of reminds me of situations where we have domestic situations where there is an intimate partner, except this is a father-daughter. Not sure why this got out of hand, allegedly, but these are just allegations. And so my charge as a judge is to try and keep everything safe, keep people safe, while we try to figure out whether the charge was even bona fide. Don't know that the charge was bona fide. He's presumed to be innocent of the charge in any event, as we all will appreciate. So the easier course would be for me to accept Mr. Marshall's word as an officer of the court and to allow some limited non-contact contact in terms of like Zoom, phone calls and the like, until I actually have an opportunity to speak with her myself to make sure that I can feel comfortable with a more sort of interpersonal type of a contact. You know, usually when we have these sorts of situations with respect to people that are intimate, we actually have Eve or somebody get involved, put together safety plans and things like that. I don't know that we necessarily need to do all that, but certainly I would want to have her look me in the eye and tell me that she's good with this. Okay. So on the basis of our discussion today, I would be willing to sign an order that would allow for some limited contact through telephonic or video conferencing methodologies so that they can have that sort of contact, because it's easy for her to be able to walk away from that if she feels threatened or if there's something going on in terms of what transpired to trigger this whole thing. I'm glad to see that he's already engaged in anger management. That seems like that would be part and parcel of what would be ordered by the court. And certainly we'll just kind of go from there. I'm not sure at what juncture this particular matter is. Is it still in the pretrial stage or?
Yes, Your Honor.
Okay. So we'll figure out where we're headed once you guys decide how you want to try to dispose of the matter. Might be actually a case for 769.4A. I don't know if they were still living under the same roof at the time that this occurred or not, but sounds like she's young enough that she's a student at Central Michigan, so this might actually qualify for 769.4A. Okay.
All right.
You guys want to go ahead, put together the stipulation, send it to me, I'll sign off on it, and then we'll kind of go from there.
Okay, the order for limited contact?
Yes, ma'am.
Okay. All right, I will prepare an order and have it sent over, or does the bond just need to be amended and he needs to re-sign it?
I think to be safe, he's probably going to need to sign a new bond
Okay,
that will have the changes and the conditions of his bond put into the system.
mhm.
And just kind of go from there. Mr. Marshall, are we missing anything?
Not to my knowledge. I think that's appropriate.
Ms. Martinez, what do you think?
I think that will work. We have the court amend the bond. Mr. Reed will come and sign it today or tomorrow, whatever works, and I can do the order for the file and send it over to both you, Judge, and Mr. Marshall. So that's clear.
Mr. Reed, I will tell you, I don't usually give people advice, but listen to your lawyer so that she can keep you out of trouble. I'm sure she'll want to talk to you after we're done speaking today, because she knows how much of a stickler I am for court orders. So listen to her carefully and adhere to her advice and counsel.
Yes, sir.
Okay. All right, I think we've covered everything we need to cover for purposes of today. I'll make a notation in the file that I should be expecting to receive a stipulated order. Okay.
Thank you.
That one was a little sad. I mean, he should have known about it, should have taken care of it, should have done whatever he needed to do, but it did ruin both of their holidays. The question I have is, why didn't the daughter show up to help him get it dropped? I agree with the judge not doing anything until he actually heard from her, because you never know. So anyways, that was your interesting cases of the day. While I work on some other stuff for you, I will try and get it all together as soon as possible. I had some other stuff I had to take care of today. And I've got a Florida Man weekly news report I am putting together. And boy, they have been having some fun down here in Florida. There are some stories I went down a rabbit hole last night reading these stories. I don't know how to pick and choose. I could probably make a whole day long stream out of what I found. So I will put that together and a couple other things that I found that are kind of exciting, and I will see you soon. Thanks. Hey there. I have a bunch of really, really awesome stuff in the works for you. I hopefully will have it out within the next day or so. In the meantime, I wanted to throw this one up there. What do you do when a judge gives you quote after quote that should be on a t-shirt?
You're Mr. Hopkins? Is that you?
Yes, sir.
Come on, yeah, don't be shy. Are you headed to work today?
No, I'm off today.
That's the way you dress to come to court? Would you like a shirt and some pants?
I never came in the building.
Well, it's kind of like going to church, isn't it? Isn't that important? It's an important time in your life. You've got a state jail felony here that you're on probation for. You want to impress me, don't you? You don't want to go to state jail for 2 years, right? Look at this man. What's he wearing? A tie? Nice. That lady's dressed nice. Look at everybody. Does that make you feel out of place?
Yes, sir.
Don't do that again. It's kind of shows respect for everything, you know.
Yes, sir.
It's important. This is important. This is about the Constitution and about the Declaration of Independence, things like that. So you're on probation here for burglary of a building. And we had some issues back in October we dealt with.
Yes.
Reporting, community service, that prevention class, moral reclamation therapy. So how's he doing?
Since his release from custody, he's returned to work at Wingstop. He's making.
Wingstop?
Yes, he's making an effort to pay monthly towards
Are you
his
working full-time?
court assessed fees.
Yes, sir.
You kind of hesitated.
I work full-time.
Sometimes you do, sometimes you don't.
No, I work full time.
He
How
works
how much do you make an hour?
11.25 now.
He's completed the theft prevention class. He is scheduled to start the moral recognition therapy next month. He hasn't completed any community service
Whoa,
since his
mama.
release.
Whoa. Will you? New arrest. Mhm. You or Kagan Dixon?
Yes, sir.
All right, this is. Says MTRP held in review, held in abeyance, is that right? I
Yes,
held
sir.
this because there is no action that has been taken. It was filed in June. Why aren't we moving forward since it's a criminal matter that's been filed against him? Plus failing to report, well, that was a year ago. Then the report 2 years ago. So where are we on his probation status?
Your Honor, his last review was March of 22. Since that
A
period.
year?
Yes, sir.
His last review was March of 22. Since that period of time, he accumulated that new arrest for the evading. In May. I took over supervision of his case in July. Since that time, he's shown some, I would characterize them as moderate difficulties in keeping appointments.
Failure is not an option on that appointment thing. Every probation, or else you're not on probation. If there's nothing else you can do, you need to show up. If you don't show up, you're absent and you're going to prison. You understand? That's the way it works. Because we can help with other things, but if you don't show up to work, what happens? You get fired, right? That's the way it's works the same way here. This is a 3rd-degree felony too. You're looking at up to 10 years in prison. You want to flirt with that, do you? I get frustrated here because I don't understand. If I was in your position, I wouldn't miss an appointment, but that's just me. Call me silly, but I'm a rule follower. You have to follow the rules or else you go to prison.
For
Anyway,
moderate difficulties with the appointments, he's not demonstrating what I would consider real effort toward the financial. Since his last review in March of 22, he's paid an aggregate total of $119. The agreement was to have.
do you work somewhere? Are you employed?
So,
Where?
I work for a construction company in Houston.
Okay, so, well, how do you get paid? Hourly, monthly, what?
I get paid weekly every Friday.
Weekly every Friday. How much do you get paid every Friday?
Around $650 a week.
Okay. So. That's 2,600 a month.
Yes, sir.
All right. Well, that's over $30,000. Which ought to be enough to start paying more than $100 a year on your fees. But this not showing up thing is bad too. I don't like this. So what we don't have a hearing scheduled today.
No,
We're going to schedule one. 2 weeks. Okay. That's all the time you have, buddy. Get your affairs in order, because I mean, I'm looking at 6 violations here.
If I may, Judge, he's entered a plea of true back in March of last year on counts 1, 3, 4, and 5. The only matter that really needs to be addressed as to whether or not he's going to plead true or not is from the second amended.
That's not the only matter. The only matters are, what are we doing here on failing to report? Because you entered a plea of true on that, but if you're not reporting, then we're going to revisit that, baby.
Yes, sir.
No, Your Honor, he has been reporting. I would characterize it as moderate difficulty in the keeping of the appointments, the repeated rescheduling of the appointments. And he did definitely fail to report for the month of July 22.
Which was after he had pleaded true.
Yes, sir.
Correct.
All right. I mean, failure's not an option here. You got to follow all the conditions. I want a hearing. 2 weeks, everybody. Yeah.
If I may, I would just like to know what his plea is going to be on count 6, because that makes a difference about whether or not I've got to bring the officer from Humble in regards to the Harris County charge.
I can't make that, Judge, because
Yeah, bring him in.
I,
Yes, sir.
I don't represent him at this point on the. So we'll.
What are you here for?
I'll go try it.
No.
What am I here for? I'm
Uh-huh.
not quite sure. I mean, my representation actually ended a long time ago.
Well, so why are you here though? I mean, it's
So because I got notice and I was told to be here. Of course, when you asked.
So,
for me to
okay.
be here, let's try. But I will have him go to my office today after this and see if we can come to a meeting of the minds.
it looks bleak. You got to fix this quickly. If you can, but we're moving forward. And if you're not going to be the attorney, Mr. Burbank, well, at $30,000, you go hire somebody. You're not indigent, sir. But really, you want to play with 3rd-degree felony? You want to play with up to 10 years in prison? Really? By this, well, that's what you got, 1 foot in prison right now. It's just simple. What I've heard is enough to say you violated your probation. Your probation's revoked. You're found guilty. You're sentenced to up to 10 years in prison. Was that 3 sentences? That's it. You've got a couple of weeks to fix this. You better scramble and get your affairs in order. We said 2 weeks. We're not carrying these things long. Javarian Brooks,
Mr. Burbank, I just faxed your office. I need to look at our schedule. We've got some
You
trans-
need them to sign something, because if I'm not the attorney, you're not gonna have notice. You guys work to that.
Well, this was saying, I don't know when we can set it, because we have training coming up, so we'll figure it out. I'll make sure he gets notice.
And is it, Mr. Brooks good or bad?
He's good.
It's a nice change.
I'll check the patient.
Come on up, sir. Come on up. And quickly, there you go. You're Javarian Brooks, that's, and 16-25531. And Mr. Burbank, I believe is your attorney, right? And Miss Martinez is here. She's your probation officer. You've been on probation, looks like over 5 years, 5.5 years. And we had a little issue last year on community service hours. How are we doing?
He is still behind with his community service.
But is he doing good and trying to catch up?
He's making
Progress?
yes.
That's good.
Absolutely.
Well, that's a pleasant change from the last few.
He was given probation on the new offense in Harris County. And I got a progress report from that officer, and he is completely compliant. He's making a great effort towards his payments and made several payments. He recently had surgery that set him back a little bit.
Okay.
But he has been reporting every month to us. I mean, we just gotta work on community service now, but he was out a little bit, he had surgery.
Are you okay now? You get,
I'm back at work.
sir,
I'm back at work.
you're back at work. Good.
The court considered dismissing this, seeing he's on probation. He's doing so well.
Well, no, I mean, yeah, no, it's a good try. It's a good try, but no, we're, I think it's, yeah. I think what the pressure on him is keeping him, is helping him jump over the bar. But yeah, this is only up to life imprisonment, isn't it? On this one. That's why we're gonna keep that carrot dangling out there to make sure that you walk in the right direction. Because it sounds like Miss Martinez says you're doing fine. And you've been 5.5 years, but let's carry this a little further for a little more steady performance. I think Miss Martinez agrees with that. Yeah, that's fine. But this is good news. I mean, it's better news than I've had in the last 3 or 4 defendants here. So what do you think? Tell me what you think.
Since I got out, I've been doing the best I can.
That's what we want you to do.
So I've been working hard,
Yes,
take
sir.
care of my family. I got a little son on the way.
Great.
I'm trying to be the best father I can be.
Well,
Yeah.
that's great news. That's a lot of people have families and all good family members. They know the rules, but they don't follow the rules. They don't try as hard as they can. Sounds like you're doing that, which is what we want. I don't have a problem considering early release on this if we just have a little more time. How long were you on probation out of Harris County?
3 years.
Sir,
3 years, 2 years.
what do you say?
3 extra years.
3 extra years of what?
3 years. He was placed on probation for 3 years.
When he says extra, what do you mean? Were you on probation on something else open? Oh, okay, so
They run the CC, I think. They just.
with this one,
Yes, sir.
so you've been on probation since when?
Since I got out.
May 17th.
Since you got out? What? God bless you. What is the date that you got out? Do you remember? About, what's a month? You don't remember the month? I remember the month I got out of jail. If I was ever in jail, I would think I would. Like 6 months ago?
Like April, it's gonna be the whole year. April.
Almost a year. Okay.
May 17th.
May 17th.
All right. So you're well into completing your probation. It's
Yes,
3 years? You said
Yes, sir.
over there?
Move it off in 2025.
Well, maybe. We'll review it in 6 months, okay? And see how things are. Okay, who's representing you in Harris County? Is it Mr. Burbank?
No.
Okay, get a resetting for 6 months, sir. Thank you.
You're
Honor, do you have any problems with when he gets his money current, donating to the food bank, the special project? And we were performing the hours so that he can continue to work.
Well, of course, that's,
Okay.
I'm not gonna be the one saying no to the food bank. I'll tell you that. Or Salvation Army, or
Okay.
which I'm a member of, and any of those worthy organizations, or I certainly would reward people for doing and helping out.
Okay.
Yes, sir.
Thank you.
Yes, ma'am. Nolan Weber,
Sir, you'll need to sign right down there, please.
eighteen 29875 is called the State of Texas versus Police Moore. That's you,
Yes, sir.
present, with your attorney, Mr. Kelly. And the probation office. Looks like in April last year, there was a first amended motion to revoke probation filed. Is that what's pending?
It's pending right now, Judge.
You have
Police completed
one
safety.
urine sample on February last year that showed phencyclidine. In February, same one showed cocaine. In March, phencyclidine. 4, failed to complete DWI repeat offender. 5, interlock device showed presence of alcohol in January of last year. Okay. So the real hitch in the giddy up there is that you're on probation for DWI 3rd. So, what are we gonna do today? I don't know. I just have it in front of me, and there's a motion.
In that
Do we
time,
have a hearing?
police has completed safety. She has been out of the halfway house for
Not
2
even
weeks,
a month.
not even a month, and is starting aftercare at Spindletop. So at least for the moment, it seems like things are going in the right direction.
Your Honor, we did amend their terms on May 24th after the following of that motion for her to go to safety relapse. So this was just, my understanding was just a review to see how she was doing.
And
she just beginning the program, so she got out safety relapse on 23rd of December, and she started her aftercare January the 12th.
And what other than what's in this first amended motion to revoke probation do we need to deal with? Anything she's failed to do?
No,
other than
sir.
What's in the motion?
No, sir, she has not failed to do anything since she's been out. She's been doing everything she's supposed to do.
Okay.
Since she's completed the relapse program, Judge, I would recommend dismissing the MTRP. Watch how she does on probation.
She's current with all fees?
No, sir.
Why not, I wonder?
Most likely because she hasn't been here, Judge.
What do you mean here?
Well, she's been at safety.
How much is she behind?
She's behind an amount of $2,400 and 8. Pick up $480.
Are you working somewhere?
No, sir, not yet, but I'm in the process of trying to get.
When were you released from the facility?
December 23rd.
Okay, a month ago.
Yes, sir. I'm just getting into the motion of being home, rekindling with my children, my family as a whole, and myself, you know. So, but I'm in the process of looking for something. I'm not just sitting at home twiddling my thumbs.
Where have you gone to look for jobs?
Different fast food
What
places
name?
right by my house. Jack in the Box is right by my house. Checkers.
What do they say?
Just that they're not hiring right now. So I'm
Okay.
I'm
you gotta
still in
Try
motion.
other things.
Yes,
right?
sir. And I'm putting applications on Indeed.
So I'm hopeful, just trying to get something overnight.
Anything else we should deal with on this today?
No, sir.
Okay. You're gonna file a motion to dismiss the motion to
Yes, Your
revoke
Honor, I think that's-
probation?
since she's, our biggest concern with the motion was ensuring she went through safety relapse. Trust the probation.
Don't
to
show
monitor
positive,
after that.
because I want to know immediately if you have a positive,
Yes, sir.
especially for those drugs. Never should anybody have phencyclidine in their system, much less combined with something like cocaine.
I'll send your motion.
You know what phencyclidine is called? Embalming fluid. Used to embalm animals. Why a human would put that inside themselves defies logic.
Number 2 on the list. Absolutely.
Okay. On Joseph Ladette. How we doing on this?
He has not come up with the money to pay the restitution off.
10879, okay. Now he's limping. Limping is not going to get you out of your obligations on probation. You know that.
Sir, I've got a prosthetic on my leg. It's no intention to see the court or yourself.
Okay, no, that's just telling you that these obligations need to be
That is
performed.
correct, sir.
And it sounds like it's kind of like it's restitution, which is
Yes, sir.
important. Paying back, that's how you fix a mistake.
Correct.
When it's a theft, you pay back the people for the value of the services or property that was taken or lost. How much is the balance still left, Mr. Harmon?
$5,627.88.
Well, that's what it was since May.
Correct.
Are you kidding me? You haven't been able to come up with one penny?
Yes, sir.
All right.
I've had some medical expenses and this.
We all have.
Okay,
We all have.
okay.
Issues.
Just let me know if you want to.
We all have
Actually,
issues.
yes, sir.
I mean, but truly, unless you're incapacitated, you gotta figure it out like we all do.
Right.
All of us go to work when we're not feeling well or injured or something, unless it's so bad you're incapacitated, but that's what we do. It's just life. But you did something here that injured a person and took their property. You got to pay that back. You've been on probation now since over 10 years. What's the total amount he's paid in this restitution, please, Mr. Harmon?
Okay, he was credited with $2,325.50.
So far?
So far, yes, sir.
How much?
$2,325.50 so far.
So, is that true?
Yes, sir. It's correct.
Okay. Let me just. Okay, that you weren't, I'm gonna let you.
I'm just gonna let.
That you weren't trying hard?
No, sir. What I said was, what I was cut off was that the figures that Mr. Harmon, I assume they're true.
Yeah, I don't have any reason.
Right, okay.
So
I have no.
So you know you know what that comes out to per month? Over your term of probation, how much you paid on restitution per month? $13. $13. That's not even 50 cents a day to pay these people back. You think that's breaking a sweat? Do you think that's working hard enough? I know if I was a victim of a theft from you, I'd think $13 a month over a span of 11 years is not acceptable. I'd wonder, where's justice? Why a victim can't be put back whole again better than this? I don't see that you've worked hard enough. And I think we've given you more than enough time. What we're going to do is hold a motion on this. And the issue is whether I'm convinced that you could pay or not. And if I'm not, your probation shall be revoked. So it's that simple. This has been ridiculous. I have thousands of cases, and this is one of the very few where so little has been accomplished to pay back the loss that you intentionally were responsible for. Theft is a crime. Theft is a commandment. So it's treated with importance. You, however, don't consider it important. All right. Are you able to hire a lawyer?
Yes, sir.
Yeah, well, you're gonna get one. You need to get one to represent you because you're looking at up to, this is a state jail felony, up to 2 years from the state jail. You've showed a track record of not putting forth the effort that is necessary, that everyone needs to put, especially someone who committed a crime against another person. So I'm going to set this for a trial in 6 weeks on a motion to revoke probation. In 6 weeks, you have 6 weeks to get somebody in the game. You understand?
Yes, sir.
That is all. Get a resetting. You're limping. You weren't limping last time, were you?
Yes, sir.
All right. How are we doing? It's a
Last time
review.
that he came, you ordered him to pay $130 a month, which he has been doing. However, his 10 years is up in July of this year. We extended him for a year.
Well, okay. So what's the balance?
It is $13,921.
And when's the anniversary of?
July.
In July. Are you able to pay that by July?
The amount?
Mhm.
No, sir.
Then we're gonna have to file a motion to revoke probation to keep it open. Because your probation naturally ends. I guess, what did we do? This says 13, 5 years on.
Yes, and then in 2018, he was extended through an admin hearing for 3 years.
3 years.
And then we extended him for a year.
Okay. So we're gonna need to file another. How much are you able to pay a month on this?
The 130, I'm getting by, I'm struggling, but I'm good.
At 130, 130, it's okay, so that's only about 1,500 a year. And how much is left?
13,920.
That's 10 more years. Well, that's what we're gonna do. It's gonna take whatever the people need to get paid back.
Absolutely.
What was done with the money?
All of his fees are being applied to.
I'm talking about the money that was taken in the first place under this indictment.
How did this come about?
Yeah, what was done?
Yes, sir, I was working offshore, 28 days offshore, 2 weeks home. Not earning any money on the 2 weeks home, so Human Resources for Cal Dive International told us we could draw our unemployment for 2 weeks that we were off. We did so. Years went by, 10, 15 years. Then all of a sudden I got a knock on my door that there's a warrant out for me and this come about. All I did was listen to Human Resources along with everybody, not everybody, but about 20 people on my vessel. Drew unemployment for the 2 weeks we were off, 28 on. I did that. I worked offshore for 15 years. That's how all this started.
Okay. So quite naturally, because you were filed on for See, this indictment, sir, alleges that you intentionally and knowingly appropriated property. What you're telling me is that that's not what happened. You were misled by your people.
Human resources.
So quite naturally, you filed a lawsuit against them because that sounds like that would be an easy one to win, right? Since they misled you and tricked you into getting an
I
indictment.
think it would be. I
Did
heard
you
they filed
file,
for
did you file something against them?
I heard
A
they
lawsuit?
filed for bankruptcy.
Did you file a lawsuit against them? Okay, did you go seek some help from a district attorney's office for maybe criminal behavior for putting you in a situation where you had to be arrested?
No, sir. Now that I think about it, I should have.
Yeah. Now that you think about it? I
Those
would've-
years
I-
back when this
I would have
happened.
thought about it at that time and. it would've
Yes,
been
years
pretty-
back when this happened, it did cross my mind.
It would have been pretty clear. But trying to deal with it now at this late date is kind of. You're trying to shut the barn door after all the animals have left. All right, and then motion's gonna have to be, a motion must be filed and we will handle it that way. I'll do the same thing as the other one, a personal recognizance bond for his bonds. We didn't have to post a bond and a minimum of $130
Yes, Your
per
Honor.
month must be paid. And then we'll cancel the rest of the obligations, okay? Anything else on that one?
No,
But there's a time sensitive thing there, Dan.
Yes, sir.
Okay. Get a resetting in 6 months, sir, right there. From that, thank you. Jeffrey Collins. No, I'm sorry. Daniel Moten. Daniel Moten. You're Daniel Moten?
Yes, sir.
Okay, this one is another probation review. How are we doing on this?
Your Honor, he's been on inactive since I took over supervision of the case.
Okay,
We've made good contact back and
good
forth.
contact, good.
By telephone and otherwise as the court dates and
Yes, sir.
everything. Any developments? The payments since the last review. I'll get you the amount.
There's a lot of money here.
He owes a lot of money. There are 2 different victims listed. He's made an aggregate total since his last review, $390.
For what length of time?
Last review, June 16th, 2022.
For 7 months? 6, 7 months?
Yes, sir.
So. That doesn't sound good, does it?
No, sir.
Why haven't you paid more than that paltry sum?
Unemployment. I haven't worked since they shut down the pipelines.
Well, are there other jobs in the world?
Back when I welded, there was, but
There aren't any, you're just saying?
other when I was in the refineries, I can't get in no more because of this. Most jobs I can't go to because they pull up this. That's what I'm being told.
You might be surprised to know that everybody on probation in this court has to get work and most of them do. And so nice try on that one, but it's not like I got my head in the sand. You're not trying hard enough.
Plus, I got a bad knee. Been aggravating me for a while. That I'm gonna have surgery on next month.
If you have to stuff envelopes for a living,
Yeah,
I don't care, do it.
If they're
You-
firing, I'll take the job today. I mean, somebody needs me.
If I decide that your probation, you're not trying hard enough on your probation to honor the terms, what can happen if your probation is revoked? You want me to tell you? You could be then found guilty and sentenced up to life in prison. You think I'm going to forget about this and what happened in this case? This is serious. You shot somebody. And there's $60,000 in restitution over your conduct. And you're sitting there telling me there's no job on the planet?
I've tried, Your Honor.
No, I'm not gonna, okay. Here's what I want is I'm gonna 60 days. And we're gonna come back. I want the probation office to do a thorough analysis. If he's not trying hard, I will order a motion to revoke probation to be filed and we'll move forward. And then I can guarantee you, they got a lot of jobs in the prison. You understand how serious I am about this? You're one of the few people who's come up here and who isn't working somewhere. And your excuse doesn't satisfy me.
No, you hire anybody with a bad name. So,
There are other jobs you can have. I'm not going to bore you with this, but I went to college and had 3 jobs and went to night school. 3 jobs during the day, over through a weekend. Had 3 different jobs. So, and I don't ever consider myself special. I'm just a regular person. If I can do that, you can. Get 1 job. Get a resetting. You better shape up better than this, sir. Or else we're going to move forward. And then you ever been to prison before?
no, sir.
Terrible place. 131, that's you?
Yes, sir.
Okay. This was sent for a review today, is that right? Yes. And so my question is, how is he doing? There's a motion to revoke that had been filed. You're on probation for burglary of a habitation since April 8, 2021. So we're going on 2 years. Last year, you had failed to report, you had tetrahydrocannabinol or marijuana in your system, you had community service that you had not done, and you busted a curfew, and you hadn't completed a theft class. So there were marching orders you had, and how has he done?
He did provide verification that he completed the theft course. We've had some payment issues and some reporting issues, but he did make a payment on the 19th and in the amount of $102. So still has a balance of community service of 800 hours. He did express that there was a bit of difficulty in him finding a job, but he has one now at a restaurant. So
Where?
That's all.
So what do you think we should do?
well, the closer we got to the court date, the
More serious he got?
yes, sir. The
Should
payment
we
was
have a court
remitted
date
yesterday.
today?
Well, I hate to have to supervise someone like that. If it had not been for the court date, I don't know that we would have had payment. And now consistent reporting since November. So
Here's the deal is if there's a violation, she's gonna let me know. You know, if it's a violation that's not excusable, that y'all can work out. And then you got something that's open here, right? I mean, this is still open. I can deal with this anytime. And it's that simple. It's the motion's granted, your probation is revoked, and then let's see, we're looking at no less than 2 nor more than 20 years in prison.
And Your Honor, this was in May, the last time when we had this hearing, he had 0 community service hours. That was May 25th, 2000.
How's he done?
There's 0 still.
You gotta kick it into gear here. Failure is not an option. I guess it is an option, but that means it comes with prison. You've never been to prison before.
No.
You don't want to go. Then you're convicted of a felony forever. Plus, you're not living with people you want to live with for up to 20 years. I just, these are simple things to fix. It's just frustrating to see that that doesn't seem to be something that that causes you a sense of urgency. But it better. Let me know. We'll pick it up. It's real simple. If you're not going to put out the effort, I want to know. I'm going to review it in 90 days. Boy, you better have some good news. Okay, thank you. Get a reset.
I think that's the last one I have, Your Honor, for today.
All right. Okay.
See you Monday.
Art is yours, Jimerson. Bye-bye. Art is yours, Jimerson, please. 2 cases.
Somebody else, for me, please.
Man. We do have a motion. We had to make some changes.
I got fix and amend it anyway, so.
That was back in
I remember.
last year. That
It was a very, very bad day for me. Actually, I think there were 2 or 3 motions. I had a very, very bad day. It happens.
Yes, the most scarred up motion I've ever seen. But. Yeah.
We get to amend it if you look at the
All right.
administrative hearing.
Here we are. We are here today, and you are Mr. Jimerson.
Yes.
2 cases, 16-23987 and 24480. This is a review of status as we've held the motion to revoke adjudicated probation in abeyance, and then there's a motion for deferred in 23987 that you had pleaded true to. And so here we are, and it's been nine months. So that's enough time to get a sense of how he's doing, if he's going to be serious or not. So, all right, Ms. Joseph, tell me, what's the word?
He is now gainfully employed as a precinct.
Well, you got a nice bright shirt on. What do you do?
I work with Fred at different plant. I work with Fred 8 through Apache at the plant.
How much are you making an hour then?
I'm making 18 to 19.
Hello. That's 50,000 a year.
Yes, sir.
Well, you're a player.
Well,
I mean, you can do things.
Yes, sir.
Is that the most your family's ever made? You think?
Yes,
Well, you're a role model,
yes, sir.
but you gotta, you're in a position to be a role model for your family and the people who know you go, I want to be like him.
Yes, sir.
I know they don't want to be like you on this stuff, but people make mistakes, but you got to fix it and move on with your life better.
Yes, sir.
You're doing that?
Yes, sir. I've been doing very good.
Good.
I'm blessed to be on that.
There's one little issue on the.
There's a little issue. Okay, what is it? What's the little issue?
Mr. Jimerson did report on January the 12th of this year for a regular office visit. He was required to submit to urinalysis.
And
the urinalysis technician, as well as unit supervisor on duty, did find a prophylactic on Mr. Jimerson's person with urine.
what's going on out there? We did that yesterday with somebody. They came with a bag of urine tied to their leg when we tested them. I mean, it's hilarious. Whose phone just went off?
I don't have my phone.
Is that yours?
No, sir.
Mom.
No.
No, sir. Lives on side.
Serious. So.
Turn it off. Well, that's a couple of things that are wrong there, right? Why would you do such a thing? Well, okay, so he was tested.
Yes, sir. We tested him he came by the office this morning and submitted for analysis. And at that point, he did test negative for illicit substance. On January 12th, he did not submit to a statement, to a specimen. after the situation with the prophylactic, I guess he got a little nervous and was unable to produce a specimen. So today we conducted a urinalysis and he was negative. So,
That's terrible. You $50,000 income, you want to throw all that away and a career? Well, I mean, even if you didn't get tested, the fact that you had a prophylactic in there is a bad for a urine test to defraud the probation office and avoid the ordering of the conditions of probation, which is you shall be drug tested. You have to submit to it and you can't try to falsify it, or else it's the same as failing it. It is a failure. Why would you have done something? Well, I know what the answer is. You wouldn't have done it unless you thought you were going to fail it.
Yes, sir.
So what's the problem?
Yes, sir. I own up to that, sir.
What's the problem? What were you going to test for?
I'm pretty sure that I thought that I could have been dirty, but I was.
For what?
Probably for heroin, because it doesn't get out your system as fast, but I've been stopped. And, you know, I own up to it. I'm very sorry. I apologize, but I've been doing it right after that, and I did go get.
I know you got, but you got to. You got to play the whole game without errors.
Yes, sir. And from now on, that's what it is, sir.
Yeah, you're. This is why we don't do it on the defendant's terms. Listen to this. This is what you signed when you started probation here, and it's dated in 2016. This is, you signed right here. A promise, like a contract. I agree to follow all conditions imposed upon me, and I know that this community supervision can be revoked for any violation. So today, telling me, oh, okay, from now on, I'll do the right thing. That doesn't absolve yourself from failing to honor your commitment you made when you began probation, does it? What should we do?
well, we have two options.
Two options.
We can do 30-day weekend jail sanction, or he can be remitted to ISF for the substance and cognitive treatment tracks.
What's other than ISF?
Aside from ISF would be a SAFE or a JCDI.
What's the least thing we can do?
The jail time, weekend jail time, probably.
No, other than I want him to get some substance abuse help, but I don't think ISF is necessary.
JCDI.
JCDI,
Yes,
which
sir.
means, what would he have to do? So he knows.
Frequent random drug testing. He has to attend group meetings, and there's sessions, drug court sessions. And he will actually be assigned to another officer that has they specialize with the.
But he's still able to work.
To work, yes, sir.
That's what we're gonna do. Amend your probation terms to complete successfully JCDI, but don't do that again. You understand? You got a lot to lose.
Yes.
Okay. All right. I want to review it in 90 days and see how he's doing on these two cases. Okay. Ms. Joseph, thank you. Get a resetting certificate.
Xavier Kane. Xavier Kane.
Sylvia Rodriguez. Sylvia Rodriguez, please. 18-30853. Connie, what's his name? Kane, I need Xavier Kane's file.
Judge, that case was reset.
That case was reset. to win.
Hold on one second.
February the 24th.
Go, come get a resetting. You reset to February 24th, sir.
Your new date's at the bottom.
All right, you are Sylvia Rodriguez? Okay, and you have been on probation now for, since 2019, I guess we extended it, huh?
Yes.
Yes, sir.
Back in 21,
She's had two separate extensions.
two separate one-year extensions?
Yes, sir.
Okay, so you were on probation until October of this year. And where are we on her progress or no progress?
Okay,
Oh, boy.
when we did that extension, the underlying problem is failure to pay. During her office visit in September, this past September, I had instructed her to bring in some copies of some financial documentation, some copies of her bills, income, etc., so that I could help gauge her ability to pay. When her October appointment came, she did not bring those documents. I then said, she said she left them at home, forgot them at home. I then,
And you sure the dog didn't do their homework?
I'm not sure about anything. I instructed her to come back the very next day, very next morning with those documents. She no called, no showed for that. I made attempts to get her back in for appointments, set her for two separate administrative hearings, of which she did not show for. Against the recommendation of my supervisor, I submitted this to the court as a judicial review without a warrant to give her the opportunity to come before the court, not in custody. But this will be the first time I saw her since October. She stopped reporting, told me she did not.
Really?
Stopped reporting in October
Okay,
and told me she did not want to do probation anymore, wanted to come before the judge.
okay.
So that's where we're at.
How much does she still owe?
About 2,400, 20.
That's on,
2418,
how much of that is restitution?
zero. There's no
It's
restitution.
just court fees and things like that?
Correct.
All right. Well, before we light the missile here and fire it away, you want to say anything? It sounds like you just quit. Is that it? How much time does she have credit?
Judge, on my original order said I didn't have to pay restitution or anything on my original thing, so when I went to them, they said I had to pay them.
Well, no,
No.
he's saying no.
There's no
You have,
restitution.
you have, every month you have to pay, what, $60 is a probation fee?
That was,
Then you have court costs. Then you have court costs are 329 in this case.
So she has 1 day credit.
Oh, boy.
Your Honor, I should also make the court aware that on each of those extensions, well, at least on the most recent extension, if not on both extension, we added those without additional fees.
Yeah, so you didn't have to accrue anything, but the total amount over time is 2,418.
That's how much she has left outstanding. She has paid an aggregate total since she's been on $873.
Okay. Well, the failure to report is the most important thing to do. If you don't do anything else, you got to report, which means when you don't, you're not on probation, really. No, what do you have to say? Anything you want to say? Because, I mean, I cannot conduct business without the people being required to report. And if I don't do something affirmatively, when somebody fails to report, especially somebody who said to the probation office, I'm just not going to report, period, act of defiance. Well, we're going to have to set an example. 2 years is a long time, but That's your choice, not mine. Anything you want to say?
Well, I just wanted to come before the judge,
You're here.
right, to tell them that to explain to you that my original paperwork said that I didn't have to pay. So I was.
No, look at it.
Yes,
You're wrong. The probation order that you sign,
Mhm.
you can show her a copy of it. But because, oh, look at you, there's your signature.
Mhm.
And it says on the bottom of that probation order, you see it? Do you see a copy of it?
No, they don't have one.
I didn't have a copy upstairs in Yolanda, but there, let me pull it up online.
It's
I can-
stapled here. It's stapled here, but
I'll print out a copy, Judge.
Have it right here, Your Honor.
you have it the size. Okay. All right. Look at the last page where you signed.
Mhm.
Look right above your signature. I have received a copy of this order. I agree to follow all conditions imposed upon me, and I know that this community supervision can be revoked for any violation. You see that? Okay, in your signature. Go to the previous page. It would be the second page of the order at the bottom. Do you see where it says fine and things like that at the bottom? Could you point it out to her? You see that?
$500.
Okay, look at that. Supervision fee. You signed it, $60 a month. The next line, Crime Stoppers, $50. The next line, pre-sentence investigation fee, $500. Over there to the right of that, your analysis fee, $15 per month.
But I already paid 800 and something dollars.
Well, you're gonna get credit for all of that, but you get credit for all of that, but over, what was this for? Stand by. For over, just in 2 years, but it's been accruing since you've been on probation. We had to extend it, so it keeps accruing. So it's what, how long has she been on probation actually now?
Since October of 2019. 2 years. And then,
No, that's 3 years, 3 years and 3 months. Am I right about that?
right,
Am I right? 3 years and 3 months?
October of 19, so yes, 4.
Yes, sir.
So 3 years and 3 months. That's 40 months. 40 months. So your supervisory fee is 60, so that's 2,400 right there total. Then that's 500 for post sentence, so that's 2,900. Your analysis fee is 15 per month, so that's 600 more right there. So now we're at $3,500. How much did you pay total?
800 and something.
800. So see, you're behind now 20. Yeah. But that's the least of your problems. Problems you have is not reporting. That's kind of bad. But I'm not making a deal with you. You'd still have the problem dealing with the failure to appear for the meetings, the scheduled meetings and the reporting. But people who pay their obligations, are treated favorably by me on other matters. But I'm not making deals. I can't make deals. But I'm just thinking maybe you ought to consider fixing what you can.
Can I get it put back on probation?
I'm not making a deal with you. There's gonna be, you've undone, you've got a problem by not reporting. We got to deal with that. And you can't now report backdated.
Right.
And that probation office says you come in and just, you know, you were gonna have a problem, but you just defiantly said, I'm just not gonna do it. Y'all go jump off a cliff, kinda. But that's okay. You can take that tack, but you pay those monies that would I always reward people who do the right thing. And then we've still got this issue about not reporting. And that needs to be worked out. Everything can be worked out if a probationer is willing to do their part.
Be examined, and we have been to court since that report, and the judge and the doctor found him competent. But in visiting with him, he is still pleading not guilty and to this charge. Is that correct? You're pleading not guilty, right?
Yeah.
Can you move this down so we can hear you? Are you
Yes,
pleading
sir.
not guilty?
Right.
Okay, that's okay. Do you understand if convicted of this indictment, you are looking, it is indicted as a third-degree felony, but there's a prior conviction?
He, I believe, has 6 prior felony convictions, Judge. I don't know that they're all.
They're not in the indictment, and they're not in the discovery.
Why is
There's one, let me speak, just to complete. And paragraph 2 goes on to allege that you have, in 2020, in the 252nd District Court, you were convicted of similar failing to comply with sex offender registration requirements. So if, just on the indictment, if all of this is true, you were looking at a second-degree felony punishment of no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. And the state is stating that there may be additional convictions that could be added to that punishment range, but if you have 2 or more, you would be looking at habitual felon status. So one more prior conviction, if it's alleged into this equation, and the state is saying you've got several others, if there's just one more final conviction that is in a sequence that the law states is what is looked at for habitual felon status, your punishment could be increased to no less than 25 nor more than 99 years imprisonment or life imprisonment. I just want you to know all of that so that you know where we are headed. So we're going to set this for trial like you want. And Ms. Mantellini can continue to represent you. It'd probably go to trial quicker if you agree to release her. But this is the kind of case that we're going to move forward on pretty quickly.
Right. And I get my papers that deals with all this. I do have release papers and check-in papers for what you're.
You're going to have to talk to your lawyer, but do you want to keep Ms.
Well,
Mantellini?
that's what I keep trying to tell them. They're going to have to check the check-in office.
I can't hear what he's saying.
Well.
Go ahead. We had a security issue. Go ahead.
Well, I don't know what the problem is. If we keep asking these lawyers and stuff to check with the check-in office, it's already been verified. It's on the computer of the check-in papers, the release papers, and explanation papers.
I don't know what you're talking about.
Well, this is what this is about.
Sir, the point is that you're charged, you've got this indictment and you have apparently prior felony convictions. I don't know what you're talking about, release papers, but the only issue that this court is interested right now are the 4 corners of this indictment, which states that you have failed to register properly after being a previously convicted felon that required to follow the sex offender registration. And that's all we're going to be focused on. So do you want Ms. Mantellini to continue to represent you, or will it be assigned to someone else? And this will be set for trial.
Yeah, I'll get somebody else. See if they're gonna get the.
Are you able to hire somebody?
Yes, yes, sir, I can afford it. Yes,
You can.
yes, sir.
Okay, well, she will continue to represent.
Your Honor, this is the gentleman that had the Gillian, the 126 Gillian at the Capitol of One in Bank, and that I think Walter Humphrey was representing when we were in court before.
He's been declared competent and.
Yes, but an indigent, I don't know.
And he's got a. Yeah, the last time he filled something out, and you need to fill this out, sir. There's an indigent document. Fill that out so I can determine if you're indigent or not. Miss Mantalini, make sure he fills that out, because the last time it was filled out, he stated he had $126 kajillion
I don't even know what you're talking about.
at Capital One Bank.
Yeah.
And
That's the bank to verify.
you told me, you told me, and it's in the record, that that number is a 1 with 25 zeros after it, which is
Well, whatever.
a lot of money.
Whatever. Y'all know.
Yeah, no, it's not whatever, it's what it is.
Yeah, really. Yeah.
So where are we today, Your Honor? What's happening at this point?
You're going to continue to be a lawyer, and we'll set this for trial. If he hires somebody, he can hire anybody he wishes, but until then, it's what's in the record is that you are still the lawyer, and we will set it for trial.
Well, I would just ask the court to assist me with that directive and explain to Mr. Hernandez that I need him to be able to communicate with me when I'm coming to talk to him.
Well, I hope he will act like an adult and communicate, but he's also free not to communicate, even though that would be in his worst interest, but he's a grown-up and he's competent. So I'm not going to order him like a kindergartner to spit the gum out. You know, he makes his choices, and if it's a good choice or a bad choice, it's his. He has to live with it. But these are some important choices that could affect you for life here that we're dealing with. So, sir, I would act, I would act like a grown-up and a mature man and try to communicate with your attorney fully and truthfully. But we'll set it for trial at this stage.
So I'm kept on this one, Your Honor.
I'm sorry?
I'm kept on this one.
That's what the indigent law says, and under this set of facts, you are.
So do I not need to get the indigent form filled out, or do I?
I want to see if he's indigent or not. Because the last time he filled one out, it was, it had the 1 and 25 zeros, but that was before he was declared competent by an evaluation, and we'll see what he says.
You got a phone number? I'll get the bank to call you.
All right, that is all. I'll set it for trial. Letitia Hunter is next. What are we going to do with Letitia Hunter?
So, you know that saying that you should have to get a license before you do things? Like you have to get a license to drive. You should have to get a license before you can own a pet or have a kid. Make sure you're competent, responsible, committed to the process. And you're going to do the right thing when you know what hits the fan. So you watch this and you let me know. Is she at fault or not?
It would make Penny very happy if you would like, subscribe, and leave us a comment.
This case is Ronald Sylvie Jr. et al. Versus Ellen Cook, case number 22 SC1. Plaintiff Joanna Sylvie is present, and is Ronald Sylvie there as well? Okay. And you'll have to unmute yourself, Joanna. It's on mute.
Okay, can you hear me now?
Yes. I can, okay. And Ellen Cook, defendant, you are also on mute, so you'll have to unmute yourself. Okay. I've had an opportunity to look at the petition in this case, and I believe that the respondent has filed an answer as well. And I don't know, Miss Sylvia, if you would have a copy of that answer?
I do not.
Okay, I think she just sent it today to the clerk. But basically she can testify, I think, about this. It sounds like it would be her testimony. She does have some photos that we can discuss later. Okay, so Miss Sylvie, you're the petitioner in this case. You have the burden of proof, so I'll allow you to go first. Are both you and your husband going to be testifying?
Yes, well, my husband's the one they actually, the dogs ran into.
Okay, so if you'll both raise your right hand, I'll just swear you both in for testimony. And Miss Cook, you raise your right hand too. I'll swear you all three in for testimony right now. That way any statements you make can be considered as evidence. Do you solemnly swear that the testimony you'll provide in the case and hearing today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Yes, ma'am.
Okay, so Miss Sylvie, tell me what happened, and Mr.
Okay.
or Mrs., whichever.
Yeah.
Yeah, it'd probably better I do it because I was actually the one driving the vehicle.
Okay.
Basically, I was proceeding west on First Street in Moline off of Main Street.
Okay.
And I got approximately to the alley between Biddle and I'm not sure what the next street is. The two dogs just come flying out of the alley. I mean, I had no time to react. I mean, I hit both dogs. One flew one way, one flew the other. I immediately stopped. There was her kid, apparently her kid was out in the yard. I heard them screaming. So I got out, the dogs got up and ran, both of them. And then she come outside. When I went to talk to her, basically she just took her kids and went inside. I basically had no conversation with her that I can remember. So I just called the sheriff's department to make a police report.
Okay. So let's see, let me pull up the petition so I can see that again. According to the petition, you're requesting $773.57 plus a filing fee of $67.50 and the service fee of $15.
Yes, ma'am.
Okay, so how did you come up with that amount?
Well, the court fee and the filing fee is what they charged me.
Sure.
And then, you should have a copy of the estimate that I got from Murphy's a couple days after it happened. I got the estimate of the body damage from him.
Okay, yes, I do have that. Okay. And that is from Murphy Auto in Moline.
Yes, ma'am.
Body labor, paint supplies, and aftermarket parts, total $773.57.
Yes, ma'am.
Do you have any other exhibits, photos, or anything you want to present?
I forgot to get the photos, but I sent a exhibit that I had went to her house, contacted her a couple days later, asked her, basically if she could either help me pay it or what the intentions are. She started off, it was okay conversation, and then she told me to put it towards my insurance. I explained to her that I couldn't put it towards my insurance because prior to that, my daughter hit something and I had just claimed that on the back, and my insurance went up. So I explained to her, well, maybe she can put it on her insurance or however she wanted to handle it. And she was on the phone with someone and she started getting kind of angry about it. And the man on the phone was hollering, call the police, whatever, which is fine if she would have. I mean, I was just trying to make a solution. So I sent her a letter asking if she was willing to help me pay half of it, not even all of it. Never heard a response. I think I sent another letter, never heard a response. Then that's when and then because the next day she had like a no trespassing sign. So I didn't even go to her house anymore or anything like that. I just did it through letters.
Okay. So, Ms. Cook,
Yes, Your Honor.
and I'm gonna pull up some pictures I have here. Well, I think,
I do have pictures, but I forgot to send them.
oh, here they are.
I have pictures. Oh. Well, I don't know if the sheriff turned them in or not. I don't
So,
know.
and just so Miss Sylvie can see, this is a picture of one of the dogs. Wait, can you see that? No,
Not
you-
really.
Hold on, I gotta figure out.
Okay.
Where'd it go? I don't know.
Might pull it back just a little so it can focus in.
Okay, I'm not focusing.
It's
not-
okay. I believe you. I mean, I know you, obviously you have a picture. I mean,
Okay,
don't-
it's a picture of a black dog with some kind of abrasions, bloody type abrasions on it. And the second picture is this, looks like the same dog, but the hind legs. So there's some abrasions on that picture as well.
okay.
Okay. So let me go to you, Ms. Cook. How do you respond to this?
So basically what was my understanding and what I had seen, the dogs were on leashes in the front yard with my sons. They had gotten away from the boys, and obviously Mr. Sylvie had hit them. The dogs didn't run into his vehicle head on. They were running across the street and struck on their sides. Only the one dog had a lot of damage to her body that needed to be, stitched up and mended. The other one, her hips were knocked out of place, and the vet was able to just pop them kind of back into place. Aside from that, basically, obviously, all of us, I went outside to take care of my kids first, got them in the house, and then my daughter and I got the dogs. And once we brought the dogs, I was getting Ellie, the black dog, back into the house when I asked Mr. Sylvie which one of my dogs he hit. And he kind of had this weird smirk on his face, and he was like, both of them. And so at that point, I was just like, I'm not going to even bother talking to you because he was on the phone calling the sheriff. So I went inside my house with my dogs and my kids and stayed in there until the sheriff got there. So there wasn't a whole lot of discussion that happened with him. I was busy trying to take care of my dogs. The black one obviously was the one who was bleeding everywhere. I was trying to clean that up, and I was more focused on my kids and my dog than talking to him. So
Okay.
I didn't speak with him. I did speak briefly with Joanna when she came to my house, and that encounter was basically less than desirable. The one thing I did find was different that she had just stated was that she had informed me that her husband was in a car accident, not her daughter, and that someone struck the back of their vehicle, and that the damage to that was like $3,000, and it was way more than, what damage was done to the front of her car by my dogs. So I didn't want to sit there and argue with her about any of her previous experiences or anything about that personal matter. It didn't matter to me.
Okay. Okay.
So
And anything else, Sylvie's, that you want to present?
I do. And the only reason that it was brought up that my daughter did that damage to the back of my car is because that's when she told me to claim it to my insurance. That's the only reason I was explaining that I could not, because I had already previously had a claim.
Okay. And where was the damage, Miss Sylvie, on this vehicle?
It was like the front bumper, the grill part of it, and like kind of at the bottom, because it hangs low at the bottom. It was like a split in that, and like where the Toyota symbol is, there's a crack. And so it's the front bumper mainly.
Okay, okay.
Yeah,
Uh,
well, may I have a word? May I have a word?
Yes.
May I speak? Yeah, I mean, honestly, the reason, because it happened so fast, the reason the dogs actually survived is because this Toyota Corolla sits so low, and all the front bumper area is all plastic
Right.
or fiberglass. So basically, the dogs just busted all that up.
Okay.
And as far as any smirks or anything, I mean, and she's right, our conversation was very short. I had no smirks. I mean, them dogs scared me as much as it probably scared her kids. And I
Okay.
just had no opportunity to react. They come out so fast out of the alley.
Sure, okay. So I'm also looking at this document that Ms. Cook provided. And in this, she says that her kids said that what happened was the dog saw a rabbit or some kind of an animal running across the road or across the street. And so they took off and got loose from the kids, their leashes or the handles, and got loose from the kids and ran. So it sounds like in that respect, you both have the same story, basically. The dogs ran across the street for whatever reason. It doesn't really matter. Clearly, Miss Cook, your dogs caused an accident. They didn't intend to, the kids didn't intend for it to happen. You didn't intend for it to happen, but it happened. So the car was damaged. I think from all that I know of Mr. Murphy, he provides a good and fair business. I have no problem with his estimate of what the damages would be. It sure doesn't take much to make a mountain out of a molehill on a car. You know, it doesn't take a whole lot of damage before all at once you've got a ton of money to pay out. So my judgment is for the plaintiff in the amount requested, including the court cost and the service fee. So that's $773.57 plus $67.50 plus $15. Yeah, Ms. Cook, you do have the right to appeal this decision. That would be in the same court, Elk County, but it would be a limited case. Any questions?
No, at this, Your Honor, I'd just like this to be over with. I don't want to deal with these people any longer.
Okay, so you can send them payment.
I can't guarantee a payment in full, obviously, because I do have my own finances that I need to take care of at this time.
Well, it'll have to be in full at some point.
At some point, obviously, just not right now. As I stated in the letter, I am a single mom on a limited income, so I understand.
The total amount is $856.07. This will begin to accrue interest at the statutory rate. Anything further, counsel or parties?
Would she be paying that through the court? So that there's proof of payment?
Let me ask.
No, it does not come through the court.
It does not come through the court.
So basically we can just make copies of whatever she sends us.
Yes,
track
yes.
Okay.
Exactly. Okay.
Okay.
And we'll be in recess.
All right.
Now, stuff happens, and I feel really bad for the puppies. They should have been an offense or something like that. I firmly believe big dogs should be an offense because they need to run. But her not taking responsibility for it is kind of an issue to me. I mean, something you owned caused the damage. You're responsible for it. The judge just ruled you're responsible for it, but you probably should have settled with her ahead of time when she was giving you the option for like half, because now you owe all of it plus court fees. I don't know. What do you think? So here's another one. And this is what happens when you don't just settle things and you want to fight about them forever. You end up with $10,000 attorney fees and threats of jail for contempt of court.
Did you have any fruitful discussions during your breakout?
Judge, we did, and with the court's permission, I'll recite my understanding of the agreement.
Okay, thank you very much. You may do so.
Judge, my understanding of the agreement is that Ms. Kirkhoff has agreed to send my client a true and correct copy of the front and back of her Texas driver's license today by 3 p.m. And that Mrs. Kirkhoff agrees to reimburse my client $271 by next Tuesday at 5:00 p.m. The $271 represents 50% reimbursement for orthodontic expenses and dental expenses. The issues being reserved for the court today are attorney's fees, which we could not agree on whatsoever, and the issue of a finding on contempt.
Okay. Is that the agreement, Ms. Holland?
Yes, Your Honor.
Okay, Mr. Grove, you may proceed.
Thank you, Judge. I call Robert Jurassic.
Mr. Jurassic, if you'll unmute your microphone and raise your right hand to be sworn, do you solemnly swear or affirm that the testimony you're about to give this court will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay, you may proceed, Mr. Grove.
Thank you, Judge. Mr. Jurassic, were you previously married to Ms. Kirkhoff?
Yes, sir.
Was there a final decree of divorce entered divorcing you and Ms. Kirkhoff in the past?
Yes, sir.
May I share my screen, Judge?
Mr. Jurassic, do you remember your lawyer's opening statement?
Yes, sir. Yes, ma'am.
And in that opening statement, he said that you were seeking passports to take children on a cruise. Is that correct?
Yes, ma'am.
And were passports required for you to go on that cruise?
They were not required, but recommended.
So not required, yes or no?
Not required, no.
Okay, so then you filed a motion to enforce and are asking her to be held in contempt for not turning over passports for a lawsuit you started for something you didn't need?
I don't understand the question.
You didn't actually need the passports to go on your trip.
Not according to Royal Caribbean, but it was recommended.
Okay, so then you're requesting all these attorney's fees saying that they were necessary, right?
Yes, correct.
Okay, but you didn't actually need the passports.
I
So
found
this
out
is-
after the fact.
Okay, so then you're still taking up the court's time today for something you didn't need, correct?
Judge, I'm going to object to relevance at this time. The court order does not mandate that Mr. Jurassic actually have a need to obtain the passports. My further objection is asked and answered. Mr. Jurassic has said that Royal Caribbean recommended that the passports be in hand.
I would be remiss if I didn't stop this and talk to both of you about the absurdity of the number of hours that have been invested in collecting orthodontic payments. And this is a reflection on all of you, all four of you, that $10,000 of attorney fees on one side could have been incurred for some basic failures to pay what amounts to, I mean, I am really like, I'm speechless, quite frankly. Asking for jail time for a failure to pay orthodontic half payments. It doesn't make the failure to pay and comply with a court order okay. It's not, Ms. Kirkhoff. But this court spending this kind of time and the request for you to be jailed over it are mind-boggling. I'm never going to order that Ms. Kirkhoff be held in criminal contempt. You all reached an agreement this morning that these would be paid. I will award attorney fees, but I'm going to award reasonable and necessary attorney fees. And I don't want to spend any more court time on this. This is really absurd. There are lots and lots and lots of more pressing issues. You have 3 precious children whose college funds are being poured down a drain. What are you doing? Can the 2 of you see the absurdity of this?
Judge, absolutely, I can see the absurdity. I respectfully disagree with the court that our position is absurd. While the attorney's fees were enormous, they were incurred because Ms. Kirkhoff simply would not reimburse a couple $100 in orthodontics and sign the passport applications. Attorneys are expensive. I don't apologize for that, Judge. I do apologize that we are having to take up the clerk's time, but I do not believe that it is Mr. Gerassi's fault.
Okay. Let me just give you a little guidance and then we can finish this up if necessary. I'm not going to find criminal contempt today. I'm not going to find civil contempt today. I will award attorney fees and I will award reasonable and necessary attorney fees. Ms. Kirkhoff, you should have done what the court order said you were to do. You shouldn't have had an agreement, Ms. Holland, on the day of the hearing while we're all taking court time to be here. It's too late, too little, but we're here. And so I'm going to ask you to go back one more time and see if you can reach an agreement about attorney fees.
Your Honor, just one point. This is opposing counsel's exhibit. I'm not sure the exhibit number, but it's the final decree. At the bottom of page 8 of 53, it says it's ordered that Robert Gerasi, as parent joint managing conservator, has the following rights and duties. And it says the right, and then in italics, it says subject to the agreement of the other parent conservator to consent to medical, dental, and surgical treatment involving invasive and non-invasive procedures. If the parties can agree, pediatrician has to be the tiebreaker for medical decisions, invasive and non-invasive. Ms. Kirkhoff had scheduled orthodontic appointments the following week. Mr. Gerasi did not contact my client. Instead, he independently got a different orthodontist, took the kids, and I'm not saying dental care is bad. What I'm saying is he was ordered to get her agreement prior to doing anything. And then he went and took the kids and got braces, which if she needs them, great. I have no problem with the girls getting care that they need. But he never contacted my client. He literally violated the decree. And I'm here on a motion to enforce and compel and asking for jail time and $10,000 in attorney's fees when the entire reason that he has these fees owed is because of his violation of his own decree. So in my petition, he's going to get hit with a motion to enforce because this is putting us here and I'm getting asked to have my client pay attorney's fees for Mr. Gerasi violating it in the first place.
Okay, I see. I'm looking at what you're reading. You know what you guys actually need is some more detail on how to handle the orthodontics going forward. Is she the youngest or the oldest, or have the other two?
The oldest.
Okay, so you're probably going to have 2 more in orthodontics following her treatment, I assume. Okay. I heard very briefly about mediation. What happened with respect to mediation?
Judge, I don't think that was spoken of in this case.
Okay.
Maybe I'm incorrect.
Nobody-
It hasn't been.
Okay. And, you know, it's not unreasonable to ask for attorney fees, Mr. Grove. I'm not saying that. I believe that you incurred these fees. The amount is unreasonable given what's at issue. And I think there's probably been difficulty in trying to get Ms. Holland's attention just based on what you showed me. But there's clearly some, you know, if there was an obligation that Mr. Gerasi confer before getting the orthodontic treatment, what happened there?
Judge, my understanding is that he did confer, and I'm happy to bring Mr. Jurassic back to the stand to address the fact that he did try to confer. Further, Judge, with respect, this is the first that I'm hearing about this, number one. Number two, it's my belief that such a defense would be an affirmative defense that was necessarily needed to be pled, and I don't believe that it was pled in the enforcement. Answer.
Okay, it's your motion for enforcement, and show me, let's look at your petition.
It's her answer, Judge, that I'm saying that the affirmative defense was not pled in.
I understand that, but I'm looking at what language you're trying to enforce.
Judge, on page 7 and 8 of my enforcement, and 9 is where I copied the relevant portions from the underlying order.
Okay, let me get there. Okay. 8 is the insurance language, is what I'm seeing. 8 of your PDF.
Yes, ma'am. Page 8. Page 7 of the PDF on my enforcement is the each side pays 50% language.
How do you reconcile that though with the after conferring with the other party? Do you have?
Judge, I can place on evidence that my client attempted to confer with the other party and that conferring was not successful. If I recall Mr. Jurassic, number one. Number two, I reassert my position that if that is in fact the case, Ms. Holden should have pled that as an affirmative defense in an answer which was not pled.
But the language says that Mr. Gerasi, as parent joint managing conservator, has the right, subject to the agreement of the other parent conservator, to consent to medical, dental, and surgical involving invasive and non-invasive procedures. If the parties cannot agree, the children's pediatrician shall be the tiebreaker. So before you get into evidence, just one of you help me understand, was there a disagreement or not?
My understanding is that there was a disagreement. As the court can see, these parties disagree about nearly everything. So the fact that there was a disagreement, in my humble opinion, is not difficult to believe with respect to medical and dental care.
Your Honor, if there had been a disagreement, Mr. Gerasi would have had to make an appointment with the pediatrician to have them be the tiebreaker if he was following the decree. That didn't happen. Not only did that not happen, my client didn't find out that the girls went to the orthodontist until after he had already taken them. And she got a random email saying, I took the girls, Kylie's going to need orthodontia. And then he made a secondary appointment and had the braces put on, and my client was informed via email. There was no attempt to confer, but even if that attempt to confer had failed, if he was following the decree he's attempting to enforce, there would have been an appointment with a pediatrician and or, in my opinion, an orthodontist. So that language would need to be added, that the child's dentist would need to make the decision. But that would have had to happen.
No. I mean, if he didn't have an agreement, which you just told me he didn't, then according to the language of the order, he would have had to go to the pediatrician as the tiebreaker for all medical decisions per the decree. How do you reconcile that, Mr. Grove? How am I supposed to enforce the order that you're asking me to enforce? Doesn't say what you're saying it does.
Your Honor, with respect, I reassert that needs to be an affirmative defense, number one. Number two, if in fact the court finds that is the case, that does not get us around not having signed the necessary passport documents.
Okay, well, let's go there. Okay, take me to that language, if you would, so that I can see just on the
In the
face.
underlying order, Judge.
What's
That is the underlying order. The passport language is page 10 of the underlying order.
Okay, I'm there. Okay. It is ordered that if a parent's consent is required for the issuance of a passport, that parent shall provide consent in writing no later than 10 days after receipt of the consent documents, unless the parent has good cause for withholding that consent. And what you were waiting on was the photo of Ms. Kirchhoff's driver's license copies, right? Correct?
Yes, ma'am. Okay. Well, that was after Judge Burgess had to order her to sign the passport applications in our last hearing.
Okay, and let me go to that order.
Well, it also says unless that parent has good cause. And like I said, there's a lot of language further down in this decree about the children not receiving vaccinations, and it's an agreement and a waiver that Mr. Gerasi has had notarized. And at the time that he was discussing international travel, there were still requirements that if you were traveling from the United States to another country, you'd have to be vaccinated for COVID. And it was after they started vaccinating kids with the COVID vaccine. And so my client's objection to him having the passport was, we have this in writing saying the kids can't be vaccinated, and I don't want the girls vaccinated. And she withheld her consent. When she got ordered, she turned over the paperwork. She went and got it notarized and turned it over. There is the sentence that Mr. Grove underlined saying that she needed to give the front and back of a driver's license, but that wasn't an intentional withholding from my client. That came up after she'd already turned over the other paperwork and we've agreed to give it over. But everything else,
Okay, has Ms. Kirchhoff complied with Judge Burgess's order?
As written, yes.
Okay. Yes, I will. And those, how much time do you need to pay that amount, Ms. Kirchhoff?
I need to speak with my husband in regards to how much time it will take. Can we create a plan outside of this?
I'm going to order that they be paid within 90 days, and then you can work out the payment plan.
Okay.
In that time frame. Is that workable?
Okay.
Okay. All of the other agreements of the parties shall be reduced to an order, and the court will sign off on those agreements, and they will be enforceable. Okay. You all are excused. Mr. Grove, are you going to prepare that revised order for the court and for my signature?
Yes, ma'am, I will.
Okay. I will look for that approved as to form by Ms. Holland. If you cannot get an agreement as to the form of the order, then you should send it to me with any red lines. Okay.
With respect to the attorney's fees, Judge, is the court finding that they were reasonably necessary for the safety and welfare of the children?
I am not.
Thank you.
Okay. All right. Thank you all very much.
Thank you.
All right. You're excused. Thank you.
I had to trim a lot of that out because they were showing sensitive documents that had information on the kids and things like that. But I think you pretty much got the point. Like all of that was over a dentist bill. There's no reason for that. You know, talk to each other, work together. They were both in the wrong. There's no reason to $10,000 in attorney's fees. That blows my mind. And I think that one was attributed mainly to the passport. After they had made an agreement not to get the kids vaccinated, but it was required. It sounds like they're doing things to each other just to be vindictive, and there's no reason for that. If you want to be vindictive, do it outside of the kids. Don't get the kids involved. We've talked about this, people. Leave the kids out of it. So here's another one. Yeah.
All right, good morning. We're here on the family law pro se docket for January 18th. I'm Commissioner Dave Nelson. Let me first call Tiffany Rooks and Gareth Clark. Either of them here. Okay, we will pass that for the moment. Jessica Kintz and Jesse Lee Kintz. See Jessica Kintz. Mr. Kintz here. All right. You provided final orders for the dissolution, and they looked appropriate to me, so I will go ahead and sign those. Okay.
Okay, thank you very much.
I'm going to do that right now. Just hang on while I go through them.
Okay.
All right, Ms. Kintz, I've signed the findings and conclusions about a marriage and then the final divorce.
Okay, thank you very much.
All right, thank you for being here. You're free to go.
Thank you.
Mute this person. There we go. All right, let's go to Sarah Soyster and Brandon Alexander.
Hello.
Good morning, Ms. Soyster, and I think Ms. Looney may want to be part of that.
Good morning,
Ms.
Brandon said he's gonna be here this morning.
Okay, he's not in the waiting room right now. Do you want to pass it and wait a little bit to see if he arrives?
Yeah.
Let's go ahead and do that then. Okay. All right, next will be Alyssa Gutierrez and Francisco Gutierrez.
Hi there.
I see Mr. Gutierrez is here. You may want to unmute yourself, Mr. Gutierrez. If you're on your phone, it might be pressing *6, or there may be a microphone icon that you touch. Can you talk now and see if we hear you?
Can you hear me?
Yes, we can. Good. We got through that. All right. Ms. Gutierrez has brought a motion for a temporary restraining order and also for adequate cause to modify the parenting plan. And typically what I do in this case is I'll put or place Ms. Gutierrez under oath so she can testify to the facts supporting the temporary restraining order. And then I'll give Mr. Gutierrez an opportunity to respond. I'll also place you under oath. And then Ms. Gutierrez will have a chance to reply to that. Okay? So Ms. Gutierrez, if you want to raise your right hand, please. Do you swear or affirm to tell the truth in these proceedings?
Yes, I do.
And what is your full name, please?
Elisa Drew Gutierrez.
Okay. And is everything that you stated in your petition for a temporary restraining order true and correct?
Yes.
Okay. Tell the court why you feel a temporary restraining order is necessary.
I don't necessarily feel that a restraining order would be necessary at this time. I more am looking for like I don't want to feel like my peace is being disturbed. I don't want like a physical restraining order because I do want him to be able to have visitation rights to our kids.
Okay. So how was your peace disturbed in the past that you would like to end or be stopped?
Well, he actually went to jail for domestic violence because he put his hands on me, and I was filing the restraining order because I was scared of retaliation, like him coming back again. But when he was released, they actually placed a no contact order on him, which I was not notified of that until later on. And
There's already a no contact order in effect. Is that right?
yeah, I got something in the mail saying that they gave him a no contact order when he was released. So yes, now with the no contact order, it's been fine. But I do want him to be able to be around the children.
You also filed a motion for adequate cause, which is the first step to change a parenting plan. Are you still asking that be entered?
Yes.
And tell me why you feel that should be entered at this time.
I feel that should be entered at this time because him being alone with the kids has not been safe for them. He's had addiction issues and cannot finish his rehabilitation programs. And every time he's around the kids, he continues to drink, smoke marijuana. It's not safe for the kids to be around. They don't feel safe. And then he eventually gets violent. He also has tendencies of blacking out.
So at this point, you want visitation to be supervised?
Yes,
And the order in existence right now is not supervised.
it's not supervised.
Okay. All right, anything further?
That's all.
Okay. Mr. Gutierrez, I'm going to place you under oath. If you want to raise your right hand, please. Do you swear or affirm to tell the truth in these proceedings?
Yes.
Okay. What is your full name, please?
Francisco Julian Gutierrez.
All right. How would you like to respond to what Ms. Gutierrez has stated?
I don't think supervision visitation with my kids. I don't think that should be happening. I'm capable of watching my kids, hanging out with them, and being with them.
What about Ms. Gutierrez's request that you not disturb her peace and quiet?
I have not done that at all.
What's your current visitation schedule, sir? With your
I
children?
believe it was like every other Friday or every Friday on my day off.
Okay, just during the day?
Not sure, to be honest.
Okay.
Because he's an alcoholic and a pothead. That's what the lady just said.
Pro tip, if you're listening in on Zoom meetings, hit that mute button, especially if you're not, involved in the case and you're going to relay a little summary to your friend. Mute. It's a great feature.
So I started speaking there. All right, Ms. Gutierrez, you have a chance to reply.
Chance to reply.
What's that?
Yeah, he has not disturbed my peace since he's been released from jail. I do agree with that. But I still feel that it is the best option to have supervised visits at the time being until he can provide me with proof that he has finished rehab or provide me with a negative drug and alcohol screening.
All right, just when I'm looking at the parenting plan, it was entered in June of 2022.
Yes. He actually has visitation every day, and he also has every other weekend. He doesn't use them though.
All right, it says his visitation Friday at 4 to Sunday at 8 p.m. looks like.
Mhm.
Okay. And that's every other week.
Mm-hmm.
All right, based on what's been testified to, and that is the concern about disturbing the peace has been stated in terms of what Ms. Gutierrez is concerned about in the future. And Mr. Gutierrez has indicated he hasn't done that. But there's really not sufficient evidence for me to enter a temporary restraining order at this time. Should Ms. Gutierrez's peace actually be disturbed in the future, or she feel an actual threat about that, you can bring the motion again. Sounds like there's some protection with the criminal matter, no contact. But that, in terms of what I have before me today, I'm going to have to deny that motion. The motion for adequate cause, I'm going to defer at this time. I think I have heard enough that convinces me that I should appoint what's called a guardian ad litem to investigate the parental conditions.
Okay.
And so I'm going to do that before we leave here today. I'm going to leave the visitation plan where it's at for now, with the one proviso that Mr. Gutierrez cannot use alcohol or illegal drugs 8 hours before the visitation or during the visitation. All right. That seemed to be one of the concerns, and I think the court can put those restrictions in place. And then, depending on what the guardian ad litem determines, I may or may not agree to the motion for adequate cause. This visitation schedule was only entered 6 months ago, and typically we don't change them that quickly. But I do think what Ms. Gutierrez has brought to the court's attention today does warrant further investigation. So what happens is the clerk will give us 3 names of individuals who do the guardian ad litem work. So if we could have those at this time.
Next 2 names are Keith Lawrence, Amy Turnbull, and Vashti Langford.
All right, so there were Keith Lawrence, Amy Turnbull, and Vashti Langford. The reason we give 3 names is we give the parties an opportunity to strike one of them. I'm assuming neither of you know any of these folks. Is that
No.
okay? So I'm going to appoint. In that case, we appoint the first person on the list. So that will be Keith Lawrence. And Mr. Lawrence, if you're here, if you want to turn on your camera, then you can. So if you have your computer, Mr. Lawrence is now a parent, and he will be reaching out to both of you.
Okay.
Initially, the requirement is that you each pay 1/2 of his fees. If your financial condition is such that you receive public support, you can bring that to the attention of the court by filing a financial declaration, and we could come up with a different payment scheme. But the default is that both of you will pay half of what Mr. Lawrence charges. Okay. So I'm going to enter a bench order with the decision that I made today. It'll be denying the motion for temporary restraining order, requiring no use of alcohol or illegal drugs 8 hours before a visit and during, and a separate order will appoint Mr. Lawrence as the guardian ad litem in this matter. Okay, and you're both required to cooperate with him.
Okay.
All right. Any questions, Mr. Gutierrez?
No.
Okay, Ms. Gutierrez?
No,
Okay. All right. Thank you very much.
thank you.
So I understand that things have happened in the past, but disturbing your peace when he hasn't physically done anything and there's no evidence of doing anything is not enough to be bringing a case in court. There's enough cases that really need to be brought in court. Don't clog up the court with stuff. If you're going to do it, bring some evidence. Have something to show them. You can't just go to court for a TPO and say, well, I want this. You have to have some reason or show them something to give them a reason to do it. There's no he said, she said that a judge is going to believe you over him. In most cases, there's got to be some form of evidence. Watch some Judge Manning. You'll understand. All right, that's it for now. Everybody have a great weekend.